the defendants. It's listed on 4th, Your Lordship. If they mark it, the writ will become infructuous.
Give it. Yes. 230.
230. Much obliged, Your Lordship.
Am I not hearing here? Wait.
My lords, GMCPC. In OS, my application for amendment is allowed. However, impleting the same party, the defendant, is rejected. Matter is day after tomorrow for evidence. Evidence is starting, my lords. Hence,
Let it be done. Monday. Yes. Other lane ತೊಂದ್ರೆ ಆಗಲ್ಲ.
Lords, this is a matter where ex parte interim order was granted in my favor, my lords, but later on suspended on the basis of certain facts brought on record by a party who is not even party to the suit, by an impleading applicant.
Monday.
My lords, there is a threat to possession, my lords.
It's vacated another. Give it. Yes.
My lord,
Kindly maybe had it
Fresh matter,
tomorrow, my
right?
lord.
Fresh matter.
Fresh matter, my lords. Tomorrow.
my lord,
maybe
court,
had it.
my lord, court
Will you wait?
In execution proceedings, my lord, delivery warrant was issued. Pleading my lord's insolvency before the honorable court. A false submission is made in interim order to state. This is my 4th memo, my lord. Tomorrow, my client.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ. ನಾಳೆ ಅಲ್ಲ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಬರ. Give it, yes. ಏನು? ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟ್ರಾ? ಟ್ಯಾಕ್ಸ್ ಮಾಡಿ ಟ್ಯಾಕ್ಸ್ ದಿನ ಬರುತ್ತೆ ಕೊಡಿ.
Same party, same property. Matter must be taken up. The matter was for judgment. Then the particular order was set aside. Now the written statement was allowed to be taken on record.
At the stage of judgment.
Yes.
When is the next date?
Next is on Monday.
We'll take it on 4th. Yes, 3rd. Monday, sir. So what? Give it. Yes. Could you? $230. ಮಂಡೇ ಆಗ್ಬೋದಾ? ಕಾಂಪೌಂಡ್ ವಾಲ್ ಬಂದಾಗಿದೆಯಲ್ಲ, ಕಂಪ್ಲೀಷನ್ ಇದ್ರೇನು ಕಡಿಮೆ ಇದ್ರೇನು? ಮಂಡೇ ಎಸ್. ಯಾಕೆ ಮಧು? ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. ಅದು 4th. ಟೇಕ್ ಇಟ್. ಎಸ್. Wait. Yes. Give it, madam. Fresh matter. Please give all fresh matters.
my lord,
GMCPC. ಮಂಡೇ ಆಗ್ಬೋದಲ್ಲ ಕೊಡಿ. ಅಯ್ಯೋ, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕ್ಲೋಸ್ ಆಗೋಗಿದೆಯಾ? ಸ್ಕೂಲ್ನ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬರಲ್ಲ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ ಕೊಡಿ. ವೈ ರಿಜೆಕ್ಟೆಡ್ ನಾಟ್ ಗ್ರಾಂಟೆಡ್?
Not granted.
ಹಾಂ ಸರ್.
Not granted. 230.
Memo for being spoken to.
ವೈ?
There's some calculation error and the timeline is mentioned wrong in the judgment.
ಆಯ್ತು ಕೊಡಿ. Tomorrow.
my lord, in GMCPC, my lord, court commissioner application was filed and it is rejected. The suit for declaration, my lord. Kindly have it on. Stage is for evidence, my lord.
ಮಂಡೇ ಅವ್ರು ಬರುತ್ತೆ ಕೊಡಿ.
Date,
ಏನು
urgency
ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
is-
ಎಂತ ಅರ್ಜೆನ್ಸಿ? ಹಾಕಿರೋದೇ ಡ್ರ್ಯಾಗ್ ಮಾಡಕ್ಕೆ, ಬೇರೆ ಏನಿಲ್ಲ.
The BDM alerts they have issued, they're seeking for the development plan,
Give it,
alerts
give it.
they're seeking by.
Pending.
Taken up. Alerts.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ತಾನೆ?
No, my lords, fresh matter. Maybe taken up tomorrow, my lords.
No, sir, not at all. Give it, yes.
Monday, my lords, at least Monday.
It will come on fresh matter, yes.
Land acquisition.
Documents, this is GMCPC, my lord.
Give it, madam.
Commercial court has accepted additional documents surpassing commercial court's act. The documents have already been marked, it's posted for cross-examination on date. It may be
On?
2:30 on Monday, my lord.
8th, we'll take it tomorrow, give it.
This is a land acquisition matter, my lord.
Give it, sir.
Filed a application vacating of stay order. It's More than 1 year, it's still pending.
What to do? Sir? Before me 1 year? Give it. Don't project something that can't be digested. Yes. No, sir. Yes. It will come on vacating stay days. Give it, sir. Give it, sir. Are you fighting with him? Be quiet for some time. Yes. All last 3 years. 3 years in stay idea. Third. ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ. ಅದ್ರ ಮೇಲೆ ಬರೆದು ಕೊಡಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಂತ ಕರೆಕ್ಟ್ಲಿ ಕೊಡಿ. ಸೂಟ್ ಫಾರ್ ಲೆಟ್ ಇಟ್ ಬಿ. ಏನ್ ನಾಳೆ ಡಿಕ್ರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕೊಡಿ. ನೋ ಸರ್, ನೋ ಅರ್ಜೆನ್ಸಿ. ಮೇ ಬಿ ನೋ, ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ. I will also consider along with main. Give it. Yes. Nothing. Give it. No, sir. Rejected. File an appeal. File an appeal, sir. Yes. File an appeal for that also. No problem. Nayan Madaka. File an appeal. 2197 itself an order. Decree. Yes. Land acquisition. Kodi. ಮಂಗಳವಾರ ಆಗ್ಬೋದಲ್ಲ? Which subject, sir? ಕೊಡಿ ಸರ್. ಕೊಡ್ತೀರಾ ಬೇಡವಾ? ಎಸ್ ಬಿಡಿ. 100 ಮೆಮೋಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? 100 ಮೆಮೋಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ ಸುಮ್ಮನೆ. ನೋ ಸರ್, ಐ ವಿಲ್ ನಾಟ್. ನೋ ಡೇಟ್. ಐ ವಿಲ್ ನಾಟ್ ಗಿವ್ ಅ ಡೇಟ್. ಎಸ್. ವೆರಿ ಗುಡ್. Give it. Give. Why are you standing still? Give all the memos.
Land acquisition matter, my lord, covered by judgment.
Give all the
Very
memos.
simple notification has been caused.
ಡೆಲಿವರಿ ವಾರಂಟ್ ಇದ್ರೆ 230 ತಗೊಳ್ಳಿ. ಡೆಲಿವರಿ ವಾರಂಟ್ 1 ವರ್ಷದಿಂದ ಆಗಿದ್ದ? 1 ವರ್ಷದಿಂದ ಆಗಿರೋದ? I will adjourn it by 16 weeks if you move without there being any urgency. What urgency? ಡೆಲಿವರಿ ವಾರಂಟ್ 1 ವರ್ಷ ಆಗಿದೆ, ಸುಮ್ಮನೆ ಇದ್ದೀರಾ? ಸರಿ ಸರಿ. ಎಸ್.
Land acquisition matter.
ಇನ್ನೊಂದ್ ಸರ್ತಿ 10ನೇ ಸರಿ 20ನೇ ಸರಿ ಅಂದ್ರೆ ಆಗಲ್ಲ. ನನಗೆ ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ಮಾತ್ರ ತಗೊಳಕ್ ಸಾಧ್ಯ. ಹೇಳ್ತಾನೆ ಇದ್ದೀನಿ. I will stop taking matters beyond 100 in a day. ಯಾವೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ, ಕೊಡಿ ಇಲ್ಲಿ. ಸುಮ್ಮನೆ 10ನೇದು ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಅದ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಎಲ್ಲರೂ 10ನೇದು ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿ ನಾನು? Everybody are taking 10 memos. What should I do? ಆಯ್ತು, ಅದು ಹೇಳಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಅದು ತಗೊಳ್ಳಿ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿ. ಅದು ಬಿಟ್ಟು ಬೇಡದ್ದೆಲ್ಲ ಮಾತಾಡ್ಬಾರ್ದು. ಕೊಡಿ. 9th ಕೊಡಿ ಸರ್. ಯಾವತ್ತಿದೆ ಆಪ್ಷನ್? 230.
Land acquisition matter, the very same notification is caused.
No problem. 9th.
Based on a memo filed by the defendant, the next date is 6/9, Your Lordship. This
Come
court
on.
has-
Sorry?
Commercial court has stayed the proceedings based on a memo filed by defendants. This court has already rejected the interim relief of stay. Next date is 6/9, Your Lordship.
Wait, 4th.
The GMCPC matter.
4th.
GMCPC matter, my lord.
Fresh matter.
My lord's pending matter. Is I filed IF for vacating. The proceedings before the trial could have been stayed for the last 1 year, my lord.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನಾನು ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಂತೀನಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ. ಎಲ್ಲ ಹಂಗೆ ಅಂದ್ರೆ.
GM police matter.
Yes.
GM
police, why here?
We're disabled before the roster bench, my lord. The request, my lord, is that the petitioners have been prevented from putting up their business of telecom towers by just nearby residents. We don't know who they are, and the police is not neither registering the complaint, my lord. May I request for tomorrow, my lord?
Give it tomorrow. Suit for?
Partition.
ಏನು?
Application to withdraw the suit and formal defect which was rejected. Standing that he has filed a petition here. No stay was granted. For past 2 years, he is writing on the matter saying that petition is pending. And for the defendant.
ಕೊಡಿ. Vacating stay, give it. Yes. Give it. Give it. No, I am not going to fix. We'll tax matters on 4th. Give it. 230 ವೈ ಯಾವಾಗ ಫ್ರೀಸ್ ಆಗಿದ್ದು? ಮೊನ್ನೆ ಅಂದ್ರೆ ಯಾವಾಗ? 1 ವರ್ಷದಿಂದ? ಮೊನ್ನೆ ಅಂದ್ರೆ 1 ವರ್ಷದಿಂದನಾ? ಕೊಡಿ ಸರ್, ಸುಮ್ಮನೆ ಏನನ್ನ ಡೋಂಟ್ ಪ್ರೊಜೆಕ್ಟ್ urgency is not there. Yes, give it.
It's memo for 230.
Give it, sir.
It's memo for 230, my end of the list, my lord.
Why?
This is a suit for partition, my lord. I filed an application for 39 on rule 1 and 2, my lord. Interim order ಕೊಟ್ಟಿಲ್ಲ.
Partition ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಸರ್ ನಿಮ್ಗೆ?
ಇಲ್ಲ ಮೇಡಮ್, the respondent 2 items ನ already solved ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
Not to alienate.
Not to eliminate and clear.
230. Yes, sir.
Item number 27,
Review.
review. Your lordship has informed that my friend that he must argue. That's what you have said. That's what he also informed me I have come.
That's all right. You tell me how review would be maintainable.
I'll convince your lordship on that. I'll convince your lordship. My only request is.
What is error apparent there? Or what is error apparent there?
Definitely I'll convince your lordship. Your lordship may take up the bundle, definitely. Get the.
Not now. We'll take it up. What's serial number?
Serial number 27.
In that turn, I'll take it up.
Second list. Only request, my lord, is I have got some personal inconvenience in the evening. So lordship may take it up at 1 o'clock today.
All right.
So if, since your lordship said, let him address argument, I'll be here.
No problem. Yes, sir.
My lord, serial number 82. I'm seeking a adjournment.
Adjournment? No.
I need to file objections in that.
You very good, sir. File.
KIBD, my lordship.
No, sir.
I'm a panel
Yes.
advocate.
No adjournments in the morning. Yes.
List one order, still number 1.
Weeks time, my lord, because survey was ordered, my lord, it has to be produced.
Conducted?
Survey was conducted, but they were not intimated until survey ಹೇಳಿದ್ರು. I have intimated the same. They will give notice and conduct the measure, and they will carry on one more survey in the same, my lord. Survey was conducted. It was to be overlapped with the Google, but in meantime, they were not intimated, it seems, my lord. So,
The Learned Council for the Learned HCGP submit
9th or 16th. 9th or 16th.
10 days time to get a joint survey conducted and file a report of such survey before this court by the next date list on 16th.
Much obliged.
Number 2.
Non-serving of 15/4?
2025.
Huh.
Just open it in your phone.
Yes. Ravi Shankar sir.
Just
ಏನಿದು? There are so many rectification of your red.
those things needs to be carried out. What's the long and short of it is that this property is
Granted land?
it's a granted land. Revenue proceedings has already been concluded. After the revenue proceedings is concluded and has become final, KEDB wants to come and say that insofar as this property is concerned, we have paid the compensation to somebody else whose names they reflected. It came from this honorable court by the coordinate bench that we need to impede the other respondents, which is the second matter. So notice has gone to respondent numbers 5 and 6, Milords. The process is required to be taken.
All right.
But this is the long and short of it. Now the KEDB, Milords, who's merely the beneficiary, wants to come and say that the lands, there is a dispute regarding the grant. That's essentially, Milords, the.
Is our case. Lordship may kindly see the synopsis. There is first point is that, my lord, there is 12 years delay in.
ಆಯ್ತು, ಇದನ್ನ ನೋಟಿಸ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಾ? Impleading applicant.
There is already a notice ordered, Milords. The process needs to be taken.
Lord, it is not.
ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇದ್ರೆ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಈಗ ಹೇಳಕ್
ನಮ್ಮ ಫಸ್ಟ್ ಕೇಸ್ ನಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
ನಿಮ್ಮನ್ನ ಹಿಯರ್ ಮಾಡಿ ತಾನೇ ಮಾಡಿದ ಆರ್ಡರ್ ಇಲ್ವಾ?
ಅವತ್ತು ಇವ್ರು ಇರ್ಲಿಲ್ಲ ಹಿಂಗ.
They have not filed any objections for the impleading application.
Ashwini,
It is,
kindly
Milords,
see,
it's they who brought about this controversy before the
Kindly
court,
appreciate
saying
this.
that for this property, we have paid compensation to somebody else.
My lords, it is only delay, the ground of delay on which it has to go. Even otherwise, your lordship may kindly see.
It has to go ಅಂದ್ರೆ ನಿಮ್ against
Our writ petition has to go, my lord. 2008
2024,
compensation-
2021 writ petition.
Yes, yes. Plus, my lords, the name of the petitioner was ordered to be entered in the revenue records only in the year 2011, after the entire acquisition proceedings was
Oh,
over.
after everything was
Yes,
over.
yes, after everything was over,
I-
and the name was in fact entered in the year 2021 and 22.
ಆಯ್ತು ಅವ್ರು ಬರ್ಲಿ ಯಾರು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಅಲ್ಲ,
ಹಾಕಿದ್ದಾರೆ
ಅದು-
ಸ್ಟೇ ಇದೆ ಅಲ್ಲಿ.
Yes.
ಅಲ್ಲ, ಇದು ಏನಾಗಿದೆ
No,
ಅಂದ್ರೆ, my lord, land was,
I'm rather,
land has
I'm
been
rather
developed,
surprised, my lords, because
land
two
has been
proceedings
developed.
will be decided not on the basis of your acquisition proceedings. Whether there was a grant, my lords, ultimately
Like
136.
revenue proceedings hold that there was a grant,
Yes, there is a grant. The revenue proceedings holds under
that has
136.
become final.
That has become final.
2011 ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
No, after that, the entries are made in my name in the revenue records. Even that is not under challenge.
After
No, it's the-
producing that only, my lord, this honorable court directed, my lord, the special commissioner to produce the records, because the special deputy commissioner says that there is no grant records, but only one registry is there where the name is found.
ಅದು contemporaneous documents ಅಲ್ಲಿ ಇದ್ರು ಆಯ್ತಲ್ಲ.
My lord, that has been verified now by this honorable court.
Where is
And
the
this is
you bought it here?
15-4, my lord, this honorable.
It's already verified?
Yes, yes, verified by the honorable court, and
ಅದೇ ಸಾಗುವಳಿ ಚಿಟ್ಟಿದೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಅಲ್ಲ, ಯಾವುದೂ ಇಲ್ಲ.
ಹೆಸರಿನ ಇಶ್ಯೂ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಹೆಸರನ್ನ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ಆಲ್ಸೋ ನಂಬರ್ ಓವರ್ಲ್ಯಾಪಿಂಗ್ ದಟ್
And what is challenged in the writ petition is not land acquisition proceedings initiated for the benefit of the KIDB, and the petitioner says that I don't have any say in the matter.
No, no,
And my
When
lord-
did he say you don't have any
No,
say?
no, KIDB should not oppose is what the.
Lords,
No, no, revenue, he said, I'm surprised that revenue proceedings is not dependent on land acquisition proceedings.
It's not dependent on land acquisition.
ಅದನ್ನ ಹೇಳಿ
proceedings,
ನಿಮಗೆ
it's
ರೈಟ್ ಇಲ್ಲ ಅಂತ ಯಾರು ಹೇಳಿದ್ರು?
Lords, the revenue records have been.
Because as a matter of fact, this issue came up for consideration, my lords, while determining the compensation, because after the compensation was decided under section 50 of the 1894 Land Acquisition Act, my lords, I think 87 Supreme Court had decided beneficiary of the acquisition has no role to play in the manner in which the title to the
That's
property has
all
to be
right. Title
determined.
to the property now we'll see, because 15/4/2025 order says nothing
Lords,
is
the
there.
15/4/2025 order says that this Chagoli chit register extract is there. My name is reflected.
Have sought copies of Sagavali chit
They
issue
have not yet
register.
given it.
Where is it?
I don't know. They have to give it.
Original register of Sagodi chick.
Copies ಕೊಡ್ಬೇಕಲ್ಲ.
And this.
ಅಲ್ಲ, ಎಲ್ಲಿದೆ?
Copies is also given.
No,
ಅಲ್ಲ, where is the
ಯಾರಿಗೆ ಅವ್ರು
register?
ಕೊಟ್ಟು KDB ಅವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಕೊಡಲ್ಲ. ಹಾ.
Register ಎಲ್ಲಿದೆ ಕೊಡಿ.
Original register.
Lord, initially, my lord, register, my lord, was my lord called for. Thereafter, my lord, there was no name. Thereafter, again, my lord, Sagoli, my lord, chit register was called for. There also, my lord, the court. felt
Yes,
that-
Ravi Shankar sir.
Lordships.
On same
Alla,
day, my lord, there are
Yeah,
two grant
Lords,
orders in
It is
respect of, my
pointed
lord,
out,
two adjoining
it is
villages.
pointed out from the Sagoli chit register, entries has been made showing the name of.
One
so and
grant
so and
made
so
in
and so.
favor of Kamalamma.
Komalama and Krishnappa,
Ah.
in respect of two properties.
Nevertheless, pointed out all the entries are illegal and without there being any original grant order.
Lords, that's the reason, my lords.
Registry ಕೊಡಿ. Register ಕೊಡಿ.
Original registration.
Even I have.
ಎಷ್ಟಿದೆ?
ತುಂಬಾ ಇತ್ತು, ತುಂಬಾ ಇತ್ತು sir.
11 page ಆರು ಕೊಡಿ sir.
I have.
You flag it and get it.
I have given Xerox copy for all this, but in our file it is missing, might be.
ಇದರಲ್ಲಿ ಇಲ್ಲ. ನೋಡು. ಅದರಲ್ಲಿ.
We'll take it tomorrow then, day after tomorrow.
Please.
Yes. ಕೊಡಿ ಅದು.
Lords, the direction is to give the copies of the Sagoli chit register. Even now, they have not given the copies.
ಅಲ್ಲ,
The
ಇಲ್ಲೇ
process
ನಮ್ಗೆ-
got to see.
ನಮಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
Allah, sought for copies of the Sagoli chit register extract.
Let him get it, we'll see.
He has to give the copies to us to make anything comment on that.
We'll see. ಇನ್ನೇನ್
Now, there
6 and 8 ಅಲ್ಲಿ ಆಗಿರೋ acquisition process.
Lords, I just wanted to say this, my lords,
Name, my lord.
that
Photograph
these
is-
are all quasi
Photo
judicial.
is there, my lord. Original grant certificate is there.
Is
Register
there?
as photo. Madam.
ಕೊಡಿ.
For them also, I have.
Original grant
No, no,
certificate
no,
is
no
there.
copies are given.
Both of them given access for the book, and I have just turned the pages. They have also given a copies also, but in our
signed
file
on
it
It's
is.
a, my lords,
It
I
is
can,
also
I
signed
can,
through the-
I can
the
say that
acknowledgement is
it's
also
not a
signed.
fair statement being made. I'll stop it at that. If you want more, I can give it at that. But I'll stop by saying it's not a fair submission.
Thursday.
They have not given the copies yet.
We'll take it on Thursday.
In fact, the honorable court has also, my lord, perused the, my lord, original records.
Thursday we'll take it. I'll get it. Yes, next.
Lords, interim order has to be extended.
Three.
Rectification of office subject, memo for withdrawal.
I am permitted to
I
withdraw.
withdraw, yes.
Permitted to withdraw, my lord. It already filed a
Withdraws.
memo. Please,
Yes.
my lord. Much
Furnishing of a week's time is granted to do the needful. Interim order idea nodi continue ಮಾಡಿ.
5.
Non-compliance of vacating interim order.
Respondent number 7 and 8.
There is vacating interim order.
This will take a while, my lords, if you can.
Take a while.
Lordships, this will take a while for arguments, my lords, if your lordships can take
Does
it
it
up and
take
after
a
2:30, I'll.
If you listen to me, my lord, it doesn't take a while. My lord, the very writ petition is not maintainable on the ground that he has no locus standi to question. My lord,
Who is the petitioner? Locus yakilla?
He is a petitioner because he has failed to prove his ownership or possession over the social property.
Interim order was
The matter
granted after
went up to
hearing both
Supreme Court.
parties. I
Not
wanted to
once,
say this.
Four times
Well,
it
yes.
has gone up to Supreme Court and he has failed to prove his right and title.
3:30.
Demonstrate.
ಮೂರುವರೆ.
I,
Pass over. Take it at 3:30. Yes. Next.
6.
In 6.1, I appear for the petitioner's counsel.
6.1 na.
6.1, connected matter. Our matter has been pending for a while. In our matter, there's an order of February 25 by coordinate bench.
One moment. Sir.
Serial number 6, copies have not been.
Which is that matter?
No, this is 6.1 is.
ಅಲ್ಲಲ್ಲ. First
Double
ಹಾಕಿರೋದು
two,
ಯಾವ್ದು?
first matter
I
is my
appear in
learned
6.
friends.
ಅದು ಕೊಡಿ.
My lord, my name may be shown in 6.
ಒಂದ್ ನಿಮಿಷ.
BBMP responded it instead of.
Land acquisition. What's this?
No,
BDA.
no, this is redevelopment of the old complexes,
Redevelopment of
the BDA complexes, Kormangla BDA complex and Indiranagar BDA complex. About 6 complexes, BDA had said that they want to redevelop. This happened in 2018. Following public protest, it had died down. Then suddenly they had reactivated it, and our challenge was the process that you have to follow under the KTCP Act has not been followed. In my matter, my lords, which was heard in some detail in February, before the coordinate bench, they said they will place the records to show that they have followed the process. That order, my lords,
ಓ ಯಾರು BDA ಹೇಳಿದ್ದ?
PDA ಹೇಳಿದ್ದು. ಆಮೇಲೆ ಏನು ಫೈಲ್ ಮಾಡಲಿಲ್ಲ. Date was given in 25 February. Only they said you please furnish. They did not. After that, it's not happened. Now my learned friend has filed in respect of Indiranagar complex. Ours was
ಯಾರು
in respect-
ಇಂದಿರಾನಗರ?
In Indranagar complex, the demolition has already started. We are filing photographs to show that.
I'm appearing for 3, 6 and 7 in that, my lords. I'll need some time. I've just been served 3 days ago. So 2018 concession agreement.
18 ಇಂದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗ್ತಾ ಇದೆಯಾ?
ಇಲ್ಲ, concession agreement where I was awarded is 2018. As per their own petition, 2024 is when it was.
Which petition are you appearing in?
Serial number 64504.
4504.
I'm for
This
respondent
is
3,
22886 is a 4504 R4 ಯಾರು?
R4 is,
4504 ನಿಮ್ದ?
Swami,
My lords, I don't have instructions for 4. I can check. I'm here for 3, 6 and 7.
in fact, 3 and 4, the address is the same.
1 minute. 3 and 4.
3 serve ಆಗಿದೆ, 4 ಆಗಿದೆ.
MFAR developer, who is that?
I'll take instruction, my lords.
MFA developers, he is one among the person who has.
No,
got
I am
the
holding,
contract.
1 minute, 4504.
Please.
4504.
You are, madam, ಇಬ್ರು ಅವರೇ ಮತ್ತೆ ಸುಮ್ಮನೆ ಪ್ರೊಸೆಸ್ಗೆ ಬರುತ್ತೆ ಮತ್ತೆ ಅದು.
May I take instructions because I don't know if the name has changed, company is still in existence, etc.
R3 is a special
So I'll take
purpose
instructions
vehicle.
if I can undertake, I will.
R3 is the SPV for R4.
All right.
My lord,
R3 is an SPV, true, my lords.
Then
6 and 7.
created by.
4 you're already appearing.
4, no, my lords. 3, 6 and 7.
Learned council so and so. ಅದು ಆಗಿರ್ಬೇಕಲ್ಲ 4 ಮಾತ್ರ ಇರೋದು ಮೇಡಮ್.
4 ಮಾತ್ರ ಇರೋದು. I'll take instructions, my lords, because I
ಮತ್ತೆ it will come in this only, you take it. Yes.
My lords,
The learned council 3 Vegadarshi.
Please, my colleague. My lords,
Learned council so and so undertakes to enter appearance for 4th respondent. In the event you are not, you tell me later. Therefore, the service of notice stands complete in serial number 6. 6.1 yaru, R6 yaru.
Copies have not been.
R6, it has come as nobody at that address. That is the address provided in the agreement.
My lord.
R6 is an entity called ADD Realty.
ADD reality. The
No, they are-
learned senior counsel to the petitioner submits that the postal shara is returned as no addressee found. In that light, registry to print the name of the sixth respondent and show the entity as served. List the matter on copy kotilva.
4504 of 25.
I'll search.
Copy has not been served on.
Learned counsel for the petitioner to serve set of papers upon the counsel for the respondents with respondents if not already served as on date. List the matter on 9th and preliminary hearing.
My lords, my name may be shown in.
Yarge, sir.
For respondent number 8, instead of Karthikeyan, I have entered appearance.
Learned counsel Patil.
KB Manish.
KB Manish Kumar submits that in place of KBS Karthikeyan, he has entered appearance. Therefore, registry to print the name of so and so is appearing for respondent number 8. List on 9th.
BDA may be directed to file whatever documents they want.
The counsel for the BDA shall place on record the original, before the court the original records
In respect of
In-
Kormangala.
in respect of
6.1.
in WP 22886 of 2024.
Please.
Yes.
My lords, if they could also do the same exercise in.
ಅದರಲ್ಲೂ ಕೊಡಿ ಎರಡು
You can have anything.
ಕಾಪಿ ಕೊಡಿ.
ನಾನು ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ.
Yes.
ಕೊಟ್ರೆ ನಾನು ತಗೊಂಡ್ಬರ್ತೀನಿ.
It's similar in nature.
ನೀವು
as
ಕಾಪಿ
well.
ಕೊಡಿ ಇವತ್ತು.
ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ.
Murugesh will get it. Yes. Non-compliance.
Relevant portion of the copy of the notification has been filed. And in respect to including application.
Accepting the submission of the counsel for the petitioner, office objections overruled. 7.1 ಏನು?
ಎಲ್ಲ same matter, my lord.
Including application.
Impleading ಯಾರು?
Niece
My
or
lords, niece and my
I'll
lords.
I'll file
Nandi
objection.
Conway Corridor Enterprise, it's
Oh,
section A
Nitin
of the.
Prasad.
Yes, ma'am.
Nice.
Impleading
was already
application we will
filed.
allow.
Yes, ma'am, they're beneficial.
My lord, first
IA1.
matter, I am not having entire set of papers.
ಅದೇ ಹೇಳಿ. So and so for, madam. For the reasons indicated in the affidavit accompanying the application being satisfied with the same, applications allowed petitioner to amend the cause title accordingly. List all these matters on 16th.
My lord, serial number 7. papers
Petitioner
were
to
not
serve
served.
set of papers upon the counsel for the respondent if not already served as on today.
Public.
Indian Beck.
Papers.
All, ella same. Up to 7.3, ella impleading application allowed. ಆಮೇಲೆ IA 1 of 25 dispensation also allowed for the reasons, yes.
Entry model may kindly.
Entry model ಇದ್ರೆ continue ಆಗುತ್ತೆ, yes.
It have complied, my lord. Needful has been done. Kasabda copy.
ಏನಿದು?
Correspondent number 3, my lord.
Illi matter. Copy has been served. This is,
Then
I challenge the second land acquisition notification, my lord. What happens in this one?
First one ಏನಾಯ್ತು?
First one only, my land is included. Thereafter, they take consent of everyone, they take over the possession, works has been done.
We'll take it on 9th.
Certainly.
I'll file my objection.
Objection ಅಂದ್ರೆ 16th. yes.
16th.
List on 16th.
Preliminary
Objections if any, but entry ಮಾಡಿದ್ಯಾ?
Preliminary hearing.
Preliminary hearing.
Please.
Yes, next.
Obligation, my lords.
To appear for office bearers of the association.
Yes, sir.
4 to 8.
You are permitting some construction in the
No, my lord.
pathway.
No, my lord.
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳಿರೋದು.
ಅಲ್ಲ ಅದ್ರ ರಿಪೋರ್ಟ್ ಹಾಕ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿತ್ತು.
They have inspected the premises, so they have prayed for 2 days time, Lord, they'll file a report.
File a
Hey.
report. List on learned counsel M. Ajay Kumar submits.
Respondent number 3 has did the inspection of the spot and they had given a report. Panchayat lordship.
ಆಯ್ತು ಕೊಡಿ. ಮೆಮೋ ಅಲ್ಲಿ ಹಾಕಿ ಹಂಗ ಹಾಕೋದು.
No, just for the, I'll place in the record also. Lord.
Yes, you place it on record by way of a memo. The learned counsel M. Ajay Kumar submits that the BDA has inspected the property and have drawn a report, the report of which would be placed before this court on the next date. List on 9th and preliminary hearing. Report.
One more submission, Lord. In list number 2, serial number 7, my lord.
Same.
Same connected.
Tag this petition along with list number 2, serial number 7. List them both on 9th. Intermodal subsisting would continue to the next date of hearing.
Lordship also, may I be permitted to, your lordship, after the grant of an interim order, concrete has been put up in the said premises. I'll place it in the order.
Yes. ಎಲ್ಲ ಮೆಮೋ ಅಲ್ಲಿ ಹಾಕಿ ಫೈಲಿಗೆ ಬರಲಿ ಅದು.
Process for the PDO has to be taken. Process for the PDO, respondent number 3 has to be taken.
ಸ್ಟೆಪ್ಸ್ ರಿಪೋರ್ಟ್ ತಗೊಂಡ್ಬಂದಿದ್ದೀರಾ PDO ಹತ್ರ ಪ್ರೋಸೆಸ್
We have served
ಕೊಡಕ್ಕಾಗಲ್ಲ.
the copy time, they had even, they have visited this place.
The learned
I'll
counsel.
serve the copy also.
Learned counsel for the petitioner submits needful has been done, office to verify.
Writ petition copies may be served. Writ petition
Copy
copy.
ಕೊಡಿ ಅವ್ರಿಗೆಲ್ಲ.
Yes,
Association ಕೊಡಿ copy.
Please.
Lord, we have served the copy, we'll serve the one more.
If not already served, yes.
These two processes have been paid. Lease to
Video.
serial number 7.
Take the copy.
ಅದ್ರಲ್ಲೂ needful has been done ಅಂತ office to verify ಅಂತ ಮಾಡಿ ಆಮೇಲೆ
copy.
tag ಮಾಡಿ.
For
Next.
respondent number 3, we have served the copy now.
Copy.
I will serve the copy.
If not already served ಅಂತ ಹೇಳಿದೀನಿ, yes.
My lord, in lease to serial number 7, I'm serving the
ಏ
copy.
ಫೋಟೋ ತೆಗಿಬೇಕಾ ಈಗ?
My lord, it may be noted, my
If
lord.
not already served ಅಂತ ಹೇಳಾಯ್ತಲ್ಲ, yes.
Preliminary hearings, number 10.
Lords, the lordships are directed a survey to be conducted, survey report is filed. Lords, I have gone through the survey report. I think it requires an objection to be filed, my lords, to the survey
To the
report.
survey report.
To the survey report, because one grievance,
Hmm.
survey report is given last occasion, my lords. After,
last
because
time
the
there
instructions, my lords, says
2014 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಜಾಯಿಂಟ್ ಸರ್ವೆ ಆಗಿದೆಯಾ?
joint survey, my lords, what they did on 25th, they have come. This is my instructions. They have taken the signature on the major, but the survey is what they conducted on the next day when I was not present is what
My lord,
I am under instruction.
Affidavit ಹಾಕಿ.
My lord,
I'll file an affidavit to that
my lord, the
effect.
surveyor is also present. They have, they informed them, the first time, my lord, they have appeared.
They did not come.
First time they appeared, ಆ time ಅಲ್ಲಿ it was to be this conducted by the CTS survey. Ordinary survey ಆಗುದಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು date. Next date ಅಲ್ಲಿ they have informed the firm and they have also come the spot, but they refused to sign the major. Therefore, the surveyor is present, my lord, before the court.
Or affidavit ಹಾಕಿ, ನಾನು affidavit ಹಾಕ್ತೀನಿ.
Affidavit ಹಾಕ್ಸಿ.
Yeah.
ಅವ್ರದ್ದು affidavit
That is,
ಹಾಕಿ.
if that is to be done, my lords, your lordships may fix a date and time. I'll go and be present before the, before the.
ಎಷ್ಟ್ ಸರ್ತಿ ಮಾಡ್ಸದ್ ಸರ್?
Lords, this is the reason, my lords, they did not conduct the survey on the date stipulated by your lordships. They fixed
No, I
some
did
other
not
date.
stipulate any date here.
Yes, my lords.
ಇಲ್ಲ ಫಸ್ಟ್ ಗೆ ತಾವು 25th ಗೆ
Oh, 1725/6 ಗೆ ಹೇಳಿದೆ.
ಹೌದು,
It was
ಅವತ್ತು
not-
ಹೋದ್ರೆ ಅಲ್ಲಿ ಅದು CTS ಸರ್ವೆ ಇಲ್ಲದೆ ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದ್ ದಿವಸ ಅಂತ ಇವರಿಗೆ ಹೇಳಿ ಇನ್ನೊಂದ್ ದಿವಸಕ್ಕೆ ಅವತ್ತು
ಯಾವತ್
ಬಂದಿಲ್ಲ.
ಮಾಡಿದ್ರಿ?
Next, my lord, it was conducted on, my lord, the
Why do you give scope to such things?
ಇಲ್ಲ ಅವರಿಗೆ
ಅವತ್ ಮಾಡಿರುತ್ತೆ, ಅವತ್ ಮಾಡಿದ್ರೆ ಆಗತ್ತೆ.
ಅಲ್ಲ ಅವತ್ತು ಆರ್ಡಿನರಿ ಸರ್ವೆ ಇಲ್ಲ, ಅದು ಫುಲ್ಲಿ ಡೆವಲಪ್ ಆದ್ದರಿಂದ CTS ಸರ್ವೆ ಇಲ್ಲ, ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ ಅಂತೇಳಿ ಅವರಿಗೆ ತಿಳಿಸಿದ್ದೆ. ಆನಂತರ
No separate notice need be issued ಅಂತ already ಬರ್ದಿದೆ.
ಇಲ್ಲ
He could not have, this ground would not be available at all.
ಇಲ್ಲ 25th ಗೆ ಅವರು ಎಪೇರ್ ಆಗದೆ ನಾನು ಡಿನೈ ಮಾಡಲ್ಲ. ಬಟ್ ಅವತ್ತು ಈ ಆರ್ಡಿನರಿ ಸರ್ವೆ ಇಲ್ಲ, ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ CTS ಸರ್ವೆ ಬೇಕಾಗಂತ ಹೇಳಿ ಇನ್ನೊಂದ್ ದಿವಸ ಹೇಳಿದ್ರು. ಅವತ್ತು ಫೋನ್
ಆಯ್ತು,
ಮಾಡಿ
you file your affidavits.
Please.
ಇದ್ರಲ್ಲೇ ಕೂತಿರುತ್ತೆ. 10 ವರ್ಷದಿಂದ ಹಂಗೆ ಇದೆ, ಇವತ್ತು ಹಂಗೆ ಇದೆ.
otherwise, my lord, if
It's the matter on preliminary in preliminary hearing on 9th.
my lord, one submission. Instead of all this dispute, my lord, let the ADL ಮೇಲೆ directed to conduct a survey on the specific date. Instead of BDA ಇದು dispute ಬೇಡ, ADL ಹತ್ರ ಒಂದ್ ದಿವಸ ಮಾಡಿಸಿ.
This court on so and so date haki had passed the following orders previous 2 dates. The learned senior counsel appearing for the petitioner submits that the survey is conducted on a different date that was assigned, different date then that was assigned by this court in terms of its order dated 25/6/2025, which was a direction to conduct a survey on 1/7/2025.
Lords, survey was directed to be conducted on 25/6/25.
No, sir.
Survey shall be conducted on
25/6/2025, a report of which was directed to be placed before the court
On one
on 1/7/2025. The learned counsel for the BDA pleaded his inability to conduct a survey for technical reasons. Therefore, the survey is conducted at a later point in time, which has now become a dispute as to in whose presence it was conducted. In that light, I deem it appropriate to direct the state party there,
State party ಇಲ್ಲ, but
direct the assistant director of land records of the jurisdiction to conduct a survey on, conduct a joint survey on
In respect of
10th September in respect of the subject property,
properties, please.
on respect of the subject property.
Properties, my lords.
ಅಲ್ಲಿ ಎರಡು ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆ, ಎರಡು
Property, in respect of the subject properties, and file a report of such survey before this court on the 20th. List the matter on 20th. It is needless to observe that the petitioner, no separate notice need be issued to the petitioner for his presence, and cannot plead that he was not notified or not present at the time of survey. List the matter on 20th.
Please.
The surveyor of the BDA
Along with,
All-
Allah, the assistant director of land records, along with the surveyor of the BDA. Next. R3? ಇದಲ್ಲ ಸ್ಟೇಟ್ ಇದ್ದೀರಾ? ಇಲ್ಲ ಅಂದ್ರೆ?
State is there.
Yes.
but,
Yes, next.
11.
Sorry, my subsequent implead
Yes, yes.
Please, ma'am.
Yes, sir.
Land has been acquired for the purpose of formation of the residential layout at Mysore, my lord.
Hmm.
While acquiring the property, my lord, I filed application for reconvey of the land. Initially, 8 acre 11 guntas of land has been acquired. While acquiring the property, my lord, I filed application for reconvey of the land of measuring 5 acre 20 guntas.
Hmm.
Kindly turn page number 27 for a moment, my lord, annexure B.
Hmm.
The then CITB
Hmm.
has admitted and approved that, my lord, 2 acre 2.5 guntas of land will be reconveyed. Kindly turn page number 27 for a moment, my lord.
Hmm. Regrant of?
ಪುನಃ ಕೊಡ್ತೇವೆ ಅಂತ ಒಪ್ಕೊಂಡ್ರು.
Regrant ಎಷ್ಟ್ರದ್ದು?
2.25 ಎಕರೆ.
2.25 acres.
2.2 ಎಕರೆ 22
Reconvey ಮಾಡ್ತೀನಿ ಅಂತ ಒಪ್ಕೊಂಡಿದಾರ?
ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
Annexure B, my lord.
Page.
Page 27. Annexure B, my lord, with reference to your letter dated 27/65, I write to state the board in its meeting held on 28/7/65 has resolved that is not possible to reconvey 5 acre 20 guntas of land as requested by him, and allowing to reconvey of 2 acre 22.5 guntas only on the conditions stipulated in resolution dated 36/65 as already intimated. Formation of road in the so and so has been taken up as per your letters cited above. I may add that if you fail to accept the offer of board resolution dated 36/65 in a week from the date of revise of this letter, further action will be taken in the matter. Thereafter, my lord, I have given the representation before the concerned authority. Several representations have been given, but now, my lord, the respondents have passed the endorsement that, my lord. Kindly turn page number 60 for a moment, my lord. Real.
Yes, sir.
ಒಂದು ಎಂಡೋಸ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ, ನಾವಿನ್ನು ರೀಕನ್ವೆ ಮಾಡಕ್ ಆಗುದಿಲ್ಲ ಅಂತ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ಮೈಸೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಮೈಸೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊನ್ಸೋ 8 ಎಕರೆ 11 ಪೈಕಿ 2 ಎಕರೆ 22 ಎಕರೆ ಜಮೀನನ್ನು ಹಿಂದಿನ ನಗರಾಭಿವೃದ್ಧಿ ವಿಶ್ವಸ್ತ ಮಂಡಳಿ ಕೈಗೊಂಡ ನಿರ್ಣಯದಂತೆ ಭೂಮಾಲೀಕರಿಗೆ ಬಿಟ್ಟು ಕೊಡಬೇಕೆಂಬ ಉಲ್ಲೇಖಿತ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಪ್ರಸ್ತಾವಿತ ಸರ್ವೆ ನಂಬರ್ ಸೊನ್ಸೋ ಪೂರ್ಣ 8-11 ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯಡಿ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡ ದಿನಾಂಕ 28/65ರಂದೇ ಸದರಿ ಜಮೀನಿನ ಸ್ವಾಧೀನವನ್ನು ಪಡೆದು ಸೊನ್ಸೋ ಮೊತ್ತವನ್ನು 23/7/85ರಂದು ಪ್ರಧಾನ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಠೇವಣಿ ಇಡಲಾಯಿತು. ಆದ್ದರಿಂದ 64-65ನೇ ಸಾಲಿನಲ್ಲಿ ಭೂಸ್ವಾಧೀನವಾಗಿರುವ ಈ ಜಮೀನಿನ ಪೈಕಿ 2 ಎಕರೆ 22.25 ಎಕರೆ ಜಮೀನನ್ನು ಈಗ ಕೈ ಬಿಡಲು ಕಾಯ್ದೆಯಡಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿದೆ. This is the endorsement issued by the respondent authority, my lord. In fact, my lord, my lord, in the year 1965 itself, they themselves admitted that, my lord, will reconvey of the land of measuring so and so. 2 ಎಕರೆ 22 ಗುಂಟೆ. Even resolution has been passed. Several representations have been provided, submitted, my lord.
ಎಲ್ಲಿ ಇದು? ಮೈಸೂರು.
But now
ಮೈಸೂರಲ್ಲಿ ಎಲ್ಲಿ?
ಮೈಸೂರಲ್ಲಿ
ಕಸಬಾ ಹೋಬಳಿ. Yes, Vivekan.
That's so far as the allotment of alternate land or reconveyance, there is no provision either under the CITB Act or under the Urban Development Authorities Act. Way back in the year 1987-85, the compensation has been deposited before the civil court and it was intimated to the petitioner. The
acquisition ಯಾವಾಗ ಆಗಿದ್ದು?
This is of 1964.
Correct.
In 1990 itself, as per annexure R2, page 11, my lord, we have informed the petitioner that the resolution of 1965 cannot be implemented. There is no provision for reconveyance of the land. But even in the year 1996 also, my lord, similar endorsement was issued. My lord, all those endorsements were never called in question and they did not approach the court, my lord, during the relevant point of time. In 2008, my lord, they have issued a legal notice stating that they are going to file a suit, and it is a the notice can be treated as a section 64 notice, and if the claim of the petitioner is not considered, they would
Suit
file a suit.
ಹಾಕಿದ್ದೀರಾ?
They would file a suit. They did not take any such steps. But in 2008 itself, in response to the legal notice, we have intimated as per Annexure R5 that the compensation is deposited, reconveyance is not possible. But all these endorsements were never called in question. But now in the year 2019,
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ ಎಲ್ಲ?
let's
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ?
Page number
please,
60, my lord.
the Annexure
ಅಲ್ಲ, ಇವ್ರು
R2,
ಯಾವ್ದು ಮೂರ್ನಾಲ್ಕು ಹೇಳಿದ್ರಲ್ಲ?
Annexure R2, page 11 of my statement of objections,
That is 1990.
1990. Now, next is Annexure R3, 1996. But, the Annexure R4 is the legal notice, which was replied to through Annexure R5, page 17, 18/10/2008. Let's even in 2016, they filed their representation that was responded to as per Annexure R7, page 21.
These are not called in question.
No, let's,
No.
now,
At page number 60, my lord, annexure.
ಅದೇ 16th ಮಾತ್ರ. ಅದು ಮುಂಚೆಂದ ಯಾವ್ದು ಮಾಡ್ಲಿಲ್ಲಲ್ಲ?
ಅಲ್ಲ, last ನ question ಮಾಡಿದ್ವಿ.
ಲಾಸ್ಟ್ ಮಾಡಿದ್ರೆ ಹಿಂದಿಂದೆಲ್ಲ ಆಗೋಯ್ತು ಅಂತ.
ಹಂಗಲ್ಲ.
ವೆರಿ ಗುಡ್.
let's, there are two judgments minutes on the ground that one is delay and another is it is a stale claim. Therefore, that this
The
juncture nor it.
Petitioner is before this court calling in, seeking a declaration that the acquisition proceedings in respect of property in survey number 209 and survey number 210 of Manandwadi Road, Mysore, Kasaba, Hubli, in terms of a notification issued then for purpose of acquisition to be lapsed, and a consequential direction by issuance of a writ in the nature of mandamus is sought to reconvey 2 acres and 25 guntas of land in the said survey numbers to the petitioners. Heard so and so. Facts in brief, Germain, are as follows. A notification comes to be issued by the then City Improvement Trust Board, CITB, which for seeking acquisition of certain lands, including the property of the petitioner, on 17/1, including the property of the petitioner, which was then in the hands of the father. On 17/1/19, the notification comes about on 17/1/1962, and the final notification.
1964.
And a final notification thereon. It is the case of the petitioner themselves that on 12/5/1964, the first respondent, 1964, the then City Improvement Trust Board has passed an award towards compensation to be paid pursuant to the said acquisition. Then comes a particular resolution of the board on 4/8/1965 that the land, the entire land of 8 acres and 25 guntas, which was sought for reconveyance by the father of the petitioner, cannot be reconveyed, but to an extent of 2 acres and 25 guntas can be reconveyed. The said representation is the dawn of hope of the father of the petitioner that the lands would come back to reconveyed to him and would come back to him. The hope remained a hope, and representation was for the first time rendered on 23/3/1981, again on 9/9/1983, and on a few dates later. An endorsement comes to be issued rejecting the claim of the petitioner to the last of the representations or the legal notice so caused on 2/11/2016. It is then the children of the Ibrana Obra, the son of one MP Seth is before this court calling in question the said endorsement and seeking reconveyance of the land. The learned counsel appearing for the petitioner would submit that the entire case of the petitioner is based upon a communication dated 4/8/1965, through which the through which the City Improvement Trust Board had opined that about 2.25 acres could be reconveyed back to the hands of the petitioner. The reconveyance did not happen. Therefore, he went on giving representations, and the representations were not acceded to, and the petitioner now challenging the endorsement seeks a reconveyance thereon. The learned counsel appearing for the respondent, Muda T.P. Vivekanand, would take this court through the statement of objection so filed in contending that the City Improvement Trust Board then did not have the power to pass any resolution with regard to reconveyance, let alone the board. Even the MUDA does not have power under the Urban Development Authorities Act to reconvey a land that is already subject matter of acquisition, to which compensation was already deposited before the concerned court. In that light, he would seek dismissal of the petition on the score that the claim is stale and the petition is barred by delay and laches. The learned AGA would also toe the lines of the learned counsel T.P. Vivekanand in so saying. The afore narrated facts are not in, I have given my source. The afore narrated facts are not in dispute. The father of the petitioner was in possession of a land in the afore quoted survey numbers. The land becomes subject matter of acquisition by issuance of preliminary notification on 17th January 1962, which was followed by a final notification. These are admitted facts. After the issuance of the final notification, compensation is determined and the award is passed on 12/5/1964. This is the averment of the petitioner himself. After passing of the award springs a resolution from the hands of the board. The resolution reads as for the resolution is communicated to the petitioner, the father of the petitioner. The communication reads as follows, page 27. The sheet anchor of the petitioner is the said communication pursuant to a resolution, which today is 60 years old. The petitioner, then the father of the petitioner appears to have kept quiet later on, and for the first time submits a representation in the year 1981, 1983, and again in the year 1990. These have been adequately answered by the Mysore Urban Development Authority, which succeeded to the City Improvement Trust Board by the following endorsement. R2, page 11, R3, page 12. These endorsements have not been challenged. In the year 2008, a legal notice is caused by the petitioners upon the officers of the MUDA seeking reconveyance of the land, again referring to the very resolution or the communication of the year 1965. This is again replied to by MUDA on 18/8/2008. They said communication is not challenged. 8 years thereafter springs another representation on 17/6/2016 seeking reconveyance of the land. Here again, the foundation of the representation is resolution or communication dated 20th August 1965. This is replied to by the impugned. Isn't challenge madidara?
This is now
R7 challenge madilva?
R7 is now challenged.
This is replied to by the impugned endorsement. It is for the first time the endorsement dated 2/11/2016 is challenged by the petitioner, notwithstanding the fact that the resolution upon which he bases his claim is 4/8/1965. If the father of the petitioner, who was well aware of the resolution, had knocked at the doors of the appropriate fora or this court, it would have been altogether a different circumstance. It is trite law that mere submission of representation will not arrest the rights of the petitioner. It would defeat the rights, as delay defeats equity. Any equity that stood in favor of the petitioner or his father has stood deleted out of sheer indolence on the part of the petitioner or the petitioner or his father, as the case would be, as there are plethora of endorsements that are rendered that reconveyance is an impermissible act as it is contrary to law. Today, after about 60 years of passage of the communication upon which the petitioner places his entire strength on, cannot be given life by a stroke of pen without considering the fact whether it was legal, illegal, or otherwise. The legality or illegality of the endorsement need not be gone into on the ground of sheer delay on the part of the petitioner or his father during his lifetime. The petition lacking in merit thus stands rejected.
I just wanted to know the final notification date, my lord, 12/5/64.
12/5.
1964. Please. Public.
Yes.
Short for a
ಇದು ಬರ್ಲಿ
declaration.
26th
26.
ಅವತ್ತು ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ ಹೇಳಿದ್ನಲ್ಲ ಇದು.
ಇದನ್ನ ಕೇಳಿದ್ದೀರಾ ತಾವು, ಅದು ಇಟ್ಸ್ ಗೋಯಿಂಗ್ ಫಾರ್ ದ ಸೇಮ್ ರೀಸನ್ ಫಾರ್ so long. Kindly, any short.
Before their grant, my lord.
No,
No, no, I can show it, my lords. I think this is an.
This I have heard.
Award itself has not been passed till date. Kindly.
26th. ಅಲ್ಲ 23rd. 28th Sunday.
Kindly.
ಯಾವ್ದು ಮೇಡಮ್? Yes, next.
Auction site. Auction site, my lord, the property which was auctioned. They say, my lord, after receiving the amount, executing the sale date, the area is shorter. There's a shortfall in the area.
Yes.
My lord, at auction, my lord, 258 square meters. But my lord,
Last time ಹೇಳಿದಲ್ಲ ಮಿಕ್ಕಿದ್ದು ಎಲ್ಲಿದೆ?
159, my lord, if we 159 ಅವ್ರಿಗೆ ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ, we will refund the amount.
I'm not saying that, my lord. Last time I had produced 4 sale dates, my lord, where they say, in similar situation, they are given alternative set for the remaining portion.
Alternate site ಕೇಳ್ತೀರಿ.
Alternate, my lord, my instruction, my lord, for the auction site.
Similar situations ಅಲ್ಲಿ ಹೆಂಗ್ ಕೊಟ್ರಿ ಮತ್ತೆ?
There, my lord, the situation, my lord, there, the site was not, but without site, my lord, it was auctioned, my lord, in that.
ಆಯ್ತು, ಈಗ ಮಿಕ್ಕಿದ ಏರಿಯಾ ಇಲ್ವಲ್ಲ, ಅದು ವಿತೌಟ್ ಸೈಟ್ ಇದೆ, ವರ್ಚುವಲಿ ಸೇಮ್ ಥಿಂಗ್.
ಯಾಕಂದ್ರೆ ನಮಗೆ ಆಡಿಟಿಂಗ್, ಲ್ಯಾಂಡ್ ಆಡಿಟಿಂಗ್ ಅಲ್ಲಿ ಆಲ್ಟರ್ನೇಟಿವ್ ಕೊಟ್ರೆ ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ ಸರ್.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು, his rights are to be taken away. Is it because of your audit objections?
We will refund the amount.
ಯಾವಾಗ ಕೊಟ್ಟು ತಗೊಂಡಿದ್ದ ಅಮೌಂಟ್?
2021, my lord.
ಎಷ್ಟು ಅಮೌಂಟ್?
Lord, the entire amount that I had paid, my lord, was 1,05,64,056. Now for the balance site which is available, my lord, it is set 64,24,000 is the sale consideration. The remaining balance is 40 lakhs that they have to give.
ಅದು ಕೊಟ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ, ಇಲ್ದರೆ 18% ಇಂಟ್ರೆಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ ಐ ವಿಲ್
ಅಲ್ಲ
ಡೈರೆಕ್ಟ್ ರೀಫಂಡ್.
ಮೇಲೆ 159 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್ ಈಸ್ ಅವೈಲೇಬಲ್. ಇಫ್ ವಿ ವಾಂಟ್ ಅದಕ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಕೊಡ್ತೇವೆ, ಅದಕ್ಕೆ ಇದಿಲ್ಲ. ಬಟ್ ಅವರು ಅದು ಬೇಡ ಅಂತ ಹೇಳ್ತಾರೆ.
For the remaining balance of 40 lakhs which they are saying, my lords may see annexure, they are charging 21% from me for that portion. ಈಗ ನನಗೆ 8% ಕೊಡ್ತೀನಿ.
ಅದಕ್ಕೆ 21%. ಈಗ ರೀಫಂಡ್ ಕೊಡಿ 21% ಇಂಟ್ರೆಸ್ಟ್ ಫ್ರಮ್ ದಟ್ ಡೇಟ್ ಟಿಲ್ ಡೇಟ್.
My lord,
which is beneficial to you ನೋಡಿ.
My lord, this honorable court, my lord, in the similar circumstance held, my lord, 7% interest.
I will, ಅಲ್ಲಿ ನೀವು 21% ಚಾರ್ಜ್ ಮಾಡಿದಿರಲ್ಲ,
ಇವರಿಗೆ 21%
ಅಲ್ಲ ಹೇಳಿದಿರಲ್ಲ, ಅದೇ 21% ನಿಮಗೆ ಕೊಡಿ.
That is, my lord, beyond 120, that is a rule, as per the rule, beyond 120 days, my lord.
Rule or no rule, you have played with this, with the money of this citizen, wait.
My lord, this
12% ಅಲ್ಲ, 21%.
ಅಲ್ಲ,
ಇಲ್ಲ ಅಂದ್ರೆ ಆಲ್ಟರ್ನೇಟ್ ಸೈಟ್ ಕೊಡಿ.
My lord, this honorable court, my lord,
ಅದೇನೋ ಫ್ರೀ ಕೇಳ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೂ ದುಡ್ಡು ಕೊಡ್ತಾರೆ. 1 ಕೋಟಿ ಎಷ್ಟಿದೆ ಅವ್ರ ಹತ್ರ? 1 ಕೋಟಿ 5 ಲಕ್ಷನಾ 5 ವರ್ಷದಿಂದ? Unjust enrichment.
There is no provision, my lord, that is.
No provision.
For auction site, alternative site.
Why did you do this then?
My lord, there, my lord, my instruction.
You don't do diligence prior to auction notification?
ಅಲ್ಲ, it is, my lord, at the time of the auction, my lord, the land was existing as it is, my lord. Thereafter, my lord, there was encroachment subsequent.
What did you do then?
Encroachment ಮಾಡಿ ಮನೆ
auction ಮಾಡಿ ಬಿಟ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಏನಿಲ್ಲ.
auction ಇದು encroachment
ಓಕೆ, ವಾಪಸ್ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. ವಾಪಸ್ ಅಂದ್ರೆ 18 to 21 ಆ ನಂಬರ್ಸ್ ಅಲ್ಲಿ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ.
This honorable court held.
No,
by
this
7
honorable court.
and the reasonable
You
8,
take, challenge it, no problem.
but a reasonable 8% or.
No, 8%. Unreasonable action ಗೆ reasonable interest ಬರೋದೇ ಇಲ್ಲ. Yes, reasonable action. No. Auction ಮಾಡ್ಬೇಕಾದ್ರೆ you should not see.
ಅಲ್ಲ auction ಮಾಡಿದ
ಮತ್ತೆ 5 ವರ್ಷದಿಂದ ದುಡ್ಡು ಇಟ್ಕೊಂಡಿದ್ದೀರಾ, ತಕ್ಷಣ ವಾಪಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ ಹಿಂದೆ
PDA ದುಡ್ಡು ಬಂದ್ರೆ ಅದು ವಾಪಸ್ ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ, ಪಿಟಿಷನ್ನೇ ಹಾಕ್ಬೇಕು.
annexure jail ನಾವು ಲೆಟರ್ ಬರ್ದಿದ್ದೆ ರಿಫಂಡ್ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಇದ್ದು ರಿಫಂಡ್ ಮಾಡ್ತೇವೆ.
ಅದೇ 2% 3% ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಏನು ಇಂಟ್ರೆಸ್ಟ್
ಏನು ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ.
ಅಲ್ಲ ದಿಸ್ honorable court said ಮೇಲೆ 7% ಇಂಟ್ರೆಸ್ಟ್
ಕೊಡಿ. Yes, Abhinay, you will take it back. Writ petition ಅಲ್ಲ, ದುಡ್ಡು.
Not at that percent, my lord. It's annexure R1.
What are the facts here?
ಅಲ್ಲ ಸೇಮ್ alert the auction ಮಾಡಿ there is no.
ಈಗ ಎಷ್ಟಕ್ಕೆ ಆಕ್ಷನ್ ಆಗಿದೆ ಇದು?
My lord, this is my lord the.
My lord, what he had paid was only the earnest money of 4 lakhs, not the entire sale.
No.
That's what. ಒಂದು ನಿಮಿಷ.
The entire amount.
Withdraw her bid and sought refund of earnest money deposit ಅಷ್ಟೇ. Clearly distinguishable. 21% ಹಾಕಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲ ಇದು ಆಕ್ಷನ್ ಮಾಡಿದ್ದು ಎಷ್ಟು ಡೈಮೆನ್ಷನ್?
My lord, the
Virtually 60-40, my lord.
258 square meters.
60-40.
ಅಲ್ಲ 60-40 ಅಲ್ಲ, ಇದು ಆರ್ಟ್ ಸೈಟ್ ಕಾರ್ನರ್ ಸೈಟ್ 258 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್.
ಈಗ ಎಷ್ಟಿದೆ ಅಲ್ಲಿ?
159 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್.
ಆಕ್ಷನ್ ಮಾಡಿ 258 ಗೆ.
ಹೌದು.
ಈಗ
99 ಸ್ಕ್ವೇರ್ ಮೀಟರ್.
99 ಸ್ಕ್ವೇರ್ ಮೀಟರ್
ಕಮ್ಮಿ ಇದೆ. ಅದು ಬಿಕಾಸ್ ಆಫ್ ದಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮೇಲೆ.
ಅದೆಲ್ಲ ಕ್ಲಿಯರ್ ಮಾಡಿ ಆಕ್ಷನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ ಆಕ್ಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಯ್ತದೆ.
ಆಕ್ಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಅಂದ್ರೆ ಯಾವಾಗ ಇವ್ರು ದುಡ್ಡು ಕಟ್ಟೋಕ್ ಮುಂಚೆನಾ?
ಇಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಅದು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಆಯ್ತು. ಆದ್ದರಿಂದ
we did not stop encroachment.
October 2020, my lord, auction is made. My lord, I paid the amount on January 21. Sale deed is executed in April 21. ಈ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಯಾರು ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಯಾರು ಮಾಡೋದು? It's not the case of encroachment. They have allotted it to somebody else.
ಇನ್ನು ಬೇರೆ ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ
Sale deed ಆಗಿದೆ.
ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮೇಲೆ ಬೇರೆ ಸೈಟ್ ಅದನ್ನು ಅಲಾಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ.
ಈಗ
allotment
97 square meters have allotted to someone else.
ಇಲ್ಲ, ಅದು 97 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ ಎನ್ಕ್ರೋಚ್ಡ್ ಬೈ ದಿ ಅದರ್ ಅಲಾಟಿ ಪಕ್ಕದಲ್ಲಿ.
ಆಯ್ತು, ಅದನ್ನ ಅಲಾಟ್ ಮಾಡಿದೀರಾ? ಲೀಗಲೈಸ್ ಮಾಡಿದೀರಾ? ಅದನ್ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದೀರಾ?
ರೆಗ್ಯುಲರೈಸ್ ಅಂತ ಮಾಡಿಲ್ಲ, ಬಟ್ ಅದು ಈಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಹೌಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಮ್ಮ.
They should take position.
ಈಗ ಬೇರೆ ಕೊಡ್ತೀರಾ ಇಲ್ಲ ಇದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀರಾ? ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಐ ವಿಲ್ ಪಾಸ್ an order. If you want to take it, Abhinay, with 18% interest, you take it. Yes.
And some cost of litigation.
ಅದೆಲ್ಲ everything. The petitioner is before this court seeking a direction to the respondent BDA to revalidate or renew the sale deed dated 27th April 2021 executed in favor of the petitioner in so and so property. ಇದರಲ್ಲಿದೆ, ಪ್ರೇಯರ್ಲಿದೆ.
ಎಷ್ಟು ಸೈಟ್ ಇದೆ ಅಷ್ಟು ತಾಣ್ತೀನಿ, ಉಳಿದಿದ್ದಕ್ಕೆ ಅಷ್ಟು. ಎಷ್ಟು ಸೈಟ್ ಇದೆ ಅಷ್ಟು ತಾಣ್ತಾರಂತೆ,
ತಗೊಂತೀರಾ?
ಉಳಿದಿದ್ದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್.
ಅಲ್ಲ, ಈಗ 258 ಗೆ
159 ತಾಣ್ತಾರೆ.
159 you will take. The remaining 97 square meters ಗೆ interest. 99 ಗೆ. ಈಗ ಬಟ್ ನೀವು 1.5 ಕೊಟ್ಟಿರೋದು ಪೂರ್ತಿಗಲ್ಲ?
ಅವರೇ ಲೆಕ್ಕ ಹಾಕಿದ್ದಾರೆ. annexure R4, my lord, it's 40,10,850. Page 10 of the statement of objections, my lord. ಲಾಸ್ಟ್ ಕಾಲಮ್ ಮರುಪಾವತಿ ಆಗಬೇಕಾದ ಮೌಲ್ಯ 40,10,000.
ಎಲ್ಲಿದೆ?
ಲಾಸ್ಟ್ ಕಾಲಮ್ ನೋಡಿ,
ಕಾಲಮ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್
ಪೇಜ್ 9 ಅಲ್ವಾ?
ಪೇಜ್ 10 ಮೇಲೆ
10. ಮರುಪಾವತಿ ಆಗಬೇಕಾದ ಮೌಲ್ಯ ರೂಪಾಯಿ 40 ಲಕ್ಷ. ಈ 40 ಲಕ್ಷ ಯಾವುದಕ್ಕೆ?
in 2001
ಅಲ್ಲ, 40 ಲಕ್ಷ is for the remaining 97. ಅದನ್ನು ವಾಪಸ್ ಕೊಡಿ with interest.
Interest may be.
Why? Yes. The petitioner is before this court seeking the following prayer. The respondent, Bangalore Development Authority, issues an auction notification seeking to auction the corner sites available for such auction at the hands of the BDA. The auction notification comes about on 16/10/2020. The petitioner.
4920.
Huh?
492020.
49.
ಹೌದಾ
ಇದ್ಯಾವ್ದು
notification.
ಮತ್ತೆ 1610?
ಅದು ಅವರಿಗೆ
Confirmation
25%.
On 4/9/2020, the petitioner desirous of securing the corner site applies and participates in the auction and is allotted a site, corner site of 258 square meters in terms of the allotment letter. The allotment letter reads as follows. Page 9 and 10. The petitioner then makes the payment, entire payment for the allotment, entire payment towards the allotment, i.e. for 258 square meters. And only to come to know that there is no, the area that was notified for, notified in the auction was short by 97 square meters. As 97 square meters was allotted to someone else and the said person is already constructed. In that light, what remained to the petitioner was only 159 square
59.
meters. The petitioner then represents to the BDA seeking allotment of alternate site of the same dimension. The BDA, on the score that there is no provision in law to allot an alternate site to an auction purchaser, declines to accede to the request of the petitioner, but passes the following order of repayment of 40 lakhs, refund of 40 lakhs. ಎಲ್ಲಿದೆ ಅದು?
Annexure
Page 10.
R4, page 10.
Page 10. They have not made the application for alternative site. madam. They have made the
ಇಲ್ಲಿ claim,
application.
yes.
ಹಾಕಿದೆಯಲ್ಲ, page 17.
ಅದನ್ನ
R,
sorry.
R for the communication reads as follows. Therefore, the BDA accepts the fact that the auction, the petitioner was granted, the petitioner in terms of the auction was not made good of the entire property that was put to auction, i.e. 258 square meters, but was granted only 159 square meters as the other property was already allotted to someone else. Therefore, there is the BDA without diligence has notified the property for auction, and the petitioner has paid the entire amount of 1 crore 5 lakh way back in the year 2021. The amount being the complete amount towards the entire auction consideration of 258 meters. But petitioner gets only 159 meters. It is accepted by the BDA. The communication made on 2/3/2022 reads as follows. The BDA is refund ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿದ್ದು, ಮಿಕ್ಕಿದ್ ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳಿರೋದಾ?
ಅಲ್ಲ excess amount 40 lakhs refund ಮಾಡ್ತೇವೆ ಅಂತ.
The BDA wants to, the BDA way back on 2/3/2022 holds that there has been a mistake and observes that the amount of 40,10,853 would be refunded. The amount is not yet refunded though. Since the petition is pending, the learned counsel for the petitioner is ready and willing to take the 159 square meters that is allotted to him and further take the refund of 40 lakhs that is as observed in the aforesaid communication. They, however, would demand interest and cost of litigation. ಈಗ ಅರ್ಧ ತಗೊಂತಾ ಇದ್ರಲ್ಲ, ಜಾಸ್ತಿ ಬೇಡ. In the light of the said circumstance, I deem it appropriate to direct the BDA to refund 40 lakhs as indicated herein above, along with interest at 12% per annum from the date it had to be paid till the date it reaches the doors of the petitioner, apart from cost of litigation at rupees 1 lakh.
Cost maybe.
50,000 ಅಷ್ಟಾರು ಬರ್ಬೇಕು. ಕಾಸ್ಟ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಅಟ್ ರುಪೀಸ್. ನೀವು ಎಷ್ಟು ಫೀಸ್ ತಗೊಂಡಿದ್ದೀರಾ? ನಿಮಗೆ ಏನು ತಗೊಂಡಿಲ್ವಾ? ಮತ್ತೆ ಕಾಸ್ಟ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ at rupees 50,000. For the aforesaid reasons, the following order: the auction notification, communication, auction notification insofar as the petitioner is concerned stands confirmed to 159 square meters. The remainder 97 square meters, which is valued at 40 lakhs, is directed to be refunded by the BDA. along with 12% interest from the date it had to be refunded till the date it would reach the doors of the petitioner. The cost of litigation, disposed ಮಾಡಿದ್ರಲ್ಲ ಮೇಲೆ, writ petition stands disposed with a cost of rupees 50,000 ಅಂತ ಹಾಕಿ ಆಮೇಲೆ ಇದು ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿ. ಎಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಯಾವ ಎಲ್ಲಿವರೆಗೂ ಕೊಡ್ತೀರಾ?
ಇಂಟ್ರೆಸ್ಟ್ ಇರುತ್ತೆ ಕಾಸ್ಟ್
ಎಸ್ ಇಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ 14% ಮಾಡಿ.
ಸ್ವಲ್ಪ ಇಂಟ್ರೆಸ್ಟ್ 12% ಕೊಡ್ತಾ ಇದೆ ಅಂದ್ರೆ ಪಬ್ಲಿಕ್ ಅಥಾರಿಟಿ.
ಪಬ್ಲಿಕ್ ನೀವ್ಯಾರು ಮಾಡಕ್ ಹೇಳಿದ್ದೆ? ಒನ್ ಹೂ ನೋಟಿಫೈಡ್ ದಟ್ ಆಫೀಸರ್ ಹಸ್ ನಾಟ್ ಡನ್ ಡಿಲಿಜೆನ್ಸ್ ಅವರಿಂದ ರಿಕವರ್ ಮಾಡಿ. ಎಸ್ so and so. The refund shall be effected with interest ಬರುತ್ತಲ್ಲ ಬಿಡಿ ಯಾವಾಗಾರು ಕೊಡ್ಲಿ ಅವರು. ಎಸ್
25%,
25,000 no bargain. Yes, next
97 ಆಗಿದೆ 99. Great.
ಇದು ಕೃಷ್ಣನ್ ಮೇಲೆ ಬಂದ್ಬಿಡುತ್ತ.
ಕಾಸ್ಟ್ ಬೇಡ ಅಲ್ಲಿ
ಕಾಸ್ಟ್ ಬೇಡ.
ಮಚ್ಚ
ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿ, ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿ ಅದು
12%.
ಅದಿರ್ಲಿ. ಎಸ್ ಭಟ್ರ ಏನ್ ಇಷ್ಟೊಂದು ಮ್ಯಾಟ್ರು?
I have filed.
Date is 2001 was the last payment when I made it.
ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ ಫ್ರಮ್
Day another 3 hour object ಮಾಡ್ತಾರೆ.
ಯಾವತ್ತಿಂದ?
12/1/21 ಮೇಡಮ್.
12/1/2021 ಅಲ್ಲ, ರೀಫಂಡ್ ಅವ್ರು ಕಮ್ಯುನಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೆ ಅವರು.
ಅಲ್ಲಿಂದ ನನಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲಿಂದನೇ ಬರುತ್ತೆ. ನಾನು ಬ್ಯಾಂಕ್ ಲೋನ್ ತಗೊಂಡು ಕಟ್ಟಿರೋದು.
ಆಯ್ತು ಸರಿ 12/1/21 ಅದ್ ನೋಡ್ತೀನಿ ಕರೆಕ್ಟ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ಅವ್ರ ಪೇಮೆಂಟ್ ಇದು 22/2/2021 ಅದು ಪಾಸ್ಟ್ ಪೇಮೆಂಟ್.
ಆಯ್ತು ಎರಡು ಡೇಟ್ ಬರ್ಕೊಂಡಿ 12/3/21 22/2/21. ಎಸ್ ನೆಕ್ಸ್ಟ್
14.
We have filed writ petitions, my lords,
Why?
challenging the award, my lords. Award has been wrongly passed under the 2013 Act. There are some non-compliance. 2 days I'll cure the same. Lords may have it on Monday.
yes
2016 is the award, my lord. 2016, and they have been, my party has been demanding for the payment by representing several times.
We'll point out.
And now,
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
Lords, Act, my lords, the award could not have been passed in 2013 Act. It had to be passed in 1894 Act only. 2013 Act is
if
not
at all they
applicable
could
to
have behind
acquisitions
it, I
under
have
the
been
BDA Act.
deprived of the property for last over 10 years.
2013 Act is not applicable to the acquisitions under the BDA Act.
All right, we'll see, we'll
I
answer.
have it on Monday, my lords. 2 days I'll cure.
Tuesday
Tuesday ಸ್ವಲ್ಪ Monday ಕೇಳಿ.
ಆಯ್ತು ಮಂಡೇ ನೋಡು. ಎಸ್
Great.
ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಮಂಡೇ.
Payment has been made, my lord. I lost.
ಮಂಡೇ ಬೇಡವಾ ನಿಮ್ಗೆ? ಮಂಡೇ ಬೇಡವಾ?
ಅಲ್ಲ ಆಗ್ಬೋದು.
ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಮಂಡೇ at the request of Ajay Kumar, making it clear that no further adjournment will be granted in the matter.
Permission to cure that.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಫೈಲ್ ಕೊಡೋಲಿಲ್ಲ ನಾನು ಸರ್.
The office objections be complied with in the meantime.
Great.
Yes.
15.
ಇದು ಅದೇನಾ?
This matter is challenged with respect to the final notification.
ಇಲ್ಲ, this also had heard.
Also, my lords have heard the
That's
matter.
what, 23rd. Yes.
15.
This is
Amendment.
the matter of 20,000 rupees award, which was passed for an acquisition of 94 for the airport.
ದೇವನಹಳ್ಳಿ ತಾನೆ?
Yes.
Yes.
But, I'll just take your.
Yes,
lordship's
Chandrasekhar
notes
sir.
to- It's filed additional statement of objections, my lords. I was in fact intending to do a bit of research as to how this should be resolved. But they have themselves come out with a solution as to how this is to be resolved. Lords, what happened? We placed on record that if your lordships were to recollect that 93
Yes,
lakh rupees. Now they have an explanation for this 93 lakhs. What they say is that these were all the lands of that village for which the revenue entries were not there for some reason. Then Deputy Commissioner determined that these are the lands belonging to them. Thereafterwards, in 2014, a representation was given to determine the compensation. So the KEDB adopted a methodology saying that we will take the valuation of 2014 and give you the award for these very properties acquired under the very same notification. I stand on the same footing. Now I am not in 2014, my lords. Now I am in 2025. But just to take your lordships, what is the kind of mischief which is played? Because the additional statement of objections, as long as it was 20,000, they were more than willing to give the compensation. Now they want to say that there is some dispute pending. But your lordships may kindly see, my lords, may I just pass on the small, copy. May I just ಕೊಡ್ತೀನಿ. Page number 36, your lordships may kindly take notes. This is where the whole things, lords, we made the representations in 1996, 2001, an endorsement is issued saying that you don't have title to the property, which was subject matter of a challenge in WP number 40911 of 2003. This is the first round of litigation. Lords, may kindly take page number 36. Lords, at page 37, paragraph number 2. And the operative portion, my lords. There is a dispute regarding the title. That is what they raised, saying that there should be a reference under section 30 and 31 of the Land Acquisition Act for determination of my title to the property. Now, after this, LAC 191 of 2006 comes to be initiated. Notes, these LAC proceedings, kindly have a look at page number 61. Commences at page 49, at page 61. Paragraph number 19, your lordships may kindly mark, because this is the finding which has been recorded saying that we are the absolute owners of the property. And this is a determination which comes about in the year 2012. Lords, it is in this interregnum, if your lordships were to take notes, page number 42.
I've seen that.
Yes. Now, after this is the third round. Lords, then what happens? There is one more endorsement issued, my lords, that is challenged in WP number 43919 of 2011. And subsequently, my lords, lordships may kindly take page number 72, 67, which I now read your lordships, my lords. Page 67, your lordships may kindly take. This is the fourth round. Lords, paragraph number 6 at page 72.
72, 73. Yes, I have seen. Next.
Then, if this is the fourth round, my lords, and then next what happens? They issue an endorsement saying that we have deposited 5 lakh rupees as per the directions issued in WP number 8302 of 2013 in LAC number 33 of 2017. Now, this is where the mischief starts.
This court did not direct any quantum.
Lords, quantum was not directed. They were directed to pass an award.
Yes.
What they did, they said 5 lakh rupees we have determined, and they deposited this money before the civil court. Before the civil court, they came and made an application saying that we have never passed an award. There cannot be a reference.
Where is that?
Kindly have a look at, lords.
Where are these contradictory stands?
Lords, page number 90, your lords may kindly take.
90?
90.
Yes. Whether this, before this court?
Yes. But after having made that application saying that no, we have not passed an award at all. Therefore, there cannot be an LAC proceedings for the purpose of enhancement of compensation, because that was an application seeking enhancement.
Correct.
So now at page number 90, this is filed by KADB. Lords, if your lordships were to see, at page 92, middle of the page, lords, paragraph number 3, lords, in the middle, since no award was passed, the respondent number 1 filed this the writ petition in 8302. As stated supra, subsequent to the aforesaid order of 2014, reference was made in LAC number 29 of 2015.
KADB deposited 5 lakhs.
Yes.
Consent.
Consent. There is again, I just wanted to say this. Notes, the KADB has an audacity to go against the findings of this court, which is at their instance. This honorable court very specifically observed that there is no such consent at paragraph number 4, page number 94. The last sentence in page 93 to page 94, their contention that there is a consent is not accepted.
This order has become final?
This order has become final, and this is the order by virtue of which, lords, that even that 5 lakh rupees was withdrawn by them from the civil court. Then again representations. Then your lords will kindly see page 103. Lords, the direction was issued in similar circumstances as to how the courts will have to decide, lords, the determination of the compensation. Now, with all these things, what they now do is, they say we have passed an award for 20,000 rupees.
Per acre.
Per acre. Now that is sought to be justified, lords, by filing a statement of objections. If your lords were to see, lords, the filing of statement of objections, I am so very happy, lords, that the statement of objections has come on record. Paragraph number 3.
Additional
Additional statement of objections.
Yes.
Notes. Pursuant to the order passed dated 2/12/22 passed by the honorable court. That is the order by virtue of which they were permitted to withdraw that amount. We obtained the statistics from 91 to 94. Then next page, they have given that table. 91 is 15,000, 92 is 1,90,000, 94 the preliminary notification, 96 final notification, 4 lakhs and 3 lakhs, 20,000 rupees is what is sought to be awarded
Per acre.
per acre. Then, if your lordships were to see paragraph number 4, this probably determines the
ಇದು ಎಷ್ಟು what's the land?
lords land.
ಎಷ್ಟಿದೆ?
The total extent of land in question is 12 acres.
12 acres. is
Yes.
it? According to you, how much should you get?
Lords, now
Same
what will be the
as the
date?
adjacent land?
Lords, kindly have a look at para 4. That determines, lords, what should be the manner in which the compensation has to be determined. Para
93 lakh 295 per acre.
as of 2017.
Correct.
Lords, now kindly have a look. The modus which is operated by them for the purpose of passing an award in relation to the lands acquired under the very same notifications. What happened? They did not pass an award because these were shown as the government lands. Now, similar to the circumstance where they wanted to say, no, we are not passing an award for whatever reason. Award is not passed. Now, wherever the award was not passed, that is the judgment, minutes, which is now relied upon, minutes, which is the last annexure in my writ petition. Wherever they did not pass an award, they were required to pass an award in terms of the date on which they would be passing the award by taking the reckoning the market value as on that date.
That is on 5/9/2017.
So now, as of today,
Oh, today's market
it
rate.
should be on today's market value because not what they did, this 20,000 rupees determination, what they have undertaken, Milords, is contrary to what they did in respect of the other properties which they have
Correct.
admitted.
That is contrary on the face of it.
So if once that goes, Milords, they will have to determine on today's market value. Milords, the Supreme Court says that wherever there is a delay, these are all only the documents to show what is the market value as on today in respect of properties which are 3 kilometers, 4 kilometers away from this place. I have stated in the memo itself, Milords. They have utilized the property. Now the only question is on what date the compensation or the market value for payment of the compensation is required to be determined. That they say this is the modus
ಇದು per acre.
per acre. Milords, had I had that property
ಖಾಲಿ
today in my
ಆಗ್ಬಿಡ್ತಾರೆ.
hands. ಅಲ್ಲ ಆಗ್ಲಿ. ಯಾಕೆಂದ್ರೆ ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು. If I had this property, this would have been the market value of the property, or if I had that money then, and if I had purchased the neighboring properties, this would have been the value of the property which I would have had. Ultimately, Milords, money is what money buys. Milords, this is the manner in which, this is the reason why I said, Milords, this is the 8th round of litigation. We have been driven from 2016, 1996 up to 2025. 1 year down the line, another 30 years, it will be 3 decades. The KDB can take to its benefit that they have
Correct. ಈಗ
successfully.
ಕನ್ಸಿಡರ್ ಅಂತ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ಬರುತ್ತೆ.
ಅದಕ್ಕೆ
Yes, sir.
These lands were notified in the 7794.
Hmm.
Now they are relying on annexures, the award of the other lands. So in those cases, the lands were utilized, therefore there were no.
ಯೂಟಿಲೈಸ್ ಮಾಡಿದಿರೋ ಇಲ್ವೋ ಲ್ಯಾಂಡ್ ಈಗ?
ಮಾಡಿದ್ದೇವೆ.
ಹಾ.
ಅದಕ್ಕೆ therefore, my lord, this.
20,000 ಹೆಂಗ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿದ್ರಿ ಇವ್ರು?
Because their own document says they purchased for 25,000 per acre. They have purchased 25,000. But petitioners of the court.
ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಗೆ ಎಷ್ಟು ಮಾಡಿದ್ರಿ?
Adjacent land ಇಂದ ಕಮ್ಮಿ ಮಾಡಿದ್ದೇವೆ.
ಇದಕ್ಕಿಂತ ಕಮ್ಮಿ ಮಾಡಿದ್ರಿ?
I produced the
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಎಷ್ಟಾಗಿದೆ ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಗೆ?
enhancement ಆಗಿರೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಯಾವ್ದು ಆದಂಗಿಲ್ಲ. ಕನ್ಸೆಂಟ್ ಅಲ್ಲಿ 5 lakhs per acre ಆಗಿದೆ. As per section 23 of the land action act, the compensation to determine the date of preliminary notification. The admittedly notification is 1994. And my lord, the petitioners were before this honorable court, they are the GPA holders, agreement holders.
ಇವ್ರ?
ಅಂದ್ರೆ they are the pursuing the matter.
Lords,
Pursuing the matter ಅವರು.
93 agreement, there is a deed of assignment.
Their own document says they have purchased it for 25 lakhs per acre.
25 lakhs.
25,000 per acre. They relying on that, they pass. I may be permitted to say another thing, my lord. That in the identical circumstances, this all court says identical matters, my lord. In 2010, these identical circumstances, matters were notified, awards were passed. Taking into consideration 1994, respect a very same notification. Now, that was challenged before this Honorable Court. This Honorable Court quashed the award, directed to pass award in 2010. Not, because when they were issued the correspondence. Following that, my lord, this correspondence date were taken to that lands, my lord. They passed award to that cases. That is not applicable to this case. Added to that, earlier petition, my lord, there was a direction to pass award. If that was the case, my lord, they could have sought the prayer in that case itself. Therefore, my lord, under Arbitral Rule 2, they waived the right. They are stopped into seeking that. Yes, my lord. My lord, I may permit you to.
Waiver of right, yes, sir.
And two.
So 20,000 ತಗೊಂಡು ಹೋಗ್ಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ, ಅವರ ಎಲಾಸ್ಮೆಂಟ್ ಕೇಳ್ಬೋದಾಗಿತ್ತಲ್ಲ ಅವರು. And my lord, I may permit you to pass on judgment of this.
ಕೊಡಿ sir.
In respect of the very same notification. Just may I permit to read. Petitioners are sought for Karnataka notification and word annexed with respect to issued by first respondent. Petitioner also sought for award dated passed by third respondent. Ultimately, this on court quashed the award, said 1994, this is the date of Karnataka. That's the relevant date you have to pass awards. Here there is no Karnataka. 1994, like the case annexure J, my lord, there were lands were not included. Therefore, notification was issued in 2015. 28-2 notice was issued to them. Then inquiry was held on 28-3. Then final notification was in 2016. Therefore, not 2015 notice dates were taken. And my lord, in the under judgment of Supreme Court, my lord, the petitioners. When the petitioner themselves are party for the sale deed, this is the best piece of evidence. They cannot seek more than that.
ಸೇಲ್ 25,000ನಾ?
ಅಲ್ಲ, ಅವತ್ತು ಕಷ್ಟೇ ಇದ್ದಿದ್ದು. ಅವರೇ ತಗೊಂಡಿದಾರಲ್ಲ, ಅವತ್ತಿಗೆ ಅದೇ ಡೀಟೇಲ್ ತಗೊಂಡಿದ್ದಾರೆ, ಅದೇ ಡೀಟೇಲ್ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ, ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, ತಿಳಿಸಿ.
I produced the document also, their own document. And moreover that, my lord, they sold to 3 persons. The petitioner sold to 3 persons. There are other specific suits also. They have produced the plaints also. Now that can, it can, and my another judgment related on annexure, my lord, with Justice Krishna, that is an appeal, my lord. Then the appeal.
Justice Krishna Kumar ಅವ್ರದ್ದು.
That is Justice Krishna Dikshit order. That is in pending before the appeal.
ಸ್ಟೇ ಆಗಿದೆಯಾ?
Stay ಆದಂಗಿಲ್ಲ, appeal ಹಾಕಿದ್ವಿ.
73 by way of reply, my lords. Needless to mention, if in the meanwhile the judgment passed in LLC number 191 of 2006 dated 31/5/2012 attains finality without any modification, in such event, the amount shall be disbursed.
That is Justice Bopanna ಅವ್ರದ್ದು.
Yes.
Yes.
Lords, now the reason why I am referring to this is that there is already a direction which has been issued that if LIC is not disturbed, then the compensation is required to be disbursed. Only question, my lords, which of course even now they are not in a position to respond to is this. When you have adopted this modus for computation of the compensation, that for some reason we did not disburse or pass an award in respect of the lands acquired in the year 94-96, but subsequently because of the revenue proceedings, it was determined that the land belonged to the persons belonging to this, which is this village? That is Ganga Muttanhalli village. And then they said, no, we will take the date for reckoning of the market value to pass the award of 2017.
We'll see.
That's essentially what we are saying, my lords. Now, even if your lords were to see the series of orders that has been passed by this honorable court.
Page 76 is the award they are relying on. They mentioned the dates also. That is the 2015 notification.
Yes, heard reserved.
Yes, but sir, there are some judgments, my lords. No, I'll just, please.
Yes. Next.
17.
Lord, serial number 17, 19 and 19 one are connected, my lord. 19 may be taken up as the main matter, my lord.
Wait then. Next.
The
Railways then. 19 ತಗೊಂತೀನಿ, 18 on that. Yes.
Appear for the petitioners, my lords. Matter pertains to JP Nagar 9th phase. In fact, my lords, it's covered by the decision of this honorable court.
Yes, Achappa.
And even
Covered.
confirmed by the Supreme Court.
They filed the rejoinder, my lords.
I have also filed a rejoinder.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ, ಸ್ವಾಮಿ.
Take it on 16th, then look into that. List on 16th, the learned counsel appearing for the respondent submits the rejoinder is served upon him recently. List the matter on 16th. Yes. Entry ಮಾಡಿದೆಯಲ್ಲ?
ಇಲ್ಲ.
Next.
19.
My lord, the petitioners have challenged the preliminary notification stating that the same has been rescinded. We've also challenged the section 21(1) notice that has been issued by the respondents, my lord. The date of the preliminary notification is 30/1/2019, my lord. Page 27, my lord, Annexure B.
Yes.
And the date of the final notification under section 19(1)(2) is 18/1/2023, my lord. Annexure E, page 38, my lord.
Yes.
Under the, as per the act, under section 19, subsection 7, unless and until there is an extension order passed by the government, which is also uploaded on the website of the authority concerned, the same stands automatically rescinded, my lord.
Where is that?
Section 19, subsection 7, my lord, of the act, of the Land Acquisition
Land
Act.
2013?
Indeed, my lord.
Yes. What do you mean? Land acquisition. Allah, sorry. 2013.
To fair company, transparency.
ನಾನೇ correct ಆಗಿ ಹೇಳ್ಬೇಕು.
Section 19, subsection 7, my lord. Where no declaration is made under subsection 1 within 12 months from the date of the preliminary notification, then such notification shall be deemed to have been rescinded. And the only exception to this is the second proviso, my lord. Provided for the appropriate government shall have the power to extend.
Yes.
Power to extend, and that is controlled by the subsequent proviso. Provided that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned.
What are the dates? Repeat.
18, my lord.
Preliminary notification.
31/2019, my lord. Final notification 18/1/2023, my lord.
4 years.
Indeed, my lord. Therefore, it stands automatically rescinded.
Where is the, no, it's proviso compliance ಆಗಿದೆಯಾ?
I don't appear. Extension is made.
Where?
Original documents.
ಎಲ್ಲಿದೆ?
Submit.
ಕೊಡಿ. ಅದ್ರಲ್ಲಿ ಕೊಡಿ. ಫ್ಲಾಗ್ ಹಾಕಿ ಕೊಡಿ.
ಇಲ್ಲ, ಇದೆ ಅಲ್ಲ. Page number 38.
ಹಾಕಿದ್ದೀರಾ?
No, 38 of the petition.
I am only impeding applicant. I don't have much information about the acquisition detail.
The extension order really.
That you have to get.
ಇದು ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಯ್ತು.
ಅದರೊಳಗಡೆ ರೆಫರೆನ್ಸ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಬೋಲ್ಡ್ ಲೆಟರ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಕಡೆ ಮಾರ್ಕ್ ಮಾಡಿದೆ.
14/9/2020.
ಮುಂದುವರಿಸಲು ಅಂತ ಏನೋ ಬರ್ದಿದ್ದಾರೆ. I don't know whether it
ಭೂ
is.
ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಮುಂದುವರಿಸಲು ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ. 31/2019, 14/9/2020. Where are the records? ಅದು ಕೊಡಿ, ಅದು ಎಲ್ಲಿದೆ? You're on that point, that's all.
No, that is if that point goes, then there is no need to address. We've also challenged the section 21(1) notice that they issued, my lord. The section that has also been, but if this point, if the preliminary notification stands rescinded, there is
No,
no.
correct. If it is sustained,
If it is sustained, then I'll proceed to section 21(1) notice, my lord. Even that is defective.
we'll see. Yes.
With regard to some number of trees and other things have not been recorded in, that's what he says.
First, let the threshold get over.
Next, 20. The 22 is as well.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಸ್ಫೂರ್ತಿ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ಇದೆಯಾ?
ವಿಸ್ತರಿಸಿ.
ಏನು ಒಂದ್ ಲೈನಾ?
One not order ಇದೆ. Everything it will be there.
ಬ್ರಾಡ್ ಗೇಜ್ ಮಾಡಿದೀರಾ ಈಗ?
Construction is going on.
Going.
ಇಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ ಈಗ?
Yes, that's why you have moved an application for impeding and requesting the vacating the street.
ಎಲ್ಲದರಲ್ಲೂ ಆರ್ಡರ್ ಇರುತ್ತೆ ಇಂಡಿವಿಜುವಲ್.
Except 2 survey numbers, no other issues are there in.
Next point.
No, my lord, it has to be, it has, the publication requirement is very specific, my lord. I read the publication
You don't
requirement.
worry about it. I will take care of it. Next point ಗೆ ಬನ್ನಿ.
Section 21,
What is that?
there has been non-compliance with the requirements under section 21.
What is that?
1, my lord.
Yes.
Section
Notice
21.
to persons interested.
It requires a notice and an opportunity of personal hearing to them, and the threshold, the specific requirement is it should be more than 30 days. In the specific case, the notice is confined, notice says only a written representation may be given within 30 days. No specific date of hearing has been provided for. The requirement of at least not less than 30 days and 6 months has been completely dispensed with. And that is completely unsustainable, my lord. Section 21 of,
Where is the notice issued to you?
my lord, the notice may be found at page number 49, my lord. Annexure F1, my lord.
Ah,
The first paragraph itself, my lord, at the latter half, ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಭೂಮಿಯಲ್ಲಿ ಹಿತಾಸಕ್ತಿ ಉಳ್ಳ ಎಲ್ಲಾ ವ್ಯಕ್ತಿಗಳು ಸದರಿ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮ ಆಕ್ಷೇಪಣೆ ತಕರಾರುಗಳನ್ನು ಏನೋ ಇದ್ದರೆ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 30 ದಿನಗಳಿಗಾಗಿ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿ
30 ದಿನಗಳ ನಂತರ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ 30 days time ಕೊಟ್ಟರು.
The personal hearing has been dispensed with. It has been confined to only 30 days as opposed to the minimum limit being
Personal hearing is a statutory one or
statutory requirement.
dispensable?
It is not dispensable, my lord. Section 21.
The collector may require stones shall also serve the same of occupier. ಯಾವುದರಲ್ಲಿದೆ personal hearing?
Section 21, subsection 2, my lord.
To appear personally or by agent at the time. ಇದು ಮಾಡಿಲ್ವಾ?
No, it has not been done. It instead
Yes,
they confined to
Spurti.
just 30 days.
Yes, sir.
Personal hearing, I am not able to find in the records. That is true, my lord. But their objection is clearly considered by our detailed order is also passed, my lord. The flag in the red color, the right.
But the statute mandates personal hearing.
But it is considered, my lord. Their objection is, maybe looked into, my lord, the
Kodi.
flags which are at the side.
ಅದು ಕೊಡಿ ಮೇಡಮ್ ವಾಪಸ್.
Their specific objections are only with respect to the dispute of the land which are being
This
considered.
has been interpreted?
My lord, I have not found any specific judgment on this particular point, my lord. But on Railways Act, there are some judgments
Acquisition,
that personal hearing may not be dispensed.
we'll see, yes. Because this has some ramification.
Because some of the records are only available in the office, my lord. So unless and until there is a right of personal hearing and the advocate can verify those records, the representations will be incomplete.
What's your
My
ground
lord,
now?
their representation.
La- Against the acquisition, what is the ground?
My lord,
Objections,
the
objections.
Other than
objection
that, other than these two?
that they have not, that they have not considered, that they have not given us an opportunity to consider the quantum of compensation that is to be ascertained.
Telva.
In the
That's all. We will direct them to consider the quantum of compensation now. How can we grant stay and stall railway line being,
But my lord, the publication requirement is very specific.
publication
has-
requirement, I will answer 19(7), don't worry about
It
it.
has to be
Now, there
uploaded
is
on the.
violation of 21(1). Qua compensation will direct them to hear you and pass orders.
The award notice may be quashed, my lord.
Award notice, we'll see. What's
Because
to
if
be
the-
done, we'll see, yes.
The award notice has to be
Why
quashed
do you
and
do
it may
such
be reheard.
things? ನೋಡಿಲ್ವಾ act?
ಎಲ್ಲರನ್ನು ಸೇರಿಸ್ಬಿಟ್ಟು ಒಂದೇ ಹಿಯರಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದು? ಅದಾದ್ರೂ ಕೊಡಿ.
One has been heard and every objection has been considered individually to their respective survey numbers, my lord. The red flag is the, with respect to.
There are full of red flags in this.
Not that, side.
Then?
That is the pertinent to 79 bar
ಇವ್ರದ್ದು ಯಾವ್ದು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, ಇದೊಂದೇನಾ
objection.
ಪೂರ್ತಿ?
ಅದು ಎರಡನೇದು. ಅದೊಂದೇ ಅದು ಅವ್ರದ್ದು 18 serial number 18 ಐತಿ.
18
17. And 18 is.
19. Also kindly see the page number
And-
47, my lord. They are admitted that, my lord. See. Second para.
47 ನಾ?
47 in repetition. Our request ಅಲ್ಲಿ admit ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ?
Page number 47.
ಏನಂತ?
ತಾವು ಈ ಯೋಜನೆ ಪ್ರಾರಂಭಿಸುವ ಮೊದಲು ಹಳ್ಳಿಯ ಜನರಾದ ನಮಗೆ ಸರಿಯಾದ ಮಾಹಿತಿ ನೀಡದೆ ಹಾಗೂ ಭೂಮಿಯನ್ನು ಕಳೆದುಕೊಂಡ ರೈತರಿಗೆ ಮತ್ತು ಕುಟುಂಬಕ್ಕೆ ಬದಲಾಗಿ ಬೇರೆಡೆ ಭೂಮಿ ಮಂಜೂರು ಮಾಡುವುದಾಗಿ ಮತ್ತು ಪ್ರತಿ ಕುಟುಂಬದಲ್ಲಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ತಾರ ಏನ್ ಇದು ಮಾಡಿದ್ದೀರಿ?
ಆಯ್ತು ಅಷ್ಟೇ.
My lord,
ಕಾಂಪನ್ಸೇಷನ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ.
award notice has to be
We-
quashed. My lord.
The process will not be stopped.
No, the award notice may be quashed
Oh,
and
that's-
after hearing them, the fresh award notice.
We'll
Be
see about
directed.
that. Because hearing is also given not to you individually, but to all.
No,
ಎಲ್ಲಿದೆ?
it has to be, no, my lord, that is,
Personally ಅಂತಿದೆ, we'll see.
it has to be.
I just want to look into the interpretation, yes.
My lord, I'll furnish some judgments on the point, my lord.
And you should have bought it now. Less tomorrow, yes. Less tomorrow, but day after tomorrow haki, we'll check.
The original records,
Original ಅದು.
original records, they are officers,
ಕೊಟ್ಬಿಡಿ madam.
individually. they
ಅದು
are-
ಇಟ್ಕೊಂಡಿರಿ ನಾಡಿದ್ದು ಬೇಕು.
Yes, much.
Interim order may be extended. my lord.
If you don't get any judgments, this will go. Yes. Day after tomorrow on preliminary here. Next. A second list al haki madam, tax list al then. Next.
20.
PF petition. Writ of mandamus seeking.
These copies were not served.
Counsel with the petitioner, copies are not served. Why such small things are said?
Seeking
Yen mandamus
direction- Seeking direction to the, because it's Dr. Shivram Kant layout, a representation.
Consider what? Representation.
Representation.
For what have you given?
I've been seeking because there is a committee, Chandrasekhar, Justice Chandrasekhar committee. has been
ಆಯ್ತು
formed.
ಕಮಿಟಿ ಗೊತ್ತು, ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ ರೆಪ್ರೆಸೆಂಟೇಷನ್?
To consider my application and.
Committee is
regular-
not there now.
Not there also. Other than
Then
that,
who will consider? Committee is not there. What is it? Regularization.
Regularization.
BDA will consider. Yes.
I'll secure it.
What secure? Identical orders division bench ಅಲ್ಲಿ day in and day out ಮಾಡಿದ್ವಿ.
ಇದು connected repetition has been disposed of.
ಇಲ್ಲೇ ಇದೆಯಲ್ಲ, page 51. The petitioner is before this court seeking the following prayer. The petitioner heard so and so. The petitioner is said to be the owner of the property having acquired it on 7/11/2024. The petitioner had, vendors of the petitioner. The petitioner purchases the purchases a site in the said property bearing number, idralide synopsis here. Submits representation to be, for the matter to be placed before the Justice A.V. Chandrasekhar committee, and the respondent BDA have not placed the same, and therefore the petitioner is before this court. Today, there is no committee in subsistence. In that light, the division bench, considering the identical pleas, has passed the following order. Page 53 to 54. In the light of the prayer being innocuous to consider the representation seeking regularization as also the order passed by the division bench, I deem it appropriate to dispose the petition as is directed by the division bench supra, which would be consideration of the representation within an outer limit of 4 weeks, 8 weeks kodla, within 8 weeks from the date of receipt of the copy of the order. It is made clear this court has not dealt with the merit of the claim of the petitioner. Yes.
21.
For the petitioner, my lords. Respond number 2, my lords, is putting up construction without obtaining plan sanction.
Respond number 2, yaar.
BDM.
VDA.
BDM.
Matter, my lords, is pertaining to the Sadashiv Nagar complex, my lords. There is one more writ petition, my lords, which is pending.
ಆಯ್ತು, one more plan sanction ilva?
ಇಲ್ಲ, ma'am. Can I request my lords to take page number 387, my lords? Annexure H1.
387.
387.
There are interim orders passed in the other matters. Just pass on. It's
What had
directed-
passed, what had given my lords on the last occasion.
I also passed an order, I guess. Building beyond permitted or under sanction plan.
But this is a case where there is no plan sanction at all, my lords. They've not, admittedly, if I can request my lords to take page number
Admitted, plan sanction illa anta.
387, my lords.
Sections to that text, my lords.
Kodi madam, 387 ಏನು?
Annexure H1, my lords. We'd made an application under RTI seeking information. They dismissed that where we filed an appeal. This is the endorsement that they gave in my appeal.
Connected with that.
Annexure H1 at 387.
Madam, 387. ವಾಲ್ಯೂಮ್ ಇಲ್ವಾ?
Yes, my lord.
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ? Oh, it's here, it's, sorry, yes. 387.
Please, my lords. This is
ಏನ್
their endorsement to
information?
my appeal, my lords.
Hmm.
My lord should see reply column.
As of now, no plan has been sanctioned and the application is disposed.
And construction is going on, my lords. In fact, in the connected matter, there's an
What is
order.
the construction?
My lords,
What is the construction?
they're putting up a shopping mall, my lords.
Yelli?
Big commercial establishment on that.
Complex lots in Sadashiva.
BDA complex in Sadashiva.
Pertains to BDA complex itself, not putting up the construction. That's what it is.
So ಅದಕ್ಕೆ plan ಬೇಕಾಗಿಲ್ವಾ?
There are certain directions passed notes in the connected matter also.
Which is that?
I've given a copy. Hence I was making request notes that both need to be heard together.
Is permitted to take up works, damage of the property. ಅಷ್ಟೇ.
Only to that extent, my lords.
Because may have this matter along with this.
Tag this petition. Oh, ನೀವು Residents Welfare Association.
In that petition, my lords.
Here,
We are the adjacent neighbors of the building.
tag this petition along with WP 3355 of 2024. List them all on 16th. List them all on 16th.
No order may be passed, my lords.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ intermod ಇಲ್ಲ, the coordinate bench is permitted constructions.
Only to the extent of protecting the neighboring buildings, my lords. In violation of that, entire construction is going on.
Both matters can be taken up together.
No, but since the coordinate bench has already granted permission, I cannot say I will not grant.
No, not to stop. To that extent, it may be passed.
Same
Because what
order.
is,
In the light of the coordinate bench has granted the following interim order. In the light of the matters being now tagged and the petitioners similarly situated, the same interim order is paraphrased to this petition as well. Don't damage the property. Same order. 16th, yes.
22.
For the petition of course. Lords, matter has to do with Venkateshwara layout.
Soft drinks.
Please, my lords, the Torino factory matter.
Torino.
ಹೌದು. ಮೈಸೂರು ರೋಡಲ್ಲಿ ಇರೋದು.
ಗೊತ್ತಾಯ್ತು.
Please. My lords, the matter was, sorry, the property was first notified in the year 1990. My lords,
Objections are filed?
file rejoinder also has been
Oh,
filed.
pleadings
Pleadings are
complete.
complete.
Yes.
Please, my lord. My lords, as per section 27 of the BDA Act, my lords, it was to lapse in November 1995. My lords, there are four decisions of this honorable court, three of course being of a coordinate bench and one, my lords, of a division bench in respect of the same scheme itself, observing that no progress has taken place and the scheme has lapsed.
ಈಗಲೂ ಏನ್ ಪ್ರೋಗ್ರೆಸ್ ಇಲ್ಲ, ಬರೀ ಪಾರ್ಕಿಂಗ್ ಅಷ್ಟೇ.
Please, nothing has happened, my lords. In fact, all around my property, it's private property, buildings have come up. We had constructions over there. My lords, in the objections, the stand is now taken that BDA has taken possession. My lords, before I go to the Mahazar, which of course is cyclo-styled and all of that, my lords.
Where are the judgments?
Please, my lords.
Give
Of
it,
the coordinate bench, my lords,
whatever you told now.
please,
Coordinate bench, division bench of the same notification.
please, my lords.
Could
My
you-
lords, may I kindly see page 49 of that,
Of the
of the writ
petition,
petition itself, my lords.
you've annexed it?
I have, my lords. One judgment with this, my lords, and two others with my rejoinder. The division bench judgment, I'll just hand over. Lords, page 49, my lords, of the writ petition, annexure E.
Rejoinder ಹಾಕಿದ್ದೀರಾ? Yes.
Please,
Just Anand Bare Reddy.
please. In fact, three decisions are by his lordship, Justice Bhairavi. Lords will see Act, ink page 50, my lords.
Division bench ಯಾವುದು?
Division bench is,
ಅದು ಕೊಟ್ಬಿಡಿ.
please.
All three by the same learned judge.
Of single judge.
Single
yes,
judge,
my
yes.
lords. The division bench is Justice Malimat and Justice.
No, that is confirming this or a separate? order?
Separate.
This has become final?
It has become final.
Yes, Vachan?
I'll have to verify, my lords. This
Eh?
I'm not aware. That
Not-
other
not
judgments, my
aware.
lord, the other judgments, my lord,
ಏನಾಗಿಲ್ವಲ್ಲ ಅಷ್ಟೇ, that's all his case.
ಆಯ್ತಾ? You want to say?
Lords, they have taken the stand now in their objections, belatedly, of course, that they are in possession. My lords, I've produced along with my writ petition RTCs, e-khata, tax paid receipts.
ಎಲ್ಲ ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ಇದೆ.
ಎಲ್ಲ ನಮ್ಮ ಹೆಸರಲ್ಲಿದೆ. Further, my lords, in the year 1999, 4 years after the lapse, the same property has been converted by the BDA itself in my favor from agricultural to residential. That also, my lords, I've produced.
Pages.
My lords, the conversion order is Annexure C, my lords. At typed copy, my lords, at 39. At 39, my lords, that's the clear copy.
Commissioner. 1967.
1967.
My lords, that is to do with, please see, my lords, page 39, which is to do with the scheduled property, which is 191A.
99.
How? 99. So 4 years after the lapse,
ಅದು
they have converted it.
95, not by the BDA. Deputy Commissioner, 95 conversion.
Please, my lords.
Land Revenue Act conversion.
Please.
95, yes.
Please, my lords. My lords, no 16(2) notification, my lords. And as your lordships have held in the division bench in Gautam Kamat's case, my lords,
Where is
in
that?
their statement of objections,
This one.
the BDA has
Which
not.
is that judgment?
Please, my lords. In fact, there are about 3 judgments of your lordships in
give
DB. 311. Kodi, next one, Kodi. And this one, no? Just give. Lords, 2 division benches, my lords, and 1 single of your.
What
lordships.
happened to these?
Lords, these have also attained finality, my lords, no challenge, but this does not have to do with Venkateshwara layout. They are to do with other layouts, my lords. In fact, the most recent one of June 2025 of your lordships, in fact, considered a coordinate bench with respect to that scheme, my lords, and followed it.
Yes, Swachan, ಇದೆಲ್ಲ ನೋಡಿ.
I'll see it.
We'll take it on Tuesday,
Please.
9th. Go through all this
Please.
and that day, no time, we'll close this.
We're ready.
List the matter on Tuesday. I'll also go through all that.
My lords, may I request for 10th, my lords, if your lordships.
10th kashta, CPC day. 9th or 16th?
16th, my lords.
My lords, 9th.
16th, 9th, ಶಿವಮೊಗ್ಗ ಹೋಗ್ಬೇಕಾಯ್ತು ಅದಕ್ಕೆ.
ಶಿವಮೊಗ್ಗಗ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲಿ ಅದೊಂದು ಟ್ರಯಲ್ ಇದೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
Try, ಅದೆಲ್ಲ ಹೈಕೋರ್ಟ್ ಹೇಳ್ತೀರಲ್ಲ.
16th, my lord.
Yes, all right, 16th.
Please, my lord.
Anyway, it's 2025 matter, right? Issue ಹಳೇದು, petition 20. Yes.
Interim order may kindly be extended.
Interim order subsisting would continue to the next date of hearing.
Please.
Most obliged.
I'm appearing for the respondent 1, my lords. I'm seeking time to file wakalat and statement of objections. Seeking 2 weeks' time, my lord.
List the matter on 16th at the request of the council appearing for the respondent who seeks time to file statement of objections. Objections, if any, by the next day. Next.
Grateful, my lords.
Second respondent.
Muda?
Lord, the petitioner's land was acquired. Subsequently, section 18 application was filed seeking enhancement of compensation, rejected on the ground of delay. Thereafter, my lord, an award was passed by the LSC court enhancing the compensation in some other lands.
Adjacent land.
Adjacent land. 28A application was filed, which has been rejected. It is covered, my lords. My lord would find annexure G, page number 34.
Will allow it on the same grounds. The petitioner is before this court seeking the following prayer. He heard so and so. The prayer of the petitioner is to refer the matter under section 28A seeking enhancement of compensation, which had been turned down on the score of delay. The learned counsel for the, I'll put it on that side. Counsel for the petitioner seeks to place reliance upon the judgment of the coordinate bench in writ petition, page 34. The learned counsel for the respondent GB Sharath Gowda representing the Muda would not dispute the position of law as is considered by the coordinate bench. The coordinate bench is held as follows. More pages. In the light of the judgment rendered by the coordinate bench and the petitioner similarly situated, similarly circumstanced, I deem it appropriate to grant the same relief that is granted by the coordinate bench. page 39 ಏನಿದೆ oral recording. Yes. Next.
25.
Seeking a direction to execute a sale deed.
Sir, a copy of the objections today.
Objection ಏನಿಲ್ವಾ? ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಲ್ವಾ?
ಮಾಡ್ಬೋದು. ಅವ್ರು ಸ್ವಲ್ಪ conditions ಇದೆ. They have to get me a legal head certificate from the Tahsildar.
ಅದು ready ಇದೆ. Family tree will undertake to produce.
Affidavit ಕೊಟ್ಟಿದ್ದಾರೆ. Legal headship certificate from the Tahsildar and
ರೆಡಿ ಇದೆಯಾ?
Ready ಇದೆ.
ಕೊಡಿ.
Like client phone ಮಾಡಿದ್ದೆ, it is available.
let him give it to
Will
BDM.
BDA
We'll close this then. The petitioner is before,
Moment lordship to continue. Page 4 of my objection.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು ಅಂತನಾ?
Because he's not the original allotee. Children of the
ಮಕ್ಕಳ
ಅದಕ್ಕೆ we do not know. Original documents ನೋಡ್ಬೇಕು.
ಎಲ್ಲ ಇದೆ, ಎಲ್ಲ ಆಲ್ ಕಂಪ್ಲೈಬಲ್. ನೀವು BDA ಸೈಟ್ ಕೊಡ್ತೀರಿ ಅಂದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡ್ತಾರೆ. The petitioner is before this court seeking the following prayer. Owing to the prayer of the petitioner, this court on 15/7/2025 had passed the following order. The order in fact captures the issue succinctly. The learned counsel appearing for the respondent B. Vachan files a statement of objections in which the demand of certain documents are projected. The demand is as follows, para 14. The learned counsel for the petitioner submits that all that is now sought for would be handed over to the BDA within 1 week from the date of receipt of the copy of the order. In the event the petitioner hands over all the documents that are now, all the documents and also complies with the balance sale consideration as is sought for, the BDA shall not brook any further delay and get the sale deed registered within
2 months.
ಅಷ್ಟೊತ್ತು ಯಾಕೆ?
Legal as we'll also draw a separate margin, visit the property.
Within
There are three persons, three petitioners ಅಂತ.
petitioners ಆಯ್ತು. Within an outer limit of 8 weeks from the date of receipt of the copy of the order, if not earlier. It is, there is no reason to believe that the BDA would again drive the petitioner to this court for the same cause of action.
8 weeks from the date of receipt of all the documents and information.
8 weeks from the compliance quoted supra. ಅದರಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
26.
Petitioner similar matter.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ similar matter ಕನೆಕ್ಟೆಡ್ ಮಾಡಬೇಕು.
ಕನೆಕ್ಟೆಡ್ ಏನ್ ಕನೆಕ್ಟ್?
Similar matter ಮೈಲಾಡ.
ಎಸ್ ಪ್ರದೀಪ್ ಏನಿದೆ?
ಯಾವುದು ಗೊತ್ತಿಲ್ಲ. 13 ಮಾಡೋದು ಅದರಲ್ಲಿ ಇನ್ನ not yet filed ವಕಾಲತ್ also
ಅದು ಯಾವ್ದು ಸಿಮಿಲಾರಿಟಿ ಏನದು?
ಸೇಮ್ 28/1 ನಲ್ಲೇ ನೋಟಿಫಿಕೇಶನ್.
Learned counsel HL Pradeep Kumar seeks
ಡೆಫಿನೆಟ್ ಇರಲಿ ಸರ್.
2 weeks time to file 2 weeks ಸಾಕಾ?
3 weeks.
3 weeks time to go through the papers and make a submission or file statement of objections as the case would be list on 23rd September. Objections if any by then. Next.
27.
Here for petitioner, my lord. Petitioner, my lord, kindly issues notice from respondents, notice.
First time ಬರ್ತಾ ಇರೋದಾ?
My lord, the LSC was dismissed, my lord, after 11 years they have filed this.
ಸೇಮ್ ಈಗ ಒಂದಾಯ್ತಲ್ಲ. ಏನ್ 28 ಕೇಳಿದಾರಾ?
28 ಹೇಗೆ ಅಂತ ಹೇಳಿಬಿಟ್ಟು ಅವರು MA ಹಾಕೊಂಡಿದ್ದಾರೆ, ರಿಸ್ಟೋರೇಷನ್ ಆಫ್ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಅದು 11 years ಡಿಲೇ ಇತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಆಪರೇಟಿಂಗ್ ಪೋರ್ಷನ್ ಪೇಜ್ ನಂಬರ್
ಆಯ್ತು, ಸದ್ಯಕ್ಕೆ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ಆಲ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಲರ್ನಡ್ HCGP ಸೆಕೆಂಡ್ ಅಪ್ಪರ್ ತುಂಗ ನೀವೇನಾ? ಭೀಮಯ್ಯ ಇರ್ಬೇಕಲ್ಲ. ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ KS ಭೀಮಯ್ಯ ಇಸ್ ಡೈರೆಕ್ಟರ್. ನೀವಿದ್ದೀರಾ? ಬನ್ನಿ. ಎಸ್ ವಾಟ್ಸ್ ಸೊ ಪ್ರಶಾಂತ್ BR Prashant accepts notice for respondent 2 and 3, 1 HCGP. Why is the Advocate General waiting?
29th, madam.
Oh, 11, ಒಂದೇ ನಿಮಿಷ ಆಯ್ತು.
Here for the petitioner. Petition seeking mandamus to.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
I'll file my objections in this one. ಕೊಟ್ಟಿದ್ದಾರೆ copy.
Let there be an.
Representation consider.
Representation.
They claim that the land is not acquired.
Land is not acquired, my lord. May I?
ಅದೇ ಆಯ್ತು,
may I
ಒಂದ್
point
ನಿಮಿಷ.
out?
The land is not acquired, but we have shown site numbers in our layout plan for his land. So obtain.
ಯಾಕೆ ಆನ್ ಮಾಡಿಲ್ಲ ಮೈಕ್ ಆನ್ ಮಾಡಿ?
He says his land has not been acquired. And it is his case that we have wrongly shown site numbers for his land, even though it's not acquired in our layout plan.
It has been left.
So
out
even
from
for
acquisition.
consideration, you want to
I
file
just want to
objections?
say-
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ.
Section, they have passed section 11.
16th,
order.
yes.
Award,
List on 16th,
16th.
objections if any by then.
please, read.
ಸಾಕಲ್ಲ?
Read.
Yes.
29.
10 weeks they have taken to file
Our
objection.
objection is ready.
Till
my lord.
date, neither the.
Main matter,
ಕೊಡ್ತಾ ಇಲ್ಲ.
main matter itself can be, we are ready, madam. On
Neither
Monday or
KDB
Tuesday, it can be argued, madam.
One minute.
Objections ಕೊಡಿ.
But neither KDB nor state, they have not filed objection.
ಆಯ್ತು,
till date.
ಬರುತ್ತೆ ತಾಳಿ.
ನೋಡಿ sir.
10 weeks ಆಗೋಗಿದ್ಯಾ?
ಹೌದು 19/6/25 ಹಾಕಿದೆ.
Challenging what?
Challenging notification of the KDB 28/4, they have issued 28/4, one by one, stage by stage. In the year
Stage by stage.
28/1
ಯಾವಾಗ,
to
ಯಾವ ವರ್ಷದ್ದು?
24.
24 ದ. ನೀವು ಇದ್ದೀರಾ ಸರ್?
ಇಲ್ಲ ಇಲ್ಲ.
Same acquisition?
Different acquisition, madam. Different notification.
I shall explain it how, what is the difference.
ಆಯ್ತು, we'll take it later then. ನಿಮ್ದು. ಈಗ ನಿಮ್ದು objections ಹಾಕಿದ್ದೀರಾ?
Objection JP ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದ್ಸತಿ ನೋಡಿ.
ಒಂದ್ಸ್ ಎಷ್ಟ್ ಸರ್ತಿ ಬೇಕಾದ್ರೆ ನೋಡಿ.
Meanwhile, from the day one, my request is not to precipitate the matter because the way in which these.
ಒಂದ್ ನಿಮಿಷ, ಡೇ 1 ಇಂದ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್.
ಹೌದು ಕೇಳಿದ್ದೀನಿ ನಾನು.
ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಒನ್ ವೀಕ್ ಅಂತ ತೆಗೆದುಕೊಂಡು ಇವತ್ತು 10 ವಾರ
ಆಯ್ತು. ಈಗ ಡೇ 1 ಇಂದ ಕೊಟ್ಟಿಲ್ಲ, ಈಗ ಡೇ 10 ಅಲ್ಲಿ ಕೊಡ್ತೀವಾ?
ಈಗ now the reason is now all of a sudden one aspect is they will change the RTC's one aspect. Number two is now as
court is not that powerless to undo things.
it is power, it has got from earth to sky power, but once when they do it, it is very difficult again.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. They have done it, ನೀವು ಅಲ್ಲೇ ಹೋಗಿ ಅಂತೇನು ಹೇಳಲ್ಲ. Subject
Next week, any date, it can be heard, madam.
9th ಆಗ್ಬೋದಾ?
Please, madam.
9th ಆಗತ್ತಾ?
9th ಆಗ್ಬೋದು.
Tuesday. ಶಿವಪ್ರಕಾಶ್ ಸರ್?
Tuesday election petition is there. May I kindly request on 16th, madam? May I kindly request?
16th ತೊಂದ್ರೆ ಇಲ್ಲ. 16th. ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡಿ.
Date fixed ಅದು.
ಆಯ್ತು ಸರ್, ತೊಂದ್ರೆ ಇಲ್ಲ.
Copy ಕೊಡಿ.
The learned Advocate General, the advocate, heard the learned counsel M. Shivaprakash and the learned Advocate General representing the board, alla?
Board, madam.
One specifically, I asked the Advocate
This
General
matter only.
present.
33.
To be present.
33,
Yes.
33.
So and so, heard so and so. List the matter on 16. The learned counsel Pradeep Kumar hands over the statement of objections to the counsel for the petitioner. The same be filed before the registry. List the matter on 16th, rejoinder if any by then.
Please, madam.
Yes. 16th. Yes.
Please, madam.
16. Yes. 33 ಕರೆದಾಗ ಹೇಳಿ.
Please.
Petitioner, my lords.
It was
Challenging
powered
the-
by judgment.
Against them, against you?
ಅಲ್ಲ, against powered by judgment.
ಕೊಡಿ.
ನೋಡಿ.
ಸಿ ರಾಮಕೃಷ್ಣ.
ಇದು 29 ಇದು 2006 ಅಲ್ಲಿ ಆಗಿದೆ.
Because
2002
award is
ನಲ್ಲಿ
being
award.
passed in the year 2018, my lords. I will
Totally.
pass on our judgment, my lords. Preliminary notification 97.
97.
Final notification 2002.
ಅದು ಓಲ್ಡ್ ಇದು.
ಕೇಳ್ತಿರೋದು ಏನ್ ನಿಮ್ ಪ್ರೇಯರ್ ಏನು?
Quashing the acquisition.
ವಾಷಿಂಗ್ ಅಕ್ವಿಸಿಷನ್.
ಓಹೋ.
Belated award. The award is passed in the year 2018, my lords.
2002 acquisition.
Yes, my lord. Final notification.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ 97 ಪ್ರಿಲಿಮಿನರಿ.
ಚಾಲೆಂಜ್ ಈಗ ಅವಾರ್ಡ್ ಪಾಸ್ ಆಗಿರ್ಲಿಲ್ವಾ?
Passed in the year 2018, my lords.
Petition
General
filed-
award ಮಾತ್ರ 2006 ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ಪೆಟಿಷನ್ ಇನ್ 2025. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ ಹಾಕೋಂಗಿದ್ರೆ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ.
Covered by judgment because similar petition, my lords, is-
ಅಲ್ಲ ಇದು
ಕೊಡಿ,
provided,
ಯಾವ್ದದು?
29 ಬರೋದಿಲ್ಲ.
ಗಿವ್ ಸರ್.
ಅದೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇದಾ
ಅಲ್ಲ ನಂದು ಅದು 29
RSM
ಬರೋದಿಲ್ಲ.
ಡಿವಿಷನ್ ಬೆಂಚ್.
Yes, my lord, 6819 of 17. So spas me, my lords, ಎರಡು ಸತಿ ಅದಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ. One is on dated 4th February 2022, ಇನ್ನೊಂದು ಬಂದ್ಬಿಟ್ಟು 2020 ಅಲ್ಲಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇದು
2020 ಅಲ್ಲಿ ಆಗಿದೆ.
2002 is a final notification.
ಅದಾಯ್ತು, ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್.
ಅಲ್ಲ
ಡಿವಿಷನ್ ಬೆಂಚ್.
ಇದು 2018 ಇಂದ ಎಫೆಕ್ಟ್ ಆಗಿರೋದು 29.
29 ಪ್ರಶ್ನೆ ಅಲ್ಲ. Have you seen this? ಯಾವುದು? ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ ಸರ್.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. ನಾನು ಕೊಟ್ಟಿಲ್ಲ.
Supreme Court also has confirmed it.
Confirmed it.
ಕಷ್ಟ. We'll quash it next time. Entire notification.
Email interim stay, maybe.
9th.
Email entry.
9th 4 ದಿನ. ಇಲ್ಲಿವರೆಗೂ ಆಗಿಲ್ಲ ಏನ. ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ರಾಮಕೃಷ್ಣ ಅವ್ರೆ.
ಆಯ್ತು.
ಎಸ್, ಅವ್ರಿಗೆಲ್ಲ ಒಂದು ಕಾಪಿ ಕೊಡಿ. All the whole thing, yes.
31.
Private learned counsel submits needful has been done office to verify the service of notice upon the private respondents. List the matter on 16th. Yes.
Please.
16th, 23rd. Yes, next.
32.
Yes, Prashant. ಏನಿದೆಲ್ಲ? Challenging what?
This is a case where, my lord, possession has been taken prior to preliminary notification. After preliminary notification, award has been passed. There's no issue. Now, in the case, the limited issue is, what is the damages to be paid between the date of taking possession till the date of the award?
Date of taking possession ಯಾವತ್ತು?
They take a possession on 22/6/2006.
Award?
21/4/2012. I'm sorry, award is 31, the date of 4-1 notification, sir. Date of 4-1 notification, 21/4/2012.
6.
21/4/2012. Possession is 6.
2012 and 6.
No, possession is
2002 na 12?
12, my lord. Date of 4-1 notification.
4-1 is 2012.
12. Award is on 31/12/2015.
ಅದು ಹೇಳಿ. 15. Yes.
15.
Then.
My lord, in the preliminary order, interim order, my lord, what has happened, the SLAO has calculated the compensation. But lord, he has awarded, not awarded.
3 years.
For 6 years. 6 to 12.
6 to 12.
6 to 12.
Yes.
Not awarded. Not, nearly after 10 years, they approached this Honorable High Court. This Honorable High Court may not directed the parties. Not kindly take me not page 82. Relevant page 88.
Yes.
There are 4 million.
Presentations.
Yes, you have to represent him. Based on this order, my lord, we are also party to this as Nigam, but the SLO, without not hearing us, without making.
Where is the impugned order?
32. Page 32. The relevant page, my lord.
Page 35,
37, the annexure
27.
37.
37.
Ali, there, my lord, the third column refers to total land value. The other one comes to solatium and additional amount interest. Well, according to the Honorable Supreme Court Balwant Singh case, 15% damage is to be paid for this interim period, only on the land value. Not, may I pass on this?
Now damages are determined at what?
On the entire amount.
Entire amount of compensation.
Entire amount of compensation.
From the date of disposition till the date of notification, where is it said land value? Compensation on the basis of land value fixed
Land.
by the reference court.
Yes.
Now the land value fixed here is on the compensation.
Yes,
Sorry,
I'll-
and the damages phase on the basis of compensation.
Well, I am coming. Kindly take page 60, my lord, 60. Call number ಒಟ್ಟು 92,11,807.
ಒಟ್ಟು
ಅಂತ್ಯದಲ್ಲಿ
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ?
one 10th column ಮೇಲೆ
Page 60,
60.
10th column.
10th column.
ಒಟ್ಟು.
92
lakh.
11,807. Because of solution 100% now, plus 12% additional amount, plus interest.
Yes, sir.
Notice also not issued.
Notice issue ಮಾಡಿಲ್ಲ first time.
My lordship,
I thought it's already issued.
my lordship, we already filed the contempt petition, my lordship, based on our writ petitions. Subsequently, only they filed the present petition, my lordship. At the meantime, my lordship, I realized some
ಕೊಡಿ.
documents, my lordship.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ನಿಮ್ಗಿನ್ನು?
Correct.
ಆಗಿದೆಯಲ್ಲ?
No.
32 ಆಗಿದೆ ಯಾಕೆ?
There.
ಜಯಕುಮಾರ್ ತಾನೆ?
Yes, my lordship.
ನೋಟಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ, notice ಆಗಿಲ್ಲ, but I filed the wakalat.
Without notice ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
Because, my lordship, we lose the land in the year of 2000, my lordship. Some lands. Their first defense, my lordship, ground is, my lordship, limitation. First document, my lordship.
No,
we
now
give a
your contention is only with regard to damages. No limitation, nothing. Yes.
In fact, they have also Millard filed a reference under section 18. That is, we are not a party there, though we are a beneficiary.
My lordship, first document, my lordship, my representation in the year of 2013.
ಇಲ್ಲೂ ಬಲವಂತ್ ಸಿಂಗ್ ಫಾಲೋ ಮಾಡ್ತಾರೆ.
Yes, my lordship. Our representation in the year of 2013, my lordship. Subsequently, SLY, it means first respondent, gave a letter from Nigam, my lordship.
Contempt ಯಾವತ್ next ಇರೋದು?
Lordship,
Contempt date and next.
fix ಆಗಿಲ್ಲ dates.
You take notice now in all these cases.
Yes, my lordship.
Learned Counsel P. Jaykumar.
PP, my lordship. Double P ಅದು.
Double P. PP Jaykumar.
Yes, yes.
Oh, yes. The Learned Counsel Double P Jaykumar accepts notice for respondents in all these cases. Up to 34 papers upon the aforesaid counsel forthwith. Yes.
No interim order.
9th ಅಷ್ಟೇ. When is the contempt? ಇನ್ನು ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
Notice ಆಗಿಲ್ಲ.
Before that we'll decide this.
Yes.
Appear for.
Senior Counsel MRC. Yes, sir, 33.
These are the lands. About 5,000 total extent of the lands has been acquired by the government by different notifications. How they have done it is, for each village, they have issued one notifications. And basically, my lords, they wanted to start the twin city, knowledge, well-being, information, innovative city as such.
Oh,
First,
you mean Queen City?
Twin city, not a twin, my lords.
Other,
twin.
that's what.
Knowledge. They wanted to start. My lords, the first submissions before my lord is, before they could go for this type of a 5,000 acres of the land as such, they may claim it that only 500 is incorporated in this.
3,000 acres.
5,200 and odd acres of the land. My lord may kindly turn to page number 255 of my writ petitions.
ಒಂದ ಎರಡ ಇರೋದು?
ಒಂದೇ ಇದೆ ಅದು, 2 ವಾಲ್ಯೂಮ್ ಹಾಕಿದ್ದೇನೆ.
ಆ ರೇಟ್ ಪೆಟಿಷನ್ಸ್
2 ವಾಲ್ಯೂಮ್ ಹಾಕಿದ್ದೇನೆ.
ಆ ರೇಟ್ ಪೆಟಿಷನ್ಸ್ ಅಂದ್ರಲ್ಲ ಅದು. Yes, sir.
Paper publication is produced there. Here, my lords, kindly see the total extent of each one, phase 1, phase 2, phase 3. It totally works out to 5,838 acres.
3,500, my lords.
3,800.
3,800.
I have got,
ಆಯ್ತು ಹೇಳಿ.
please, my lord. So when such a big extent of the land is being,
First, who are you?
my lords, I am the landowner.
Ah,
Let me be, about 5 or 6 members are there. We are the land owners of this land. Page number 51, just have a small look on the
51.
51 to, these are all the photographs.
Ah,
My lords, these are all the lands,
farmhouses.
farmhouses, coconut, arecanut, banana, and the vegetables are being grown. After different petitioners, I have produced it, and aerial view, I have produced it in the last annexures. Aerial view also I have produced it. Not that only one land or 2 lands or something like that. And the fertility of this land has been determined by the agricultural university. That certificate also I have produced it. My lords, when such a big extent of the land is being adopted, they should have a proper scheme. More than, they don't have the Twin City scheme, number 1. Number 2, the clearance from this environmental clearance, they have not obtained it. When I asked for the environmental clearance, they said that we don't have it. After giving me an endorsement, after publication of the notice, then they had given a public notice calling upon, we don't have the experts, kindly give, the experts should come and file a tender notification for the purpose of environmental clearance. Pollution Control Board has not given any clearance. Apart from this, NGT has taken a suo motu proceedings in, my lords, in para number 19 of my petitions, I have referred to it. Petitions, I have referred to it.
90.
1919. It is submitted that the National Green Tribunal Principal Bench, Delhi, has taken a suo motu proceedings in OA number so and so based upon the newspaper report, which indicates that the TJLD reservoir is containing a toxic material. The entity has pointed out.
This comes, the Tipkonali Lake comes here?
My lords, exactly. My lord has put me right questions. My lord may kindly turn to annexure V.
We can, within 3-4 days, we can file our
File 39.
Nargun sir,
And one-
objections ಹಾಕ್ಬಿಡ್ಲಿ.
Hardly, I am also more than eager, my lords. I only by taking an interim order and protecting few landlords, my lords, I am not serving the purpose of the whole acquisitions here.
I have not granted interim order.
My lords, yesterday only, day before yesterday, this matter has appeared. Therefore, my lords, formally, it is not, formally a status quo may kindly be ordered.
Nothing, he will file, they will file objections immediately. No, we don't know the dynamics.
Another thing, my lord, this is not a public entity. They don't say which is, they are the.
No, I'm not saying the public.
See, kindly see the prayer. They're seeking to challenge 386 acres of land in the final notification, which they're not the owners of the land at all.
That you take all those objections.
That's what, within any date, my lords, short date may be given, we file our objections, main matter itself can be heard.
I'll post it on 12th.
We should be able to file before that.
By then you should
We should be
serve
able
an
to file.
advance copy to them
Please,
and file it. List on 12th.
May I only persuade, my lords, may I only persuade, since Advocate General is appearing it, I have got more confidence with the government. Let the originals be brought before the court. The whole of it is on one scheme, when they are acquiring it for 5,000 acres, what are the requirements to be done? It has been decided by this court and by the Honorable Supreme Court, what are assumed. So let them not, I don't say anything. If it comes in the hands of this court, the original record, anything. If it comes in the hands of this court, the original records.
Yes. Comes.
But it will reflect. It will reflect.
Definitely.
No, let him file his objections. If necessary, we will summon the original records.
At the
On the
time of
next day.
hearing, my lord, we'll definitely place
No,
it before
if
you.
objections ಅಲ್ಲಿ if there is some ambiguity, we'll get the records. ನೀವು ನೋಡಿಲ್ಲಲ್ಲ objections ಇನ್ನು?
ನೋಡಿಲ್ಲ, objections ಗೊತ್ತು ಇಲ್ಲ.
ಅದಕ್ಕೆ.
ಆದರೆ
Yes.
ನಾವು objections ಹಾಕಿದ್ದನ್ನು, we have filed a detailed objections before the, I have not taken a ground that I have not been served or nothing. We have filed a detailed objections along with annexures to the land acquisition officer. That is
prohibited as per the 2003 notification, my lord.
We'll see.
They have taken care of that.
That zone also with great respect to the center, to the government, it has not yet been approved. The sign, please, I have gone through
File
it.
your
I have gone through it.
objections. Yeah,
I have
file it.
gone through it.
Heard the learned senior counsel M.B. Nargund appearing for the petitioner and the learned advocate general representing the respondent. The learned advocate general seeks a week's time to file statement of objections as statement of objections. List the matter on 12th objections, if any, by then.
Please, no.
Another.
ಅವತ್ತು ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ
ಬೇಡ
ಬೇಡವಾ?
ತಾವ್ ಹಿಯರ್ ಮಾಡಿದ್ರೆ
ಆಯ್ತು.
ನಮ್ಗೆಂತದ್ದು ಅಲ್ಟಿಮೇಟ್ಲಿ ಏನಾಗ್ಬೇಕು ರೈತರಿಗೆ 20,000 ಜನರನ್ನ ಅಲ್ಲಿಂದ ಹೊರಗೆ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ಸೊ ವಾಟ್ ಅಮೌಂಟ್ ಆಫ್ ಪ್ರೊಟೆಕ್ಷನ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಗಿವ್?
ನಿಮ್ ಫಾರ್ಮ್ಸ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲೇನೆ ಇದೆ.
ಅಲ್ಲೇ ಅಂದ್ರೆ
ದಿಸ್ ಈಸ್ ಇನ್ ದ
Petitioner ಗೊತ್ತಾಗಲ್ಲ.
ಬಳ್ಳಗೆರೆ ವಿಲೇಜ್ ವಿದಿನ್ ದ.
ವೇರ್ ಇಸ್ ದಟ್?
See, all these things comes near the
Nelmangla.
Hesargatta and Nelmangla belt. This is the two belts, Arkavati and the another river is there. Within this two river belt, this particular 3 villages are there. They have issued a notification for 3 villages. Virtually more than 10 notifications for the practical reason or whatever. They have issued a 10 notification, different notifications. And it has appeared in the press, my lords, it is offering is 1.6 crores, and the same land contract is being held with the owner industries for 6.5 lakhs. 5 crores.
Acquisition ಶುರು ಆಗಿಲ್ಲ ಇನ್ನು.
Swami, I am not on this. I am not on this. You are well. He knows it.
ನೀವು ಆತರ ಹೇಳ್ಬಿಟ್ರೆ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಎಸ್ ಐ ಎಂ ಅವೇರ್
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ನಾನು ಒಬ್ಬರ ಪರವಾಗಿ ಮಾತಾಡ್ತಾ ಇದ್ರು ಕೂಡ ಅಲ್ಲಿ ಆಗಿರುವಂತದ್ರ ಸಲುವಾಗಿ ಸ್ವಲ್ಪ ಕಾಳಜಿ ವಹಿಸ್ಲಿ. ಅವರು ಕೂಡ 20,000 ಜನರನ್ನ ನಾನು ಅಲ್ಲಿಂದ ಹೊರಗೆ ಹಾಕಿ ಅವ್ರಿಗೆ ಏನೂ ಕೊಡ್ಲಾರ್ದೆ ಏನ್ ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಟ್ಬಿಟ್ಟು ಜೀವನ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗ್ತದ ನನಗೆ? 20,000 ಜನ.
ಆಯ್ತು. Rhetoric versus reality. We'll see the next date.
Let us see.
Yes. There are 2 matters. I'll finish that and take the RP. Yes. Maybe another 2-3 minutes.
34.
Petition.
First time ಬರ್ತಾ ಇದೆಯಾ?
Second time ಬರ್ತಾ
Second. List the matter on 23rd. Interim order subsisting will continue to the next date of hearing. Objections, if any, by then. Next.
35.
Pradeep Kumar. Learned Counsel Pradeep Kumar is directed to accept notice for respondents 2, 3, 4 emergent notice, 1 HCGP.
In respect of same notifications, this honorable court has granted an interim order, my lord. In respect of very same notifications.
List the matter on 16th. The learned counsel for the petitioner submits in respect of the same notification interim orders. Counsel for the petitioner submits in respect of the same notification interim orders are subsisting. In the light of the said submission, what interim order? There shall be an interim order as is obtaining. Yes, next.
ಅಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಏನ್ ಗೊತ್ತಾಗ್ತಲ್ಲ ಸರ್.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬಿಫೋರ್ ಐ ಸೈನ್.
Same.
ನೋಡ್
ಅಲ್ಲ ಬೀಚ್ ಇನ್ ಕುಪ್ಪೆ ವಿಲೇಜ್, ಸೇಮ್ ವಿಲೇಜ್.
ನೋಡ್ಲಿ.
Please.
ಸೈನ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಸೈನ್ ಮಾಡಕ್ಕಷ್ಟೇ. ಶರಣ್. Covered. General order.
Annexure C.
Annexure G, page?
Annexure C. 50, my lord.
Page 15, ಅಂದೇ ಇದೆ. Yes.
Lord, in this case, Lord, first of all, order in IA was passed. No, I want to just 2 facts.
Yes.
Order in IA was passed on payment of costs.
In this case, I represent.
They have received,
Wait.
they have received the costs. Having accepted the cost, and after 1.5 months, they're filing a writ petition. They are not estopped. I'm saying they cannot, they are acquised of the rights to file this writ petition. Number 1. Number 2, my lord, once they have received the money,
without any protest. Your lordship knows, my lord, with regard to approbate and reprobate, they cannot do that. On 19/2, the order was passed on 15/2/2025, and the cost was received by the bank on 19/2/2025. Now, the only query, my lord, I cannot argue on merits. Even the wrong interpretation of judgment will not give right for a review. That's the order of the Supreme Court. Now, lordship may see the order, the review order 47 rule 1 for a minute.
So you can straight away go to Mayavati. 2013 8 SCC page 320 para 20 20.1.
Yes, my lord. No, my lord, subsequently, no, my lord, with the Supreme Court has given rendered two judgments. You can copy to the court. No, the entire order proceeds on the basis that we should have given a paper publication and proceeded with the matter.
No, more than anything, the order why it was that way is 2004 the suits are filed.
Yes.
Suit in a representative capacity then itself had been filed.
Yes.
Bringing it to everybody. 1993.
Yes.
Then 29/10/1995 regulations come. These people have retired subsequent to that. Some of them have received, some of them have not received. 2004 they institute a suit with several reliefs. See, voluntary retirement under section 29(5).
Yes.
29(5) voluntary retirement, and when you voluntarily retire, you get 5 years addition to qualifying service.
Correct.
So those 5 years addition to qualifying service, which the retirement age does not go beyond 33 years of service, is capped at 33 years.
33 years.
Correct. Few of them did not get that. So they institute a suit. In this suit, now in the representative capacity, they want to draw everyone, all and sundry, where the relief is not identical.
No.
Relief, if
sorry, my lord,
the relief, see, interpretation of pension regulations alone, no problem. Relief is different. That is the only problem which the court encountered.
Relief is identical because they have admitted in the written statement with regard to dearness allowance, saying that all these people are entitled to, but not the 5 years period. They've admitted in their.
Is the only issue before the court was with regard to addition to qualifying service or something else?
No, all these with regard to regulation 27. The benefit with regard to
regulation 27 is dearness allowance.
Dearness relief.
Yes.
And pension they are giving, and other benefits. How to compute?
So, computation is already there.
Only one submission.
Yes, sir.
By except by my lord, by pursuant to a lordship's order, the suit will have to be addressed. There are few employees. They'll be getting the benefit. Not all. All the employees who have been litigating for 20 years.
Where are they litigating?
Before this court, before this civil court, because.
No, only few of them are there.
No, not all of them are there. That is why the association has come. Retired Employees Association have come.
No,
they are the parties.
For the first time, they file an application seeking conversion of this into a representative suit.
No.
Correct. That is why paper publication was taken or whatever it is.
No, not thereafter, take orders of the court at any stage of the proceeding. They can do it. If you see Order 1 Rule 8.
Today, correct. That can at any stage be after 21 years of the institution of the suit.
But what to do, Milord? Supreme Court says you can do that. Supreme Court says they can do it. When they have given it, in fact, pension, though not with regard to on merits, Milord, I don't want to say anything. Pension is a property within the meaning of Article 38. In fact, they could have easily filed a writ petition. They have not done it.
You need not even tell the court about pension, because I am completely aware what is 29(5), what was the settlement, what is 29(9)/1995 when the regulations came. All that I am aware. That the only thing that led was not after 21 years you could bring in.
But nowhere it says, the period of limitation is prescribed.
Not the limitation.
At any stage.
And at the stage of evidence, it was said that the matter was reserved for its orders. Then it was.
No, it was not at all reserved for orders. Lordship may call for the records.
Submit the written argument submitted by both the parties. And the judge was transferred. And it was an understanding.
Judge was not there for 3 years. There was
3 years?
3 years. There was no judge. Then there was COVID. We have addressed argument. In the midst of argument, they were also about to complete. Judge got transferred. Then we started our argument. So it is not concluded. You can't say, my lord, some judge got transferred. Then we started our argument. So it is not concluded. You can't say, my lord, some judge has heard the matter. Subsequent judge cannot pass orders. We have to re-argue the matter.
Now, definitely this order has wide ramification on every pensioner.
Yes.
I can understand the problem.
No, I have got a certificate.
I think I've quoted that also in my order.
No, I have got a certificate copy of the order, court proceedings. Orders have not been reserved.
The morning, he has informed me. Unfortunately, I could not bring the file.
No, we'll hear him on another day also. You get the file. But if the matter was not reserved for orders and this application was preferred and 3 years there was no sitting, then it may.
Without any disrespect to my friend, the writ petition will have to be dismissed because they have not stated in the affidavit that they have received the amount. The cost of rupees 2,000 they have received. Having received it without protest, how can they file a writ petition? Which fact has also not been stated.
No, it's not stated here, neither argued.
Which
Well, that was not even submitted. And Ranganathan also did not tell that.
It is there. I am told that he has stated it in the written argument.
It
It is not a ground.
Not a ground is all right.
Lordship, let him verify. Once they receive the.
No, more than that, I am on this because it was said it was reserved for orders. So if the order sheets would indicate otherwise.
I will
and the
submit
judge-
the copies of the written argument submitted by the
Then
board. of the-
judge not, when did you submit the written arguments?
2018 or 19.
18, but thereafter judge changed. So, no, before COVID, 3
Right,
years.
We'll see, you get the file, we'll hear it. When is the next convenient date to you?
Any day is subject to your lordships.
I am here, you should tell me.
First week of October, Miller,
October is vacation here.
after Dasara.
After Dasara we can. We'll take it on, because I only have to hear this.
Yes.
Can we take it on 23rd October? And let not the
Hope
proceedings.
Diwali
go-
is not coming.
Huh?
Hope Diwali is not coming.
No, it's after Diwali, that's why.
Yes.
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 So let not the proceedings go on till then.
Yes.
It should not become fait accompli.
Yes.
Still submit.
Yes. Heard,
Say that status quo by the trial court so that.
that I will do. Yes. Heard the learned senior counsel, sorry, I forget the name.
Vaidyanathan. Yes.
Nice. Vaidyanathan sir.
Yes.
Yes. I heard the learned senior counsel, yes, Vaidyanathan.
Yes, Vaidyanathan.
Yes, Vaidyanathan, yes. Appearing for the petitioner. Read so and so. The issue in the list revolves around the entitlement of pension to the persons who have retired from the service of the respective banks, or of the bank, Kotak Mahindra, of the respondent bank. The few dates that are necessary to be noticed to entertain the subject review petition would be that in the banking industry, pension as a third retirement benefit was envisaged pursuant to a settlement on 29/10/1993, which fructified into a regulation on 29/10/1995. The petitioners are said to have retired from the services of the bank on voluntary retirement or otherwise. Regulation 29 of the regulations dated 29/9/2025 envisages grant of 5 years addition to qualifying service for those persons who retire on seeking voluntary retirement from the service of the bank. The petitioners are the employees who had retired from the service, sought the said benefit which was denied, and therefore they are before the concerned court. The suit was instituted in the year 2004. An application comes to be filed by these petitioners seeking conversion of the suit into a representative suit seeking permission at the hands of the concerned court in the year 2024. The said
2024, it was numbered in 2025.
2024, which comes to be numbered in the year 2025 and is allowed by payment of costs. The cost is said to have been accepted by the bank. After acceptance of the cost, it transpires that after acceptance of the cost, the bank comes before this court and in the subject petition, which comes to be ordered in favor of the bank. The learned senior counsel, Vaidyanathan, would submit that bank having accepted the costs, they cannot approbate and reprobate by challenging the order. The learned senior counsel would further submitted the observation in the course of the order that the matter was reserved for its judgment is erroneous, as the written arguments though were filed for the error has crept in the observations made in the course of the order. The observation could be the foundation for dismissal of the petition. In that light, it becomes error apparent on the face of the record as obtaining under Order 47, Rule 1 of the CPC, as interpreted by the Apex Court in the case of Kamalesh Verma versus Mayawati, 2013, 8 SCC, page 320, Code Para 20.1, 20.2. In the light of the said circumstance, I deem it appropriate to entertain the review petition, though not recalling the order at this juncture, reserving the respondent bank to file its objections. List the matter on 23rd. 23rd is okay, sir?
Any date, October.
23rd October. List the matter on 23rd October for, I have review is before me only anyway.
Yes, yes.
Yes, 23rd
Even-
October in preliminary hearing.
After- yeah.
In the light of the entertainment of the review petition, end of the review petition, the suit should not proceed further. Therefore, the further proceedings before the concerned court in the subject suit shall remain stayed.
Regarding the arguments file, your lordship may call for the records of the trial.
And the registry is directed to secure the original records in so-and-so suit by telephonic instruction to be placed before the court on the next date.
What about the papers? What about the papers? Certificate copy?
Yes, sir.
Only request, my lord.
Yes,
No,
sir.
it's not proper, but still I feel, lordship may have it around 12:30 so that I can come and go.
Whatever time you want.
12:30 PM.
Yes, sir. Whatever time you want. 12:30, 2:30.
12:30.
Yes.
Because 2:30 I saw, my lord, your lordship has given lots of permission here.
That is there. Sir. Yes. That happens in country. Yes, sir.
Much obliged.
Put up the writ petition papers also by the next date. Yes.
Respondent.
Your lordship, I beg to appear for petitioner in this matter, your lordship.
In which matter, madam?
Serial number 2, your lordship, being spoken.
Although there are many applications, madam. Problem.
Your lordship, we have filed 8 IAs in this matter, and
That is what-
in an order on IA.
We'll have
Your
to allow
lordship,
all the
we have
8
filed
applications
item number-
because LR application one day then, but the government is not entertaining. So we'll allow, which are the
Please,
applications
Lordship.
pending?
Your lordship, IA number 1 to IA number 7.
Idea nodi madam. Then all, madam, IA number 1 again order madidini. Same order, repeat in everything. All applications allowed, legal representatives applications. Yes. Pension
Your lordship,
ಎಲ್ಲ technicalities ಮಾಡ್ಕೊಂಡು ಕೂತಿದ್ದೀರಾ. Yes. Yes, madam.
Lordship, liberty may be given to amend main petition, your lordship, cost item.
You do it immediately, otherwise government will not take your request. The petitioner shall
Please, your
immediately,
lordship.
shall forthwith amend the cost title and furnish an amended cost title to the respondent state. Yes.
Please, your lordship.
Next.
Grateful, your lordship.
Number 3.
Then being spoken to.
My lord, application was dismissed. Idರಲ್ಲಿ, my lords, I had made a submission that under proviso of section 8(2) of the Arbitration Act ಕೆಳಗಡೆ, either the original or a true copy may be given. ಅದು order ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
What is that? Get back.
My lords, this writ petition.
Undertaking is going to produce the aforesaid document in the aforesaid manner, next date of hearing. Now, what has happened with this now?
The parties are settling the matter, my lords.
Finally?
Finally, my lords.
Ah.
The mediation talks are going on.
Hmm.
So even if this matter is urgent by a week or 2.
Yes, we'll take it on 16th. By then, if there is anything, you tell me.
Very
Document beka bedo noda.
Please, my lord.
Very well.
What's the matter on 16th? The learned counsel appearing for the petitioners, new petitioner,
Please, I'm for the
petitioner submits the talks of settlement between the parties are on. This is the matter on 18th.
I'm grateful, my lords.
Order still number 4, withdrawal lordship.
In terms of,
Number 5,
It's a mistake committed by the trial court in mentioning the defendant number 14, name of the defendant number 14. Minutes. The petition for 7 Rule 11 was came to be dismissed, my lord. Without,
serial number 4. Yes, Gangadhar, ಏನಿದು?
That's an application is, office objection raised by the registry regarding name of the defendant number 14C is mentioned as Madhushankar Reddy. Actually, the
Office objections overruled. Yes, ಏನ್ ಹೇಳಿ?
Lordship, 7 Rule 11 application is filed.
Reject ಆಗಿದೆಯಾ?
Rejected.
Notice. ಏನ್ suit for?
Notice is only against the R1. Suit for partition. my lord.
Partition 711 ಕಷ್ಟ.
Partition of the year 1956. Their own statement. 1956 partition. 1974 RRT proceedings. Parties were acted upon by this.
We'll see. Yes, serve on the, ಯಾರು contesting.
R1 only, R1.
Counsel for the petitioner shall serve on the contesting respondent, which who according to him is the plaintiff alone.
Yes,
The
Lord.
first respondent.
First respondent.
List on 18th,
Obliged.
19th. Yes.
serial number 6,
Second respondent in this matter.
Furnishing copies.
My lord, settlement tax was going on, my lord.
But
What?
that is one aspect of the matter. My lords may recall to my lords memory, my lords, this one matter. Lords where.
Possibility.
My lord, last week a settlement proposal was held.
ನಿಮಗೆ ಹೇಳಕ್ಕಂತೂ ಬಿಡಲ್ಲ ಅವರಿಗೆ. ಅದಕ್ಕೆ
Petitioner,
That's what my lord- my lord, as per
settlement
the-
ಬಗ್ಗೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
My lord, as
I'm a
directed-
part of the settlement. Lords,
as
some
directed
amounts
by
are
this-
there, my lords, I'll have to withdraw it,
as
lords,
directed by this
which is,
court, my lord.
the petition arises where, my lords, the learned commercial court judge has dismissed my claim, please, my lord, for the purposes of withdrawal of the amounts so deposited, my lords, as damages. I would consider as damages. No, that is challenged in this petition. My lords may dispose them, permit me to withdraw them. It's 2018, my lords, I have not received one NP of money, my lords.
NP ಅಂದ್ರೆ?
One naya paisa illa.
ನ್ಯಾಯ.
Yes.
My lord, as directed by this court, my lord, we had a meeting, my lord.
But
My
that
learned
is secondary
friend
aspect, my
also-
lords. I am not.
What, that is the main crux
No,
of
no,
the matter, my
what
lord.
let my friend say, my lords,
My
that
lord.
he is opposing this, my lords. He was given an opportunity.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇರೋದು ಮತ್ತೆ
ಈಗ
ಅವ್ರು?
objection
ಅಲ್ಲ,
ಹಾಕಿದ್ರೆ ಹಾಕಲ್ಲ.
ಅಲ್ಲ, ಇಷ್ಟು ಮಾತಾಡಿದ್ಮೇಲೆ ಅಪೋಸಿಷನ್ ಅಂತ
ಅವ್ರು
ಗೊತ್ತಾಗಿಲ್ಲ.
objection ಹಾಕೋದಿಲ್ಲ. My, one
ಇಲ್ಲ,
rupee I have not
meeting
received.
ಅವರು-
2018 onwards, I am not
ಅವರೇ ಬಂದು
receiving.
ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ 4 proposal
Participation
ಕೊಟ್ಟಿದ್ದಾರೆ.
is a different aspect. ನಮ್ಗೆ
As-
kindly
as
appreciate
directed
this.
by this
200 ರೂಪಾಯಿ
court,
ತಗೋತಾ ಇದ್ದಾರೆ. ನಾವು 120 ರೂಪಾಯಿ ಕೇಳಿದ್ರೆ
ನಾಲ್ಕು
ನಮ್ಗೆ ಕೊಟ್ಬಿಡಿ ಅಂತ.
ಇವ್ರು ಯಾಕೆ
ಕೊಟ್ರೆ-
ಕೊಡ್ ಬಂದ್ರಿ ಈಗ?
ಹಾ?
ನೀವ್ ಯಾರಿಗೆ ಮೇಡಮ್?
Right, sir. I take notice for respondent number 4, my lords.
Another opposition.
That is quite right, my lords.
ಮತ್ತೆ?
And
They,
also
they,
have to.
they themselves among, my lord, they are not willing, one of the owner is not willing to take rent, my lord. They
You are participating in the settlement talks.
Yes, my lord.
Then don't precipitate.
Not a precedent.
And
This is a different
Participate,
aspect,
my
my
lord,
lords.
my
Here,
lord. Participate,
I have
my lord.
challenged it, seeking to, I have filed this writ petition, seeking to challenge, my lords, the order amount of the, you damages and the order deposit
Last
ಮಾಡಿರೋದು.
week, my lord.
ಈಗ how
Then
can,
where is it deposited?
if not before the commercial court, they themselves are depositing
May
it.
make submission, my lord, as
Sir?
direct,
It is the amount that is to be paid to him.
Yes,
my lord, as directed by this court, my lord, as well as the learned arbitrator, my lord, the settlement talks.
it is another aspect, my lord.
My lord,
That is
they
it.
not allowing me,
ಇರ್ಲಿ
my lord.
ಸರ್, ಒಂದ್ ನಿಮಿಷ. ಅವ್ರು ಹೇಳದ್ ಬಿಡಲ್ಲ, ನೀವ್ ಹೇಳದ್ ಬಿಡಿ.
Meantime, my lord, arbitration ಅಲ್ಲಿ proceedings ನಡೀತದೆ ಸ್ವಾಮಿ. ಅವರೇ the learned friend also participated in the proceedings. He has given a suggestions. ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಂದು ಇಲ್ಲಿ ಬಂದು ಈ ತರ ರೆಂಟ್ ಬೇಕು ಅಂತ ಅವ್ರು.
ಇಲ್ಲ ರೆಂಟ್ ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು. ನಾನು 2018 ಇಂದ
ಅಲ್ಲ,
ರೆಂಟ್ ಇಲ್ವಲ್ಲ ಸ್ವಾಮಿ. ರೆಂಟ್ ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು ಅದು, which to my share.
ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ಆಗ್ತಾ ಇದೆಯೋ?
Settlement talks, ಆದ್ರೆ that is a
ಅವರೇ
different-
ಬಂದಿದ್ರು sir.
one minute. Settlement talks, my lords, will give rest, my lords,
ಮಧ್ಯಾಹ್ನ
to all.
ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. 1:30 ಆಯ್ತು. ಮಧ್ಯಾಹ್ನ ತೀರ್ಮಾನ ಮಾಡಿ.
Lords, can I request, my lords, after 2:30 minutes, I have one matter.
ಆಫ್ಟರ್ 2:30ನೇ.
I'll
2:30
come at
ಮಧ್ಯದಲ್ಲಿ ಬರಲ್ಲ ನಾನು.
3 PM ಗೆ ಬರ್ತೇನೆ ಸ್ವಾಮಿ.
My lord,
ಹೇಳಿ. All right.
2 days time, my lord, senior is.
My lords, we have also.
ಇಲ್ಲ, ಇಲ್ಲ, ನಂದು
preferred
rent
and
ಅಲ್ಲಿ-
ನೀವ್ ಯಾರು?
For respondent number 4, my lords.
Who are they? ಯಾರು? R4 ಯಾರು? ಏನು ಗೊತ್ತಿಲ್ಲದೆ
I'm
ನೋಡ್ತಾ
sorry, my
ಇದ್ದೀರಾ?
lords.
ನಿಮ್ಗೆ ಕೇಳಿ.
R4,
They challenge, they file one more.
One more writ
writ petition
petition,
is
my
filed,
lords.
my lord.
BK Nagaraj, one of the brothers ಅಷ್ಟೇ ಅವರು.
They, they
Sailing with
themselves-
you,
ಇಲ್ಲ, ಅವ್ರೇನು they are separately adjudicating, my lords. The one of the brothers is keeping his own, my lords.
They are also
Auctions
entitled for rent, my lord.
Rent,
They
my lords, and
themselves
also-
have
You
a
are also
dispute.
entitled for rent, is it?
Rent, and also they have
challenge the
filed a
different-
separate writ
separate writ
petition, my
petition.
lords. It can be tagged along.
Which
my
is
lords.
that, madam?
WD
Now
number
comes the problem. Really.
22404 of 25,
22404 of
2025.
2022.
525.
525.
Don't want rent, my lord.
ನಾಳಿದ್ದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಸ್ವಾಮಿ.
ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿ.
My lord,
ನಾಳಿದ್ದಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಸ್ವಾಮಿ.
ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕ್ತಿದ್ದೀನಿ ಸರ್.
ಅಲ್ಲ, you want the premises back, my lord. You don't want the rent, my lord.
ಇವ್ರಿಗೆ ಪ್ರಿಮೈಸಸ್ ಬೇಕು.
The premises
one of-
ಬೇಕು.
ಬೇಕು.
The
Or
premises
one of the
ಬೇಕು.
brothers, one of
ಅವ್ರಿಗೆ
the
rent
brothers.
ಬೇಕು ಅಂತ.
ಬ್ರದರ್ಸ್ ತಾನೆ, ಅದರ್ಸ್ ಅಲ್ವಲ್ಲ.
I'm also
Yes.
entitled.
Day after tomorrow.
Yeah. Let both the petitions be tagged down on copy.
Tag the
ಕೊಟ್ರೆ
petition along with
Copy
Ajay
ಕೊಟ್ರೆ
Kerala
ನಮ್ಗೆ
brother.
ಅನುಕೂಲ.
ಕೊಡ್ತೀನಿ sir.
As, 22404 of 2025. List them both day after tomorrow.
Like,
Yes, we'll resume at 2:30.
please.
ಬೆಳಗ್ಗೆ 10:00 ಒಂದು ಮೆಮೊ ಮಾಡಿದೆ 2:30 ಅಂತ ಕೊಟ್ರಿ ಮೇಲೆ ಅದು ಈ ಆಕ್ಷನ್ 6th ಫಿಕ್ಸ್ ಆಗಿದೆ ಮೇಲೆ ಆಕ್ಷನ್ ಡೇಟ್ ಅದಕ್ಕೆ 2:30
ಗೊತ್ತು ತಗೊಂಡಿಲ್ಲ 2:30 ಏನಾಯ್ತು
2:30 ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ಮೇಲೆ ಆಸ್ ಪರ್ ಸೀನಿಯರಿಟಿ ಅಂತ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಅದೊಂದು ಆಪ್ಷನ್ ಇದೆ ಮೇಡಮ್ ನೀವು ತೋರಿಸಿದ್ರಲ್ಲ ಹಿಂಗೆ.
ಹೌದು ಮೇಲೆ ನೋಟಿಫಿಕೇಶನ್
ಎಸ್
Ballots.
Waiting for the petition. So an office objection has been raised regarding maintainability of the petition. I've sought to challenge two impugned orders of the commercial court. One is in fact passed in furtherance of the other one, and as such I filed a common writ petition. To give your lordships a brief background of the matter, I suffered an arbitral award. I challenged it before the commercial court under section 34 petition. While seeking a stay, I was directed to deposit 20 crores. I deposited 20 crores in January of last year. That has been accruing interest. Subsequently, my section 34 was dismissed. I am now before this honorable court in a 37. This honorable court has directed the trial court to proceed with considering their application for withdrawal on conditions as they may deem fit.
In the 37 petition?
In the 37 petition.
All right.
It is in relation to that on page number.
Why are you here now?
The security that has been furnished is not sufficient is my case.
Oh, you are the decree holder or execution petition?
I appear for the respondent, my lord. The award is in my favor. The award was for a sum of 35 crores plus interest. My lord, the date of
what did the division bench say?
Directed the trial court to proceed on their application for withdrawal of my deposited amount. The amount I deposited while seeking a stay of the arbitral award.
All right.
And an order has been passed in relation to that. Subsequently, a modification order has been passed as well. It is in relation to that. I am before your lordships.
No, senior is appearing for you.
No, he's
I appear for the respondent.
All right, you tell me. 1 minute, promote, sir. Yes.
Of course.
No, the short point that is there for consideration is admittedly 12.6 crores has been provided in security. The amount sought to be released is 20 crores plus interest thereon. That is as per the guidance value. It is their case that the market value, of course, will be much higher, but there is no document to that effect.
So the deposit in its entirety is directed to be released.
Please.
You are before the court for that.
Please.
Yes, sir. Where is the order of the division bench?
Milords, I'll hand it over, Milords. My colleague is in court. I'll just hand it over. Milords,
Yes.
Along with a memo, kindly see the order, Milords.
2:30 ಒಂದು ಹಾಕಿದ್ವಲ್ಲ ಯಾವುದು ಇದಾದ್ಮೇಲೆ ಕರೀರಿ. Yes. Yes, tell me.
The
division bench is not on record, but it is not in dispute. They wish to file a memo, if I may just refer to that for a minute.
Yeah.
Where is the impugned order, sir?
Well, the impugned order is on page 62 of the writ petition, or rather the relevant portion of it is there on. If I may just read for your lordships.
Yes, 64.
The next question is whether 62 minutes. The next question is whether this respondent has furnished security of sufficient valuable immovable property for release of the deposit.
Original title deeds as per list of so and so for release of deposited amount.
Please, they have furnished 28 sale deeds before the trial court. Admittedly, the guidance value for that amounts only to 12.6 crores. They are seeking release of 20 crores plus because of the interest that has been added since last year. My contention is that it should at least be on the basis of 20 crores in terms of guidance value. That apart, they have of course furnished 3 indemnity bonds of each of them.
Hear you. What's the problem now?
Because that is not sufficient for release of the
That
entire
we'll
amount.
see. Yes. Yes, sir.
Milord, kindly see, Milords, the order passed by the division bench. My colleague will just hand over a copy of that memo.
Yes.
I've handed it over.
Milord, page 14, Milords, of that memo.
No, page 4.
Which memo, sir? Which memo?
So it's at page 4.
Page 4, Milords. This is the order dated 13/1/2025.
This one? Oh, this order of the division bench, yes.
Yes. Order dated 13/1/2025. So and so appears and accepts notice. Notice to so and so is dispensed with. It is agreed by counsel for parties that they shall file the written submissions. During the course of submissions, the learned counsel for the appellant states that respondent number 1 has filed execution proceedings in which warrant to attachment of the immovable property has been issued. Learned counsel for respondent number 1 states
All
that
right, with such conditions that
that amount is now well in excess of around 80 crores today. What has been deposited before the trial court is 20 crores. The trial court, Milords, says that there has to be an indemnity by the directors of the entity, which have been provided. My lords, all the three directors have provided an indemnity which will last until the matter is finally disposed of. The second,
No,
my lords,
is it adequate? Because with appropriate conditions is what is said.
appropriate
Now,
conditions, my lords.
for
The
the release,
conditions,
no, for the release of 20 crores that is already in deposit, what is that you have placed on record?
my lord, the trial court, my lords, asks us to provide two
Title
securities.
deeds of, yes.
One is the indemnities of the three directors of the entity, my lords, and all of them have provided an indemnity, my lords, which will last until the litigation attains finality. So, my lords,
Fair
if the
enough,
matter
yeah.
travels up to the Supreme Court till that time. The second, my lord, is we have deposited, my lords, title deeds of property. According to us, my lords, the market value of those properties are in excess of 36 crores. The guidance value may be lesser, but my lords, what the trial court has done is he's taken judicial notice of the fact that my lords, market value is almost significantly higher than the guidance value. So therefore, my lords, on this basis, my lords, he has said that I will accept this. And therefore, on this basis, my lords, on the basis of the indemnity that has been provided by the directors of the entity, and on the basis of the title deeds that have been filed, my lords, the original title deeds of all those properties have been deposited before the trial court. And my lords, what has therefore been ordered to be released is
Your
20.
state highways improvement project.
Yes, my lords.
Anything else, sir?
That is the short.
We'll dismiss it straight away.
That's my
No
only
ground of
submission is-
interference.
Only submission that has to be on the market value, on the guidance value, my lords.
ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಕೆಲ ಕಡೆ 2 ಲಕ್ಷ ಇದೆ, ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ 1 ಕೋಟಿ ಇದೆ. You're taking 2 lakhs. Compensation is paid. Yes. Anything, nothing else?
I'll leave it.
The petitioner is before this court, concerned court. The heard so and so. Facts in brief germane are as follows. An arbitral award comes to be passed on 5/3/2018, determining that the respondents are entitled to receive an amount of rupees 35 crore 32,47,734. A petition under section 34 of the Arbitration Conciliation Act is filed, and the challenge that is dismissed, is it?
It is dismissed, my lord.
The said challenge comes to be turned down. The matter is at large before the division bench under section 37 of the Act. The division bench, by its order dated 22, what's that date?
13/1, my lords.
13/1/2025. The division bench on 13/1/2025 passed the following order. In terms of the order of the division bench, the pendency of the appeal under section 37 of the Act would not come in the way of the respondent filing an application before the concerned court seeking withdrawal of the amount that is already in deposit, with such conditions as may deem appropriate. Before the concerned court, an application is filed by the respondent seeking withdrawal of the deposit that was made. The deposit before the concerned court as on that date was rupees 20 crores, as against the claim of the petitioner, as against the award of the arbitrator. The concerned court, by the following order, permits the amount to be withdrawn. Page 62 to 64.
Beginning at 56.
Huh?
Beginning at 56.
ಅದು ಬೇಕಾ?
I leave it.
Reasons ಅಷ್ಟೇ
Please.
ಸರ್. Yes. ಆಯ್ತು, 56 to 64 ಹಾಕಿ ಮೇಡಮ್. The concerned court details the properties that are placed in the title deeds of the properties that are placed as deposit before the concerned court in lieu of the which form the part of the title deeds is far less than the 20 crores that he is seeking to withdraw. The learned senior counsel Pramod Nair, representing the respondent, would contend that the title deeds and the indemnity bonds are placed before the concerned court, indemnifying any loss later, as well as the originals of the title deeds. The market value of the property that is so placed is far beyond 20 crores in deposit. The learned senior counsel submits
A document to that effect, if that may just be recorded.
submission. The learned senior counsel would further submit that as on today, the respondent is entitled to receive, ಎಷ್ಟು?
No, my lords, around 80 crores, my lords.
Around 80 crores. In be those submissions as they are. In the light of the order of the division bench, the concerned court has not committed any error in directing release of 20 crores that is in deposit, taking those documents, i.e. the title deeds and the indemnification of the directors, finding no error that would entail interference at the hands of this court under Article 227 of the Constitution of India. The petition stands rejected.
So great.
Deeply obliged, my lord.
Yes, next.
My lord, 9.
Maintainability again.
My lord, I'll tell your lordships why, my lord. My lord, a suit, I am the, I'll tell your lordships why, my lord. My lord, a suit, I am the judgment debtor in a suit, my lord. Suit is decreed. Lord, several contentions that are raised by me under section 47 in the execution proceedings. Lord, 3 points are raised, my lord, your lordship may kindly consider.
Foundation for that?
Application is filed, my lord, before the trial court. And the application is filed in 2021. 3 times, my lord, the judge posted for orders. Once in 23, once in 24, once in 25. Ultimately, my lord, the order comes to be passed in 20.
True, but how will that
No,
deviate the filing of an appeal under 96?
No, I have filed an appeal also.
Already
filed. Decree holder, my lord, was not a small scale industry on the date on which the decree came to be passed. The small scale industry, it may have been a small scale industry at the time when the proceedings started. But during the pendency of the suit, my lord, they sold away the proceedings, the entire company to lock, stock and barrel, my lord, to another company. And that company, my lord, they did not disclose it at all before the court. And that is the company that is now the decree holder before the executing court.
That can be arranged before the appellate court also.
No, but before the executing court, I pointed out that they have sold their interest in the property completely. They have no interest at all.
This is against the execution proceedings.
Yes, against the execution proceedings. Yes, therefore, what I am trying to tell you, it's not against the decree, my lord.
No,
so as far as
we will overrule the maintainability. Yes,
that's all. And your lordship sees, my lord,
should we take it tomorrow? There is impending urgency.
6th is the hearing before the trial court. Your lordship may just give me some breathing time, my lord, and post it immediately thereafter. It will be.
No, tomorrow I'll post it. I'm talking of tomorrow. Tomorrow in preliminary hearing.
Please, ma'am.
Yes. Heard the learned senior counsel J.L. Vishwanath appearing for the petitioner. List the matter tomorrow in preliminary hearing.
Yes. Along with the connected petition.
Which is that?
So there are 3 IAs. So I'll just.
Which is the connected petition?
I'll just review.
Got it.
They all arise from the same order.
Right. Those are already appeared before the court or
No, they're fresh.
Yet to?
Yet to.
FR or WP?
WP. FR number.
FRL you can't connect. Make it a WP and move the memo. Tomorrow anyway this will take.
Yes, very
yes. Good. 1 minute. There is one 2:30 p.m. matter. Where is that Mohammed Patel?
Yes, Your Lordship, yes. I appear for respondent number 5 board in this matter, Your Lordship.
ನೆನ್ನೆ ಇದ್ರಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಆಯ್ತು ಪಾಸ್ ಓವರ್
One submission, Your Lordship.
Make submissions, yes.
Yes.
I continue ಮಾಡಿ ಇನ್ನೊಂದು ಇತ್ತಲ್ಲ 2:30 Mahendra Gowda. Why is this at 2:30? Enter ಮಾಡಿದ್ಯಾ? Oh, is like 5 lakhs then idu pass over. Yes. Now go back to the list.
Pass over the matter. Pass over the matter.
Where is Manian sir? Outside?
No. Engage senior counsel, Lordship.
Manian is engaged senior counsel.
ಇಲ್ಲ
Pass over. ಏನಾಗಿದೆ? No, but what happened? Convened by them, all right. Tomorrow in preliminary hearing.
Interim order may be extended.
No, that, adu matra bida. Yes,
Great.
tomorrow in preliminary hearing. ಅದೇ ಫೋರ್ಸ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಆಗೋಗುತ್ತೆ.
ಇಲ್ಲ, ready.
You will not. Undertaking, Manian sir, he is here. Undertaking, Manian sir, he is here, yes. ನಿಮ್ಮನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದಾರ?
ಇಲ್ಲ.
ಅಲ್ಲ, he says senior counsel is engaged. What is this?
Can be just passed over for a few.
No, I'll take it tomorrow, not a problem at all.
That undertaking which I assure.
Yes.
My lord will stand by my assurance on that.
Yes. Let's tomorrow, preliminary hearing, yes.
Serial number 31, my lord.
ಆಯ್ತು, ಎಲ್ಲಿ 5 ಲಕ್ಷ?
There is some
ಬ್ಯಾಂಕಲ್ಲಿ ಇದೆ, ದುಡ್ಡು ಬ್ಯಾಂಕಲ್ಲೇ ಇರೋದು.
technical issue with the bank, my lord. Some network problem. Checker is not available tomorrow. He had a personal.
Oh, correct, he had, yes. All right, Monday. ಇದೇನು?
Lords, the charging of the extra taxes under the GST regime for the contracts entered into prior to 1/7/2017.
GM matter.
Lords, this tax matter, my lords.
GM RES ಅಂತ ಇದೆ.
ಹೌದಾ? ಅದು sub classification, it's purely a tax matter, my lords.
Your lordship,
Lord, there are at least 2 divisions. Lords, what happened? Your lordships had allowed the writ petitions. They complained they were not notified. Your lordships have recalled the order and the matters
yes,
come up
yes,
again.
Yes.
Now there is nothing much to be done because lords, one is that mass constructions case got confirmed by the division bench. Chandrasekhar's case. Then what happened, my lords? A similar issue came up before another division bench, my lords. Even the division bench relied upon me. I just passed it on. This is the latest view expressed, my lords, which said that once there is a change of the tax regime itself, if there is a change in the tax law, then obligation is on the person who avails the services to pay the taxes. Lord, this was a situation where the provisions where the Service Tax Act was considered. There was a change of regime in 2012.
ಹಿಯರ್ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ
ಅವ್ರು ಹಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಹಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಏನ್ ಹೇಳಿ?
Statement of objections ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. 2 ದಿವಸ ಟೈಮ್. Because in the last occasion, the review petition was restored, my lords.
ಆಯ್ತು, ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಒಕೇಶನ್ is 21st August.
Lords, I have received a
ಅವತ್ತೇ
copy.
ಹೇಳಿದ್ರೆ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಅದೇ ಆರ್ಡರ್ ಅಂತ. ಯಾಕಂದ್ರೆ this issue, my lords, is already no more disintegrates, already covered.
ಅದೇ ಆರ್ಡರ್.
Same order. Lords, mass constructions case is again reiterated in the decision, Mills, which I am now passed on Jyoti.
Which respondent you are appearing for?
For 6th and 8th, my lords. As far as KSRTC is concerned,
ಇದು
6th and 8th respondent.
ಇನ್ನು ಯಾರ್ಯಾರು ಹಿಯರ್ ಆಗಿಲ್ಲ? ನಿಮ್ನು ಹಿಯರ್ ಮಾಡಿಲ್ಲ?
2019 contract itself contemplated 18% GST.
ಅದು withdraw ಮಾಡ್ತಿದ್ರಲ್ಲ? Lords, that we are withdrawing. So far as KPT,
which was accepted by the petitioner. He has given a letter. My lord,
Whatever you want to file, you file.
statement of objection, I have already filed.
You already filed here? Whoever have not filed the objections, he is withdrawing the claim qua KPTCL.
quick KPTCL, Lords, I'm just.
The learned senior counsel D.R. Ravishankar submits that the petitioner is wanting to withdraw his claim qua the KPTCL. And files a memo to that effect. The memo reads as follows: in that light, the claim of the petitioner qua the KPTCL stands withdrawn. Yes.
Short accommodation. Short accommodation.
Whatever objections you want to file.
Liberty has sought for, because we have said that we have sought for liberty because there is a
memo, in terms of the memo.
Please,
withdrawn in terms of the memo.
Lordships.
Your lordship, I appear for respondent number 6 in this matter. My only submission is that post that Chandrasekhar's decision, I have basically recalculated and also I have filed a set of objections. And as per that, the petitioner is liable to pay some amount to me as per that calculation. So my submission, because even though it was pre-GST contract, in the pre-GST contract, there were various components relating to central excise and also the other caveat. So
ಅದೆಲ್ಲ coordinate bench consider ಮಾಡಿ ಬರದಾಗಿದೆ.
My submission,
I said I will pass the same order, but after hearing you, because it is, we'll see whatever justification you have. Okay.
Okay.
What okay?
No, I'm sorry.
Not okay.
No, I'm sorry. Okay, I'm sorry.
But I'm sorry, okay.
Sorry.
12 ಅಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ. 11, 12 ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. 12 ಸೇಮ್ ಅಲ್ಲ?
This is a memo in 12.
Memo in 12.
Yes.
Madam, ಅದು seal number 12 ಅಲ್ಲಿ memo ಬರ್ಕೊಳ್ಳಿ. Both this, we'll take it on 16th finally.
Please.
List the matter on 16th, both 10 and 11, 11 and 12. Yes. ಒಂದು ನಿಮಿಷ, ಆಮೇಲೆ ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತೀನಿ.
ಇಲ್ಲ, ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ.
All of them are represented now?
Wakalat was not accepted because the computer was not showing it is restored.
The petitioner shall serve on the counsels representing the respective departments if not already served.
Please.
ಎರಡರಲ್ಲೂ same order.
My lord, the order at annexure M, my lord, order at annexure M passed in MA.
Order at annexure M?
Annexure M, my lord, they passed in MA on 7 of 2024, wherein, my lord, the application filed by the respondents herein for against the order, challenging the order of the trial court, my lord, rejecting the application under order 39 rule 1, my lord, the MA was filed. The court has reversed that order, my lord. Correct. And we have challenged that order, my lord, saying that, my lord, the properties in question, my lord, were granted in the name of the father of the petitioners, my lord, through a registered settlement deed way back in the 1969. Suit for, my lord, partition, my lord, that has been filed by the respondent after acquiring the land, my lord, in the 2018.
And both of you maintain status quo, we'll send it back.
My lord,
no injunction in.
No, injunction.
No,
they have sought for injunction not to withdraw the compensation amount, my lord.
Oh, the compensation
amount, my lord.
That is 99% they have already withdrawn, my remaining
1% ಇದೆಯಾ?
2 lakhs and add ಇದೆ, ಅದನ್ನು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ ನಾವು ಅಂತ they are content.
2 ಲಕ್ಷ ಯಾರು ಬಿಡಿ ಸರ್? ಎಷ್ಟು ಕೋಟಿ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ 66 lakhs, man.
66 lakhs. ಒಂದೆರಡು ಬಿಡಿ.
And what has happened, my lord, way back in the year 1969 we have.
Way back ಇರ್ಲಿ, 2 lakhs ಗೆ way back ನೋಡ್ಕೊಳ್ಳೋಣ ಆಮೇಲೆ. You already withdrawn 66 lakhs?
Please, man, be able.
No doubt about that.
No doubt.
ಮತ್ತೆ ಇಂಜಂಕ್ಷನ್ ಯಾಕೆ ಬೇಕು?
Injunction, they have.
ಚಾಲೆಂಜ್ ಯಾಕೆ ಬೇಕು ಅದಕ್ಕೆ?
Challenging, my lord, now I am not able to make a further file an application, reference application for enhancement, my lord.
This will not come in the way of doing that, but you will not. One more defendant.
One more submission. My lord, they have filed an IA, my lord, to redeposit this amount, my lord. That, my lord.
ಅದ್ ನೋಡ್ ಆಮೇಲೆ subject to outcome, redeposit ಏನ್ ಬೇಡ.
Please, man.
But if you spend it, then ಹೋಯ್ತಲ್ಲ.
I don't. knowledge ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಫೈಲ್ ಮಾಡಿದಾರೆ ಏನೋ ಗೊತ್ತಿಲ್ಲ.
ಅದು ಗೊತ್ತಿಲ್ಲ. The petitioner ಬೇಡದ್ದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಅವ್ರಿಗೆ ಸುಮ್ಮನೆ.
ಇಲ್ಲ ಇಲ್ಲ.
The petitioner is before this court calling in question an order of the first appellate court by which the order that is order refusing to grant injunction is upturned and an injunction is granted in favor of the respondent in answering an application of order 39 rule 1 and 2 of the CPC. The petitioner is the defendant, the respondent plaintiff.
Yes, man.
Respondents plaintiffs. The suit is one for partition in OS 262 of 2023. An application is filed under order 39 rule 1 and 2 which is not answered by the concerned court, which leads the plaintiff to the first appellate court. The first appellate court has granted an injunction against which the petitioner defendant is before this court. The issue in the list revolves around a claim for compensation of the property that has been of the alleged joint family property that has led to acquisition. The learned counsel appearing for the respondent submits that the petitioners have already withdrawn 99.9% of 99% of the entire amount of compensation that is received and have left pittance of 2 lakhs in the account. Therefore, an order at least not to withdraw the 2 lakhs must be granted. The submission of the learned counsel for the respondent merit acceptance. The petitioner shall not withdraw the entire remaining amount that has come out of the as compensation of the land acquired. Next para. The learned counsel appearing for the petitioner submits that he must be permitted to file proceedings before the concerned the appropriate fora for seeking enhancement of the compensation. The pendency of this petition or the order that would now be granted will not come in the way of the petitioner to register his concerned civil court. With the aforesaid observation, the parties are directed to maintain status quo and till the disposal of the suit.
Even enhancement now prefer ಮಾಡಿಲ್ಲ ಅಂತ ಅವರು ಅದನ್ನ ನಾವು
ಏನು? ನೀವು
enhancement
ಮಾಡಿ.
ಅವ್ರನ್ನ
ನೀವು ಹಾಕಿ, ಹೆಂಗೋ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ, ನೀವು ಹಾಕಿ. ಎಸ್, ಅದು ಅಲ್ಲಿ ಬರ್ದ್ಬಿಡಿ ಮೇಡಮ್. So therefore the pendency of this petition or the order now directing to maintain status quo will not come in the way of both the parties seeking enhancement of compensation if they are so entitled in law.
My lords, in serial number 14, my lords. My lords, may I request for it tomorrow, my lords?
Tomorrow. Even
My
I
lords,
want it
learned
tomorrow.
ASG would like, very well.
I will take it tomorrow, yes.
Very well, ma'am.
Yes.
Learned ASG is on his legs in another court. He wanted to be
No
present
problem.
during the
Tomorrow.
dictation.
Get him
Very
tomorrow.
well.
Madam. Yes, yes.
Very well, very well. I'm grateful, my lords.
Yes, madam.
And I appear for the thing. But I have produced, my lord, additional documents. Kindly, my lord, say, page number 7 in that documents. This is, my lord, additional documents ಅಲ್ಲಿ.
ಇನ್ಯಾವ ಬ್ರಾಂಚ್ ತಗೊಂಡ್ಬಂದಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
Yes, my lord.
ಬೇರೆ ಬ್ರಾಂಚ್ ಇದೆಯಾ ಅದರಲ್ಲಿ?
ಬೇರೆ ಬ್ರಾಂಚ್ ಇದೆಯಲ್ಲ, ಅದ್ರ ಇವರಲ್ಲಿ. Additional documents, my lord, at page number 7, Kannada document, the typed copy is available at page number 7. My lord, it is Puttubairaya and Krishnamurthy, your lordship. They are the, my lord, the defendants now, respondents 7 and 8 before this honorable court in the petition.
Yes, Kantraj sir.
They have filed objections.
ಬರ್ಲಿ ಬಿಡಿ.
No, that
ನೀವು ಮಾಡಿದ್ದೀರಾ, ಅವ್ರು ಮಾಡಿದ್ರೆ ಅಂತ.
No, that Krishnamurthy is different. Yesterday, your lordship asked them to submit. Right, whether you have denied the partition of 1998.
ಎಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ. I asked some document ಕೊಡಿ ಅಂತ.
Has taken the share.
Document.
ಇಲ್ಲಿ, my lord, page, amended page, my lord, plaint is available at.
ಇಷ್ಟು ಹುಡುಕ್ತಾ ಇದ್ದೀರಾ ಅಂದ್ರೆ ಹೇಳಿಲ್ಲ ಬಿಡಿ ಎಲ್ಲೂ.
Yes. Page number 6, my lord, in rejoinder statement to the petitioner, objections.
Rejoinder statement.
Yes. On 5/8/25.
Page?
My lord, this is page number 8.
OS ಅಲ್ಲ?
Yes. OS, my lord, 431 ನಲ್ಲಿ.
ಆಯ್ತು.
ಇದರಲ್ಲಿ my brother, this is a suit filed by my brother who has been implicated in the present suit. In param number 3, in the middle, my lord, after the, your lordship, param number 3, after the demise of their LRs have continued in possession and enjoyment of the suitable property, it is submitted that during the lifetime of the father of the defendant 1 to 3 by name Chikkamalaya, and the plaintiff and dependents one so LRs.
He had 2 wives, is it?
Yes.
You are the son of?
Son of Uchaya.
First branch.
Chikmal.
First, ಅಲ್ಲಲ್ಲ.
Branch.
Puttlingaya.
ಈಗ ಬ್ರದರ್ ಇಂಪ್ಲೀಡ್ ಆಗಿರೋದು ಯಾರು?
I am, my lord, page respondent, defendant number 4, my lord, in the present suit, page 7.
In 431.
431 ನಲ್ಲಿ. And the suit settled properties in both the, my lord, suits in 1178 and 431 are one and the same.
Same social
Same suit, same survey numbers. And my brother has come on record, my lord, in 1178. Therefore, my lord, no, my lord, injury will be caused to them. Ultimately, my lord, they can contest the claim.
ಆಯ್ತು ಹೇಳಿ ಸರ್.
See, our case is on 10/4/1998 partition took place. So under that.
Why have you implemented their brother?
Yaro?
Your brother?
No. Our case is blood. His brother and this applicant also are colluded with the plaintiff. So earlier, so his brother was included at the consent of the plaintiff. Plaintiff gave a consent
to collude.
Collude.
Oh.
And now this application is filed after 12 years of filing the suit. If this application is allowed, another 5 to 10 persons are waiting for filing application for impleading.
In the queue?
Oh,
yes. ಇರ್ಲಿ ಬಿಡಿ, ಬರ್ಲಿ.
So this is filed after 12 years filing of the suit. And added to that, my lord, there is no dispute as to the properties fell to his share have not been included in the present suit on the ground that there was already, see, partition between
He's
the
denying
parties.
that.
ಇಲ್ಲ ನಾವು ಮಾಡಿಲ್ಲ, ತೋರಿಸ್ಲಿ ಅವ್ರು ಎಲ್ಲಿಂದ ತೋರಿಸ್ಲಿ, ಯಾವ ಸೂಟಲ್ಲೂ ನಮ್ಮನ್ನ ಪಾರ್ಟಿ
ಅವ್ರ ಬ್ರದರ್ ನ್ಯಾಕ್ ಪಾರ್ಟಿ ಮಾಡಿದೀನಿ.
ಇಲ್ಲ ಬ್ರದರ್ ನಮ್ಮಲ್ಲ, ವೈಸಿ ಕೃಷ್ಣಮೂರ್ತಿ ಇಸ್ ದೇರ್ ಬ್ರಾಂಚ್. ಇಲ್ಲ ಇದು ನೋಡಿ ನೀವು, ಸಿ ಇದು ಟ್ರೀ ನೋಡಿ, ಪಿಟಿಷನ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೇನೆ ನಾನು.
They are not the plaintiffs, they are defendants in the suit.
One second, please.
ಹೇಳಿ ಸರ್.
ನೋಡಿ, ಸಿ ಇವ್ರು ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು ವೈಸಿ ಕೃಷ್ಣಮೂರ್ತಿ ಮಾಡಿದ್ದಾರೆ. That is the grandson of the first wife. So we are concerned with the second wife's children and grandchildren. At no point of time we have included as parties in our suit, or they included us as parties in their suits, because there was a partition there 1998 itself. That is, see, implemented. Now we have filed the suit for partition amongst us only. That is second wife's
ಅದಕ್ಕೆ ಅವ್ರ
children.
ಬ್ರದರ್ ನ್ಯಾಕ್ ಕರ್ಕೊಂಡ್ ಬಂದ್ರಿ?
ಇಲ್ಲ ಬ್ರದರ್, ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ ನಾನು, ಫಸ್ಟ್ ಗೆ ಪ್ಲೈಂಟಿಫ್ ದೇ ಕೊಲ್ಯೂಡೆಡ್ ಅಂಡ್ ದೇ ಅಲೌಡ್.
ಎಸ್ ಸರ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
ಇಟ್ ವಾಸ್ ನಾಟ್ ಅಬ್ಜೆಕ್ಟೆಡ್ ಟು ಬೈ ದಿ ಪ್ಲೈಂಟಿಫ್ ಅಟ್ ಆಲ್.
ಪ್ರಾಬ್ಲಮ್ ಅದಲ್ಲ, ಇದು ಫಸ್ಟ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್, ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ ಪ್ರಾಬ್ಲಮ್ ಅಷ್ಟೇ.
What I would say is, kindly see, because he himself has admitted in the written statement in 431 itself, saying that earlier there was a partition and we have taken the share. And we have filed the suit between our brothers, and they are not concerned with our branch at all.
ನೀವು ಇಷ್ಟು ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
They have objected for that, that's what I.
12 years ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
12 years.
ಅಲ್ಲ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
My brother is. My brother was disputing in 2016 when they objected for mutation in respect of the partition. What they
2 ವರ್ಷ ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕದೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅಂತ ಕೇಳ್ದೆ ಅಷ್ಟೇ.
My brother has been filed
He was
suit
prosecuting.
ಇಲ್ಲ, ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದಾರಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಾವು they were litigating before the
ತಹಸೀಲ್ದಾರ್ ಇದೆ ಸರ್. ಇಲ್ಲಿ
ತಹಸೀಲ್ದಾರ್ ಮುಂದೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾ ಇತ್ತು.
ಬಿಟ್ರೆ ಸೂಟೇ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ ಇಲ್ಲಿ? ಎಸ್ ಸೂಟ್ ಎಷ್ಟಿದೆ ಹೇಳಿ?
Suit number, two suits only, now 1178
431
of 2012 and 431
of
2016.
ಎರಡು ಪಾರ್ಟಿಷನ್.
ಎರಡು partition same ಇದೆ. It may be clubbed together and disposed of.
ಅಷ್ಟೇ. Both the suits will be tried together.
No, your last may kindly see.
ಇಲ್ಲ ಅಂದ್ರೆ I will permit him to come into the suit.
No. See, your last kindly see the.
ಬಂದ ತಕ್ಷಣ ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
ಅಲ್ಲ, unconcerned, your last, see, your lordship knows blood under, see, order 1 rule 10(2), see, who are all the necessary parties.
Correct.
But I will make my submissions. Your last may kindly see
Yes,
my
sir.
statement of objections. Statement of objections filed in this writ petition, annexure R2. Page 13, in the statement of objections that we have filed.
Yes, sir.
But this is the written statement filed on behalf of the present petitioner. Your last may kindly see my
Page
Para
13.
2.
ಏನಂತ ಹೇಳಿ?
The further contents in para 3 of the plaintiff fell to their share. The
Whose written statement is this?
This is a written statement is petitioner. Petitioner is one of the parties.
431 ಅಲ್ಲ ಇದು?
The suit scheduled properties are ancestral and joint family properties. They are in joint possession and enjoyment over the scheduled properties is not denied. It is, your last may kindly similar. It is fact that, your last may kindly mark this. It is fact that during the lifetime of father of defendants.
Now, ಇದರ suit schedule property, ಈಗಿರೋ suit schedule property ಯಾವುದು?
ಬೇರೆ.
ಇಲ್ಲ
431 suit ಅಲ್ಲಿ ಯಾವ್ದು ತೋರಿಸಿ?
431 ನಲ್ಲಿ ಸೂಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು ಅವ್ರ ಶೇರಿಗೆ ಬಂದಿರ್ತಕ್ಕಂಥದ್ದು. ಇಲ್ಲಿ
ಅದರಲ್ಲಿ you are the plaintiff or defendant?
ಯಾಕಂದ್ರೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟೀಸ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ನಿಮ್ಮ ಹೆಸರು ವೈಸಿ ಕೃಷ್ಣಮೂರ್ತಿ ಅಲ್ವಾ?
ವೈಸಿ ಕೃಷ್ಣಮೂರ್ತಿ ಅವ್ರ ಬ್ರಾಂಚ್.
ನಿಮ್ಮ ಹೆಸರೇನು?
ಕೆ ಕೃಷ್ಣಮೂರ್ತಿ.
Where is the cost title in 431?
You see 431 cost title.
ಇಲ್ಲಿದೆ page number 14. Additional documents ಅಲ್ಲಿ.
ಅವ್ರ additional document ನಲ್ಲಿ ಇದೆ. Genealogical tree ನಲ್ಲಿ ಕೃಷ್ಣಮೂರ್ತಿಸ್ are different.
Page 14.
ಅದು ಹೇಳ್ತೀನಿ.
Y.C. Krishnamurthy, defendant number 3.
ಒಂದ್ ನಿಮಿಷ. ಡಿಫೆಂಡ್ ನಂಬರ್ 3 ಯಾರಿದು?
Y.C. Krishnamurthy is the son of Chikmalaya. Our branch adu. Genealogical tree may kindly be seen.
ಅಲ್ಲಿ ನೀವು ಯಾರು ಸರ್? What are your names?
Our names, Putta Bairaya, Krishnamurthy K.
ನಿನ್ನೆ ಎಲ್ಲೋ ನೀವು ಪಾರ್ಟಿ ಇದ್ದೀರಿ ಅಂತ ತೋರಿಸಿದ್ರಲ್ಲ ಅವ್ರು 431 ಅಲ್ಲಿ?
ಇಲ್ಲ.
ಇಲ್ಲಿ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
431 ಅಲ್ಲಿ ಅವ್ರ ಪಾರ್ಟಿ ಇದಾರಾ?
ಇಲ್ಲ.
431 ಅಲ್ಲಿ ಇವ್ರು ಇಲ್ಲ.
ನಿನ್ನೆ ಇದಾರೆ ಅಂದ್ರೆ?
ಅಲ್ಲಲ್ಲ ಇಲ್ಲ. ನಾವು ಅದರಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ನಮ್ಮ ಪ್ರಾಪರ್ಟೀಸ್ ಇಲ್ಲ, ನಾವು ಇಲ್ಲ.
I will just read, my lord, one page, my lord. Page number 7, my lord, kindly see. Objections filed by them, by the respondents 7 and 8. Melkanda, may I read it, my lord? Puttabairaya and Krishnamurthy are the same respondents.
Bidi sir, why did you file written statement in that?
ಅಲ್ಲ,
431 ಅಲ್ಲಿ
ಬಟ್ ಅವರು ಡಿನೈ ಮಾಡ್ತಾರೆ.
ಅದು ಬೇರೆ, ಅದು ಬಿಡಿ. 431 ಅಲ್ಲಿ you are the defendant.
Yes.
And you have filed that partition ಆಗೋಗಿದೆ ಮುಂಚೆನೆ ಎಲ್ಲ
ಆಗಿದೆ ಅಂತ ಹೇಳ್ತೀವಿ, but they are not. Your lordship, for a moment, my lord, I will read this paper and I will close it.
ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ.
ಇಲ್ಲೇ ಸೂಟು ಮುಗಿಸ್ಬಿಡ್ಬೇಡಿ.
ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖದ ಅನ್ವಯ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥಿಸುವುದೇನೆಂದರೆ, ನಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಯ ಹಕ್ಕು ಬಾಧ್ಯತೆಯ ಮತ್ತು ತಾತನವರಾದ ಚಿಕ್ಕಣ್ಣ ಬಿನ್ ಕೋಡಿ ಮಲ್ಲಯ್ಯ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ. ದಿವಂಗತ ನಮ್ಮ ತಂದೆಯವರು ಖಾತಾ ಆಂದೋಲನಾನ್ವಯ ಪಿತ್ರಾರ್ಜ ಆಸ್ತಿಯಲ್ಲಿ ಪಾವತಿ ವಾರಸುದಾರರು ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಿಕೊಳ್ಳಲು ತಮ್ಮಲ್ಲಿ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದರೆ ನಮ್ಮ ದಾಯಾದಿಗಳಿಂದ ಪುಟ್ಟಲಿಂಗಯ್ಯ, ಚಿಕ್ಕಣ್ಣ ಬಿನ್ ಹುಚ್ಚಯ್ಯ, ಚಿಕ್ಕಣ್ಣ ಬಿನ್ ಕೋಡಿ ಮಲ್ಲಯ್ಯ, ನಂಜಯ್ಯ ಬಿನ್ ಕೋಡಿ ಮಲ್ಲಯ್ಯ ಇವರುಗಳು ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡದಂತೆ ತಕರಾರು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ತತ್ಸಂಬಂಧವಾಗಿ ತಮ್ಮ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ನಂಬರ್ ಸೋ ವ್ಯಾಜ್ಯ ನಡೆಯುತ್ತಿದ್ದು ಇನ್ನೂ ಇತ್ಯರ್ಥವಾಗಿರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ನಮ್ಮ ದಾಯಾದಿಗಳಾದ ಚಿಕ್ಕಮಲ್ಲಯ್ಯ ಬಿನ್ ಹುಚ್ಚಯ್ಯ, ಚಿಕ್ಕಣ್ಣ ಬಿನ್ ಹುಚ್ಚಣ್ಣ ಹಾಗೂ ಪುಟ್ಟಲಿಂಗಯ್ಯ ಬಿನ್ ಹುಚ್ಚಣ್ಣ ಇವರು ಅನೈತಿಕವಾಗಿ ಸುಳ್ಳು ವಿಭಾಗ ಪತ್ರ ಸೃಷ್ಟಿಸಿಕೊಂಡು ಅಕ್ರಮವಾಗಿ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಯ ಹಕ್ಕು ಬದಲಾವಣೆ ಹೊಂದಲು ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಬಲ್ಲ ಮೂಲಗಳಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಆದುದರಿಂದ ತಾವುಗಳು
ಫೈಲ್ ಸೂಟ್ ನಿಮಗೆ ಬೇಕಾದ್ರೆ
ಅವ್ರು ಫೈಲ್ ಮಾಡ್ಲಿ.
ಫೈಲ್ ಸೂಟ್ ಇಫ್ ಯು ವಾಂಟ್. ಇದ್ರ ಮೇಲೆ ಯು ಫೈಲ್ ಸೂಟ್.
I am a defendant in the suit. My brother has already filed. But my request is this, my lord. Let there be a two, my lord,
club ಇಲ್ವೇ ಇಲ್ಲ. I will not. ಕ್ಲಬ್ ಇಲ್ಲ, ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ನಡೀಲಿ. ಕ್ಲಬ್ಬಿಂಗ್ ಆರ್ಡರ್ ಮಾಡೋದೇ ಇಲ್ಲ.
ಸೂಟ್ ಫೈಲ್ ಮಾಡಿ ಪಾರ್ಟಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ, ಅವರು ಇಲ್ಲಿ ಇನ್ನೊಂದು
ನಿಮಗೆ ಅದರಿಂದ ತೊಂದರೆ ಆಗಿದೆ ಅಂದ್ರೆ ಈಗ ಎರಡು both the suits will be tried by the same court but not clubbing at all. That's all the relief I can give you now.
ಎರಡು
ಕ್ಲಬ್ ಇಲ್ವೇ ಇಲ್ಲ. ನೋ ಕ್ಲಬ್.
ಕ್ಲಬ್ ಮಾಡಿಬಿಟ್ಟು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ನೋ ಕ್ಲಬ್ ಸರ್. ದೇ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಟುಗೆದರ್ ಬೈ ದಿ ಸೇಮ್ ಕೋರ್ಟ್.
ಟುಗೆದರ್ ಅಂತ
ಟುಗೆದರ್ ಅಂದ್ರೆ ಕ್ಲಬ್ಬಿಂಗ್ ಅಲ್ಲ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಅಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ ಟುಗೆದರ್ ಅಂಡ್ ಕ್ಲಬ್ಬಿಂಗ್ ಇರ್ಬೋದು. ಕ್ಲಬ್ಬಿಂಗ್ ಇಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 24. I will not pass that order at all. Yes.
With liberty to make an application for clubbing before the
ಅದು ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು.
ಅದಕ್ಕೆ
ಇದು ವಿಡ್ರಾ ಮಾಡಿ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. Learned counsel appearing for the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition and prefer an application under section 24 of the CPC seeking clubbing of the suits. A petition is disposed as withdrawn, reserving such liberty in accordance with law if available in law. Yes, ordered accordingly. Madam. ಅದು disposed, ordered accordingly. Yes. Next.
Counsel for respondent. Press time, my lord.
Press time.
Yes. Counsel for respondent. Press time, my lord.
Press time.
Yes, my lord.
No grants time.
Please.
No representation, we have the petitioner list after 4 weeks.
The matter is expected to come tomorrow before the trial.
Expected to come tomorrow.
So it's listed-
Unexpected ಆಗಿ ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದ್ಯಾ?
Alla, before the trial court, listed for tomorrow.
Trial court.
I haven't served the
Mike
copy.
ತಗೊಳ್ಳಿ ಮೇಡಮ್. Mike.
I haven't served the copy to the respondents.
What was the order earlier?
To serve the copy of
460 shares, my lord. It's a very, very short matter, my lord. I'll just point out, very short matter. Here, my lord, my sister and I were both the legal heirs.
I can definitely say it may be a short matter.
Very, very, my
You
lord.
appear, not when madam appears. Yes.
Please, my lord. Insofar as 460 shares are concerned, my lord, my sister Annapurna, she passed away. So my sister and I, another sister and I, that is Saroja and I, my lord, we were the only two legal heirs.
Oh, this probate matter. Huh?
Probate matter. So letters of administration, my lord, there's already an order by the trial court saying that yes, it can be both in our names. I say let it be in my sister's name. She passes away, my lord, subsequent to the letters of administration
Now,
being
whom are you seeking?
My lord, for petition number 1. Both of us are the legal heirs. Nobody else remains here. my lord.
What happens to Saroja?
Saroja passed away.
The only one surviving now.
Only one surviving, my lord. I file an application.
Then
my
why
lord.
did the court
My lord, may kindly see. Very, very
legal heir
peculiar
certificate
order.
ಬೇಕು ಅಂತನಾ?
Illa, legal heir certificate. My lord, if legal heir certificate ಸಿಗ್ತಾ ಇದ್ರೆ I wouldn't have gone for a PNS at all.
Correct.
My lords, may kindly see. She says that my sister's husband, one person is there, and my brother's wife is there. They also become legal heirs of Annapurna. My lord, how section 15 is very clear, my lord. We are, my lord, we are 5 sisters and one brother. Nobody else survives.
Now nobody is surviving?
Nobody, my lord.
Except this
Except
Leela
for Leela
Vaidyanathan.
Vaidyanathan before this honorable court, nobody else is there. So I go back to section 8, my lord, legal heirs of my father is only me. My lords may kindly see.
Yes, we'll dispose it.
You
Day
would
after tomorrow. Day
only
after
thing,
tomorrow.
my lord, urgency is that she's
Day after
86.
tomorrow, 81 years, I saw it.
86.
ಏನು 5 ವರ್ಷ ಆಯ್ತಾ ಹಾಕಿ?
ಇಲ್ಲ,
Come to your
81.
cost title?
81, my lord. ಇಲ್ಲ, ಇದರಲ್ಲಿ ಈ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ
ಆ ಕಾಸ್ಟ್ ಟೈಟ್ಲೇ ನೋಡಿದ್ದೆ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ 85, my lord.
85, all right. Yes.
ಈಗ 86 ಆಗಿದ್ದಾರೆ. Please, my lord.
ಆಯ್ತು.
48
48 hours ಜಾಸ್ತಿ ಆಗ್ಲಿ ಬಿಡಿ.
Only thing is, my lord, she is also suffering from dementia. State is deteriorating. That's the only thing, my lord.
Do it day after tomorrow.
Please.
We'll release it day after.
Please, grateful.
Refund of court fee, my lord's judgment.
HDFC Bank.
Para 16 of my lord's judgment. Well, once the matter is taken out, once the court has no jurisdiction and the matter is referred to arbitration, I'm entitled.
That's correct. That is section 89 and 16
Yes,
prakara.
yes. In this case, the matter which I'm referring to, it was withdrawn. My lord said, yes, they are entitled for refund. In my
So
case.
here it is withdrawn
Here it
to
is withdrawn. In my
arbitration.
case,
Here it
it
is
is-
referred under section 8.
Yes, referred under section 8.
Respondents ಕೇಳೋದೇನ್ ಬೇಡ ಅಲ್ಲ?
ಇಲ್ಲ, that is.
So that's the catch here. All right, we'll dispose this.
There are 4 matters, my lord. I'm giving the court fee.
ಕೊಡಿ ಅದು.
Obliged.
ಹಿಂದೆ ಇದಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ ಸ್ವಾಮಿ.
ಹಾ.
ಆಗ್ಲಲ್ಲ. Decisions.
ಕೊಡಿ.
Copy for the other side.
Documents.
Documents. Decision.
Commercial wise.
House.
11-1.
The defendant is producing documents.
Like, oh, order 11, rule 1, to be strictly construed.
Supreme Court ಅಲ್ಲಿ.
So, ಯಾವ್ದು sir? What is sir?
First one, page number 5, Swami. This is filed under order 8 rule 1. It is often said that procedure is the handmade justice. Procedural and technical hurdles shall not allowed.
Other hand, procedure is handmade, ಗೊತ್ತು
Lord, our High Court, at page number 8, paragraph 13 and 15.
Yes, Deva.
Both of these are not distinction on facts itself. All of these judgments, when it given it to me, first judgment is not a commercial court, not a
Commercial court ಅಲ್ಲ. Second one?
The second one, my lord, will notice that even there.
That is 2021 SC. That is commercial dispute.
ಅದರಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ಆಗಿರೋದನ್ನ ಅಲೋ ಮಾಡಿದ್ರು.
Sugandhi's decision is not a commercial dispute.
Sugandhi ಅಲ್ಲ, Sudhir Kumar.
Sudhir Kumar, that my lord has also referred. That is not, it is in my lord's decision in GSM Corporation also.
I've referred to this.
Referred to Sudhir Kumar itself, but that is also the case of a plain. And my lord has said, if a case is made out, in the case of a plain, then the written statement you can produce documents. Here is a case where the documents are available with them.
No, documents now at the stage of evidence.
Evidence stage.
Supreme Court, last one ನಾನು ಕೊಟ್ಟಿದ್ದೆ. MR Shah ಅವ್ರದ್ದು ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಾನೆ. ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟರು.
ಅದೇ ಸುಧೀರ್ ಕುಮಾರ್ ಡಿಸಿಷನ್.
ಸುಗಂಧಿಲಿ ಏನು?
Sugandhi ಅವ್ರದ್ದು.
Sugandhi is not a commercial dispute, my lord.
Then leave it.
Not.
That you forget. Then leave it.
Not.
That you forget that.
ಇದು ರೀಸೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ MR Shah ಅವ್ರದ್ದು. ಸುಧೀರ್ ಕುಮಾರ್.
ಅದು ಗೊತ್ತು.
ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಅಂದ್ರೆ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ?
Plaintiff filed.
ಕೊಟ್ಟಿರೋ ಕಾರಣ.
Invoices were left with the auditor.
Written statement.
Not then. Written statement ಅಲ್ಲಿ, when they take up a defense, then the plaintiff is entitled to produce those documents to counter the defense set up by the defendant under order 11 rule 1 C5. Yes.
ಇದರಲ್ಲಿ ನಾನು ಸುಳ್ಳು ಹೇಳಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ, ಅದು ನಮ್ಮ ಕಾರ್ಪೊರೇಟ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಇತ್ತು. I being the.
ನೀವು ಅದಕ್ಕೆ ಕಾನೂನು ನೀವು ಸುಳ್ಳು ಹೇಳ್ಕೊಂಡು ಕೊಟ್ಟರು ಅಂತ. Nothing. To be strictly construed. ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ವಾ, ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ.
ಅದಕ್ಕೆ ಮುಂದೆ ಬಂದೆ.
You can't go on producing documents at the time of evidence to counter evidence, counter that. Well, see, there are two chances of production of document. One, while filing the commercial suit, whatever documents in your possession you file. After he files the written statement, in defense to the written, to counter the defense taken in the written statement, one opportunity for you to produce.
Plaintiff.
Over.
Plaintiff.
Plaintiff.
In the event.
Over. Yes, ಅಷ್ಟೇ.
Non-defendant ಸ್ವಾಮಿ. ಅವಾಗ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. Next stage is at the time of producing my.
ಅದು ಎರಡೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಆಗೋದು ಅಂತ.
Lord, it is 7.5 year old, Lord. That is the document which is to be produced for the better settlement of the claim, Lord.
Very difficult. ಅವ್ರು accept ಮಾಡ್ಕೊಂತಾರೆ ಕೊಡ್ಲಿ ಅಂತ, but setting a precedent. Let's see. Tomorrow will pass. The Delhi High Court judgment, anyway, I'll get it. Yes.
There are two decisions of the Delhi High Court, but both will not help their case, my lord, honestly.
No, help your case.
It will help my case. I'll place
Against
those
you.
Judgments on record.
Against you, direct Delhi High Court judgment. Yes.
I'll place those decisions on record.
Tomorrow.
ಅಲ್ಲಿ 8 ಇದೆ ಸರ್. ಅಲ್ಲಿ 8 ಇದೆ.
ಇವಾಗ ನಾಳೆ 3. Yes. ನಾಳೆ ತೀರ್ಮಾನ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
2:30.
ಎಲ್ಲ kept it somewhere.
2:30.
What time you want to come, you come. Yes, we'll dictate it ಅಷ್ಟೇ. Put it to this file. ಈ file.
This is estate and my lord consequent relief of declaration.
ಎಲ್ಲ ಸೂಟ್ ಒಟ್ಟಿಗೆ ಟ್ರೈ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಒಂದು ಇದರಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ my lord, it is in the parties are my lord different and also my lord the partition suit in the initial stage, my lord. It is not yet even commencing for the evidence, my lord.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಆಗ್ಲಿ ಬಿಡಿ, ಕ್ಲಬ್ ಮಾಡಕ್ ಹೇಳ್ತಲ್ಲ. Let it be heard by the same court.
It is before the same court. my lord.
Then leave it, sir. Yes.
It is before the same court. It is not, and as I said, my lords, in their synopsis, one more suit, they themselves has filed application for clubbing and it is already been clubbed, which is not related to this. That is OS number 712 of 2020. Now this is a suit for partition by the own brothers, I mean cousin brothers of the.
What is the
defendant.
order under challenge, sir?
The annexure A, my lord, sir. The application filed for clubbing of the matter has been allowed. The defendant, the plaintiff.
Which is the other suit? Avare hakidare clubbing on.
My lordships may kindly see page number 3.
My lord, I have stated.
Page number 3
I have
of the
stated.
synopsis, my lords.
I have stated, my lord.
Second line, 23/9/2020. One Mr. Manor filed OS number 712 of 2020 before the Honorable Trial Court to declare that he is the absolute owner of the scheduled properties on the basis of the will dated so and so. That is said to have been executed by Akkanamma. The said suit was assigned to principal senior judge and Devanalli. The petitioner filed written statement in OS number 712 of 2020. Then the miscellaneous petition number 712 of 2020. Then the miscellaneous petition was filed on 19/4/2022. My lords, that has been allowed. And in view of the order passed in miscellaneous number 110 of 21, the Honorable Trial Court was pleased to club both the suits, and OS number 500 is considered as main suit.
ಅಲ್ಲ
ಅಷ್ಟೇನಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ ನಾನು
ಸ್ವಲ್ಪ
ಯಾಕಂದ್ರೆ
pass over.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ ಈ ಸೂಟ್ಗೂ ಆ ಸೂಟ್ಗಳಿಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ ನಿಮಗೆ ಸೂಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು ಏನೇನು
ಅಲ್ಲ ಸೂಟ್ ಆಗೋದಲ್ಲ, ಅದು ಮೆಲಾಡ್ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತಾರೆ ಸ್ವಲ್ಪ.
ಯಾರು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತಾರೆ?
ನಮ್ ಸೀನಿಯರ್ ಬರ್ತಾ ಇದಾರೆ. ಅದು ಅಲ್ಲ ನಾಡೋದಕ್ಕೆ ಇದಕ್ಕೆ ಹಾಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಸಾಟರ್ಡೆಗೆ.
ಕಾಮನ್ ಎವಿಡೆನ್ಸ್ ಸಿಗ್ತಾನೆ, ಮಾಡ್ಲಿ ಬಿಡಿ. ಎಸ್
ಅಲ್ಲ
ಎಸ್ ನೆಕ್ಸ್ಟ್
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ
8.
Petitioner, how my lord litigation can be abused?
Again.
And can my lord money be extorted from builders and developers is a classic case. my lord.
ಏನಾಯ್ತು ಇದು ಮತ್ತೆ?
2007 to 2010, we purchased large extent of land, my lord, and we start development near Malur. 100 plots we have made and we have sold. Now, my lord, comes interference from government. Revenue minister writes a letter to say, Allah kelsa stop madi. We come to court, the honorable court grants a stay. Then, my lord, 1 representative suits are filed, one after the other. And every case, my lord, court has granted order or refused the order. This is the 6th case where, my lord,
92 petition na?
Illa, order 1 rule 10
8.
ali. Main relief is idu Goma land, idu id land, ಆ land ಅಂತ ಹೇಳಿ. All title deeds are in my name. 2007 in the purchase ಮಾಡಿರೋದು. Now, my lord, learned judge grants an ex parte order permitting IA1, that is under order 1 rule 8. Also, my lord, dispenses with notice under section 80, grants an ex parte TI. My lord, work is going on. Half the property is fully developed. I have spent, my lord, hundreds of crores of rupees on the property. Please see the nature of the order, my lord, passed. At page 49, this is the order.
Plaintiff ಯಾರು?
Plaintiff villagers. Villagers. ಅವರು ಒಂದಷ್ಟು ಕೇಸ್ ಹಾಕ್ತಾರೆ, ಇನ್ನೊಬ್ಬರ ಹತ್ರ ವಿಲೇಜರ್ಸ್ ಅವರು ಒಂದಷ್ಟು ಕೇಸ್ ಹಾಕ್ತಾರೆ, ಇನ್ನೊಬ್ಬರ ಹತ್ರ ಕೇಸ್ ಹಾಕಿಸ್ತಾರೆ. ಐ ಗಿವನ್ ಅ ಲಿಸ್ಟ್, ಮೈ ಲಾರ್ಡ್.
ದಿಸ್ ಕೋರ್ಟ್ ಹಸ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಪಾಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಯಾವುದು? ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ದು ಐ ಗಿವ್ ಎ ಲಾರ್ಡ್ಶಿಪ್. ಇನ್ನೊಂದು ಸೂಟ್ ಅದು, ಈ ಸೂಟ್ ಇಂದಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು, ವಿಚ್ ಆರ್ಡರ್ ಇಸ್ ದಟ್? Page.
Annexure L, my lord. Kindly go to page 251, my lord. At 252, if your lordships have got the ink page number, it's 244.
244 is it?
Yeah. 243. There are two numbers, my lord.
Yeah, 251.
Admitted that some persons who are inimically disposed towards petitioner's company.
Yes.
Have
heard the learned senior counsel SS Naganand appearing for the petitioner. The petitioner is made the defendant in a suit instituted in a representative capacity by several persons. Several attempts are said to have been made by several seeking to stall the construction that is happening from the hands of the present petitioner. One such attempt was stalled by the coordinate bench of this court in writ petition 7786 of 2024, whereby the coordinate bench capturing the issue and the abuse holds as follows. Page 252. The learned senior counsel, list ಎಲ್ಲಿದೆ? List ಕೊಡ್ತೀನಿ ಇದೆಲ್ಲ.
That is not, it's there not at, your lordship will find it at
Actually,
annexure
NI,
G,
Gmail.
page 178.
178.
Or again, 170, 170.
The learned senior counsel further takes this court to the documents appended to the petition to demonstrate that several cases are filed by several persons, seek all in an attempt to stall the construction undertaken by the present petitioner. After all these proceedings comes the present suit, again instituted by the people of the village in a representative capacity. The concerned court grants an order of injunction, ex parte injunction, directing the petitioner to stop construction. Petitioner granting an injunction virtually the construction ಹೇಳಿದಾರಲ್ಲ.
ಎಲ್ಲ ಎರಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
The so and so order
2 IAs of them.
stopping construction being undertaken by the petitioner. The order prima facie is contrary to law and is trial process. ಒಬ್ಬರೇ ಇದಾರ ಇದಾರಲ್ಲ.
ಇಲ್ಲ, more than one.
Represent plaintiff ಮಾತ್ರ ಸಾಕು.
Plaintiff ಆದ್ರೆ
Represents the plaintiffs 1 to 6 and file an acknowledgement of such service by the 8th of September. List the matter on 15th in preliminary hearing.
Here further proceedings also. I don't want them to advance the case. My lord, all sorts of things happen in this case.
Injunction is stayed.
ಇಲ್ಲ, learned judge, my lord, has in one of the orders said they came and met me and tried.
Met me?
ಹೌದು, and complaint ಕೊಡ್ತೀನಿ superior judiciary ಅಂತೆಲ್ಲ ಬರ್ದಿದ್ದಾರೆ order sheet ಅಲ್ಲಿ.
One page number 244 is a separate one. Survey number 21 of a.
Tahsildar order ಗೊತ್ತದು. It's not a suit, I know. Yes. One such attempt ಅಂತ ಹೇಳಿದ್ದಷ್ಟೇ. Not by suits. ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಬೇಕಾದಷ್ಟು ಹಾಕಿದ್ದಾರೆ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ತೋರಿಸ್ಲಿಲ್ಲ ಅಷ್ಟೇ. All colored ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲ. Yes.
Further proceedings.
I'll ಬರ್ಕೊಳ್ಳಿ. The order of injunction granted, the ex parte order of injunction so granted shall remain stayed as well as further proceedings before the concerned court. List on 15th.
And in this petition also, they have not produced how they have acquired the title also.
How they have?
Acquired the title with respect to the survey number 2.
Pura? ನೋಡ್. ಅದಕ್ಕೆ 2 weeks ಅಷ್ಟೇ. 15th we'll see then.
ಎಲ್ಲಾ permission ಇದೆ. Every authority has granted.
ಹಾಗಾದ್ರೆ ಗವರ್ಮೆಂಟೇ ಹಾಕ್ಸಿರ್ಬೇಕಿದೆ. ಅಲ್ಲ, ಅದು ತಹಸೀಲ್ದಾರ್ ಆರ್ಡರ್ ಎಲ್ಲ ಇದೆ, ನೋಡ್ದೆ ನಾನು. Yes.
Petitioner lord. Suit for injunction. The trial court lord, after granting ex parte order of injunction, heard the matter on merits and allowed the application on.
ಇದು ಮತ್ತೆ ಆಮೇಲೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಾರೆ ಅನ್ಬೇಡಿ. ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಸರ್ ಇಲ್ವಾ?
ಒಂದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ನಿಮಗ ಅದು ಬರ್ದಿದ್ದು? ಸರಿ. ಹೇಳಿ ಸರ್. First appellate court has reversed it.
Reversed it.
Yes.
My submission.
What is wrong with the order of the first appellate?
I'll point out, my lord. Kindly go to page number 56, that is the registered sale deed executed. The kata stands mutated into my name. Page number 79. Then revenue entries are made in the RTC extracts also, which I have placed on record. Kindly, now, my lord, the preceding the execution of the sale deed, the revenue entry stood in the name of my vendors. All those revenue RTC extracts I have produced at page number 105, my lord, commencing from 105. So these entries are found in the revenue entries right from the year 2011 to 2012. This is very important. Even on the date of the filing of the suit, on the date of the execution of the sale deed, the revenue entries stood in the name of my vendors. So also the entries are found.
Who are the respondents?
Respondents are claiming title in respect of altogether different property.
Altogether different
property. That is the finding.
On the strength of what?
On the strength of the sale deed executed in their favor.
Where is that sale deed?
That sale deed I have produced. 299, my lord.
299.
It is the.
Now 299 is their sale deed,
Their vendor sale deed.
Vendor sale.
Yes.
All right. That is 301 is the agreement of sale. Adu yavadu?
301, my lord. Agreement of sale, there also your lordship will find the schedule,
The agreement of sale ನಿಮಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ವಿಜಯ್ ಕುಮಾರ್.
respondents.
What is the, come to the schedule. Where is the schedule?
318. 318.
ನಾನು ಈಗ ಕೇಳಿದೆ ಸರ್ ಎಲ್ಲಿ ಅಂತ.
Hundreds.
Page 100, the schedule in the mother deed.
No, schedule of, schedule under which they are claiming. 318,
Please, my lord.
291. 291.
ವಿಜಯ್ ಕುಮಾರ್ ಯಾವ್ದಪ್ಪ ಇದು?
My lord, that is the page 322, it is started 1992 sale deed. I purchased it property.
ನೀವು ಯಾವ, on what strength are you claiming?
1992.
property.
320. 334, my lord. There are 6 sale deeds on the very same date. It is a converted land purchased under.
ಅಲ್ಲ, all right. Kalyan Basaraj
Yes,
sir
sir.
said, both the
334.
properties are different.
334.
ಅದಕ್ಕೆ which is your property?
334, my lord.
334 ಅಲ್ಲಿ ಯಾವ schedule ಯಾವುದು?
There are 2 schedules, my lord. One is A
Schedule A.
schedule and a schedule B.
ಹಾ,
Both, my lord.
ಎರಡು ನಿಮ್ದೇನಾ?
ಹೌದು.
ಆಯ್ತು.
And likewise, there are 6 sale deeds produced. Page number 337 to.
Now which is the document here? Jack Patil sir.
Please.
ಹಾ.
Kindly see page 100, my lord, first, my lord.
100. Yes.
The schedule, this is a deed which is not in dispute. Vendor for both of us, we trace it from here. Kindly go
It's
to
a
page,
common vendor.
common vendor,
Ah.
page 100,
Hmm.
item J,
Survey number 33/2.
3/2, 1 acre 12 guntas, assessment so and so, consisting of lands, 3 stone well, fencing, various kinds of tree, etc., bounded by.
Hmm.
On east, Muniappa and Chaurappa's lands, west, Papakka Desai's land, north, Aya Sahib land, on south, Mavalli Muniswami, Gottigere Shankampa's land. Now, my lord, K may kindly be seen. Also, a portion of survey number 33 situated on the high road leading to Anekal, Begur, Hobli, Kalena Grahara, 1 acre 12 guntas. In survey number 33, there are 2 items.
One is 1 acre 12 guntas.
Other is also
1 acre 12 guntas.
12 guntas. On the east, Venkatappa Shankarappa's land. On the west, Pillaya Nanjundappa's land. On the north, Channel and Muni Hanuma.
ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು?
ಅದು ಸೆಕೆಂಡ್ ಐಟಮ್, ಐಟಮ್ ಕೆ.
ಇಸ್ ಬೌಂಡೆಡ್ ಬೈ ವೆಂಕಟಪ್ಪ ಶಂಕರಪ್ಪ ಅದೆಲ್ಲ.
ಆ ಚಾನಲ್ ಅಂತ ಚೌಲ್ಟ್ರಿ ಅಂಡ್ ಚಾನಲ್ ಇದೆಯಲ್ಲ,
ಅದು ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡ್ರು.
Your lordship may kindly go to that sale deed. It is at boundary is at page 292. Sale deed starts at 284.
Yes.
292 ದಲ್ಲಿ east by Venkatappa and Sitappa's land, west by Pillaya and Nanjundappa's land, north by Channel and Muniswamappa's land, south by Choultry Inam lands bearing survey number 34. ಇದೀಗ 100 ನಲ್ಲಿ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ at least 2 items.
ಪಿಳ್ಳಯ್ಯ ನಂಜುಂಡಪ್ಪ ಎಸ್ ಒಂದು, ಚೌಲ್ಟ್ರಿ ಇನಾಮ್ 2,
And the channel.
Same, except that channel, everything else is there.
ಅಲ್ಲಲ್ಲ, ಚಾನಲ್ ಇದೆ. ಇವರು ಟೈಪಿಂಗ್ ನಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಅದನ್ನ ನಾರ್ತ್ ಬೈ ತನ್ವೆಲ್ ಅಂತ ಹೇಳಿ ಹೊಡೆದಿದಾರಲ್ಲ, ದಟ್ಸ್ ಎ ಮಿಸ್ಟೇಕ್. ಚಾನಲ್.
So they are claiming on this. ಈಗ ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವುದು?
ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು
33/2 earlier one.
Item J.
Item J.
Trial court now records a finding saying there are 2 items in survey number 33. Those 2 items are different. And in view of these boundaries, prima facie, it's a case wherein The item J is not the property for which a claim could be made.
What does the first appellate court?
First appellate court says it is something disputed identity iddaga injunction ಕೊಡೋದಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ. That cannot be a reason for interference unless trial court reasonably, let us say, it points when the court points out.
So
there
it's
are
a
two
common vendor through which you purchase two different parcels of land.
ಹೌದು. Survey number 33 is yes.
Yes, sir. ಈಗ ಇನ್ನೊಂದು petition ಏನು?
ಅದು ಇನ್ನೊಬ್ಬ ಡಿಫೆಂಡೆಂಟ್ ಒಂದು ಅಪೀಲ್ ಹಾಕೊಂಡಿದ್ರು, ಸೇಮ್ ಆರ್ಡರ್ ಅವರ ಅಪೀಲ್ ಇನ್ನು ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
ನಿಮ್ದಾ?
For respondent number 1 and 2, my lord.
Hmm.
We derived the title.
ಅದು ಯಾರ್ದು ಅದು defendant?
No, one ನಿಮಿಷ, Vijay Kumar.
Yes, my lord.
You have a dispute, this is the sale deed of yours?
That is we are disputing, my lord. First sale deed.
ನಿಮ್ದು ಅದನ್ನೇ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Because, my lord,
ಯಾಕೆ?
Inam's abolition, this is a Inam village.
ಹೌದು.
The Inam village.
ಚೌಲ್ಟ್ರಿ
my lord,
ನಾಮ್
is a-
ಬರೋದಲ್ಲೇ.
Yes, my lord. The land has been vested with the government. Total land has been vested with the government. Once vested with the government, the persons who are in possession or who are interested persons has to file an application under section 3 of the Inam's abolition.
Just one moment. Where is the impugned order, sir? First appellate court's order.
Please. ಅದರಲ್ಲಿ your lordship may kindly go to para 16, page 41. According to plaintiffs, their vendors have acquired the suit schedule property from their ancestors by name so and so on 12/1/1948. In this regard, plaintiffs have produced the copy of the sale deed of 8/1/1948 executed by Rahmat Jan and so in favor of G. Chalora Shetty in respect of item 1 to 5. It is noticed that item number 3 in the said sale deed consists of sub-items, annexures, items A to K. The item number J is survey number 33/2 measuring 1 acre 12 guntas. Item number K is in survey number 33 measuring 1 acre 12 guntas. Item J and K are mentioned with separate and different boundaries.
Correct.
Item number A to I are not descriptive boundaries. Plaintiffs pleaded that their vendors have sold them item number J to them. It is the same or different. Except RTC extracts survey number 33/2 from 2011-12 to 23-24 standing in the name of vendors of the plaintiff. Plaintiffs have not produced the old RTC extracts and the revenue records like Akar Band Tippani to bring out total measurement of survey number 33 and about 40 of original survey number 33. However, appellants have produced the Tippani of 33/2 and report of special Tahsildar abolition of Inams, wherein it is noticed that 33/2 is measuring 1 acre 12 guntas and Bhagyamma is ordered to be registered as Kadim tenant under section 4 of Inams Abolition Act. Admittedly, order of special Tahsildar for abolition of Inams has not been challenged by respondent number 1. Further, it is noticed that sale deed dated so and so is it is recited that item number 3 properties have been purchased from one PG D'Souza under the sale deed dated 19/5/46 by the vendors of Chalora Shetty. Said
ಈಗ
sale deed
one
is
moment, sir. ಈಗ ನೀವು ಆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ.
ಹೌದು.
That is J.
ಹೌದು.
Item number J. Item number J, whatever you want to do, K ಅವ್ರದ್ದು K ಅಲ್ಲಿರ್ಲಿ.
Injunction ಕೊಟ್ಟಿರೋದೇ item number J ಗೆ.
Lords, I wanted to say this. Lords, they claim to have purchased a certain property.
ಇಲ್ಲ ನಿಮ್ದಕ್ಕೆ ಅವ್ರು ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ.
The question of, Lords, this is a suit for bare injunction.
Correct.
Now, the manner in which the suit is proceeding is to find out, the manner in which the suit is proceeding is to find out as to whether I have title to the property, he has title to the property, whether his title is different, my title is different, my boundaries. It's a suit for injunction until and unless, Lords, there is a clarity about the manner in which the suit is framed, or that there is a complex question which requires to be looked into. Question of granting an injunction would not arise. Lords, I just wanted to say this, Lords.
ಈಗ ಇಂಜಂಕ್ಷನ್ ಇಂದ ತೊಂದರೆ ಏನಾಗ್ತಾ ಇತ್ತು?
There is only one piece of property. Physically, there is only one piece of property.
ಮತ್ತೆ ಎರಡು ತೋರಿಸ್ತಾ ಇದೆ.
That is the reason why I said physically there is only one piece of property. Lords, I'll just say this, just 3 sentences. The property in question admittedly is an Inam property, whether he claims or I claim. he claims that there was a sale of the year 12/1/1948, which has never seen the light of the day. Lords, I'll tell
He andre his vendor.
his vendor, 12/1/1948, he claims to have purchased the property. Lords, all the revenue entries after the regrant order is made was entered in the name of my vendors. Now, how revenue entries comes about in his name in the year 2011-12 is because 1989, 6/10/1989, the property is converted by my vendor, Chaurappa. After the conversion takes place, the property is assessed distinctly belongs with the municipal authorities. Presently, I have a BBMP kata for this property. Property is within the BBMP limits as of today.
The problem.
This is the problem. Now he comes 2011-12, we do not know. He says that some entry is made in the name of his vendors by virtue of which that is not correct. As a matter of fact, he gets the something like this. They will show the sale deed of 1948. Today they get the entries by using the assistant commissioner. 1 week the property is sold. By the moment the entries are changed in the name of this the plaintiff's vendors. Suit for bare injunction. Lords, ultimately, Lords, the shackles are placed on the courts to entertain the claim of this kind in a bare suit for injunction.
Andre status quo maintain agli bidi ಈಗ. ಈಗ ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
Lords, now the ಅಲ್ಲ ಈಗ
ಅದು ಯಾರು ಸರ್? Who is that? Sudden ಆಗಿ ನೀವು ಚೆಲುವರಾಯ ಶೆಟ್ಟಿ ಅಂದ್ರೆ ಯಾರು ಗೊತ್ತಾಗ್ಬೇಕು?
Lords, Gadi Chelurai Shetty is the person who is said to have sold the property on 12/1/1948.
1948.
1948. Gadi, yes. Original acquisition is by Gadi Chelurai Shetty on 12/1/1948. He is the one. Lords, now the question is this, Lords. The appellate court has not granted an order of injunction.
What has the appellate court done?
It has rejected the applications. Lords, considering that this is a suit for bare injunction, Lords, in Anathala Sudhakar's case, the Supreme Court has, in no uncertain terms, has taken the view, Lords, that wherever there is a conflicting title which is now being placed, 33/2, 33, he's got some source of title, I got some source of title. This is not a question which would be gone into, Lords, by the trial
Suit
court.
is of the year 2025.
Yes.
Direction to decide the suit also kashta.
3 days after the mutation entry 2025, Lords, the sale deed is entered into. Kindly have, Lords, this is a place where there is an existing industry. Lords, may kindly see the memo of documents filed on 28th August 2025, which was also placed before the trial court. Lords, there was one earlier dispute, Lords, between myself and third parties.
299.
That is my vendors. That suit was decreed. Kindly have a look at, Lords, this memo of
So
documents.
there is only one property.
Yes, physically there is only one property.
Specifically
I
in a
just-
sale
Lords,
deed
may
of
kindly see, Lords,
1948 at an undisputed point of time, both of us are claiming under same person.
Lords, BBMP taxes are paid. Now they want to claim revenue existence of a property in BBMP limits. Lords, it's a property where there is an industry. Kindly have a look at page number 251.
Yes,
Correct
society
ಆಗಿದೆಯಾ?
is a-
ಇಲ್ಲ ರೀ. Page number 30, 30. Along with the documents on 28th of August 25.
ಎಲ್ಲ documents.
Memo with documents ಅಂತ ಇದೆ. ಅದೇನಾ? ಅದು. ಅದೇನಾ?
ಇದು ಇದರಲ್ಲೇ ಅದಿರೋದಲ್ಲ. My learned friend claims through ಅವರು ಚಲುವರಾಯ ಸ್ವಾಮಿ ಅವರಿಗೆ ಏನು ಸಂಬಂಧನೇ ಇಲ್ಲ, ನಮ್ಮ ವೆಂಡರೇ ಬೇರೆ, ಐಟಮೇ ಬೇರೆ ಅಂತಾರಲ್ಲ.
We are not saying that.
Let them point out from whom that property came.
I'll just take 2 minutes. I'll just take 2 minutes.
Kindly see page 284.
Lords, I'll just give 2 dates, Lords. This Gadi, this property was sold in favor of Abdul Rashid on 11/4/1956.
ನಿಮ್ಮ ವೆಂಡರ್ ಯಾರು?
Gadi Chelurai Shetty is the original propositus.
ಅಲ್ಲಿ ಎಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲಿದೆ ಅದು?
Lords, that sale deed, your lords will find that sale deed. 1948.
ನೀವು
page 100 ನಾನು ತೋರಿಸಿದ್ದು.
Page 100.
Page 100.
ಅದೇ, yes.
Lords, sale deeds prior to the date of vesting fees into insignificance the moment there is an order of regrant. Property vested free from encumbrances.
Where
in
is the order of
government.
regrant?
Please, my lords, I'll just point out the order. of
Regrant in whose favor?
Lords, in favor of my vendor Bhagyamma.
Was regranted in the favor of Chaurappa Mello, son of Bhagyamma and Mustafa.
Son of Bhagyamma.
Son of Bhagyamma. Page number 55 in that memo, my lords.
Ashte, not son of children of Bhagyamma.
Yes. Lords, Bhagyamma made an application. She had died and then Chaurappa was given with this.
Now Chaurappa sells it to you.
Yes.
I am the owner of the property, Chaurappa.
Chaurappa, you sold it to?
No, I am not sold the property. I have sold the property in the year 1953 in favor of the Kozhikode Jesuit Educational Society.
53 ಯಾವ್ದು ಬಂತೀಗ?
See, one submission, Your Honor. 8/1/1948 was the property was purchased by Kalbi Chervara HT.
ಆಯ್ತು.
The same was A to J, in item number 3 of the schedule, mentioned in the A to J, item number 3 of the schedule, mentioned in the A to J is common boundary. Common boundary is mentioned that's why is submitted before this honorable court in common boundary. State that in A to page number 15, 99. Sir, item number 3 of the scheduled property survey number 50, 51, 52, 53, 54, 58.
ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆಯಾ?
48, 49.
ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆಯಾ?
And 33/2, including there is a 35 acres of land in common boundary existing east by.
ನೀವ್ ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ?
No, I am not sold the property.
You have not sold.
Is purchasing the property from Rehmat Shah.
Lord, society sells it to Bhagyamma under the registered sale deed dated 5/3/1958.
My mother is purchasing the property.
Bhagyamma purchased the property.
After vesting the property.
ಅಲ್ಲ ಆಮೇಲೆ ರೀಗ್ರಾಂಟ್ ಆಗಿದ್ದು ಭಾಗ್ಯಮ್ಮ.
Bhagyamma's son.
In favor of
My son.
Bhagyamma's son.
All right.
I filed an application before the special.
ಆಯ್ತು.
Same was granted in the.
All right. ಆಮೇಲೆ
A scheduled property, not A to J.
ಓನ್ಲಿ ಎ ಶೆಡ್ಯೂಲ್.
K scheduled property.
K scheduled property.
A scheduled property and K scheduled property one and the same.
All right.
I filed an application before the special deputy commissioner in 56 of 71. The same was granted in the name of the Chaurappa. After announcement issued on 16/7/1958 in the name of the Chaurappa. After the Khata was affected in even registered number,
ಇದು suit for declaration or injunction?
Injunction suit. Then just two facts after that. Chaurappa gets a conversion of the property on 6/10/1989. Deputy Commissioner initiates suo motu proceedings regarding the validity of the conversion order. Deputy Commissioner conducts an inquiry and says the conversion is valid. Under a sale deed of 26/2/1992, it's a registered sale deed under which the property has been sold in favor of Pradeep Pisha, that is the present respondents, before your lordships.
Petitioners ಯಾರು ಮತ್ತೆ?
Pardon me, lords. The petitioners say, before your lordships.
Petitioners ಯಾರು ಮತ್ತೆ?
Pardon me, lords. The petitioners say, lords, how they are claiming title to the property is, lords, I'll just.
1948 sale.
1948 sale deed.
On the basis of 1948 sale deed, the Ladi Chervara HT filed an application before the special deputy tahsildar to effect the Khata in the name of.
ಇರಿ ಸರ್, ಎಲ್ಲ ಗಾಳಿಲಿ ಹೋಗ್ತಾ ಇದೆ.
Lords, 1948 sale deed. The Gadi Chalurai Shetty's legal representatives is said to have sold the property in favor of the plaintiffs
ಕೆಲಸ ಮಾಡಿ ಇಬ್ರು ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ.
Lords, I prepared a synopsis.
ಕೊಡಿ, ಅದಕ್ಕೆ ಕರೆಕ್ಟ್ ಆಗಿ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ, ಅದಕ್ಕೇನು ಇಂಜಂಕ್ಷನ್ ಏನ್ ಬೇಕು ಹಾಕಿದ್ರೆ ಆಲ್ರೆಡಿ. ಆಯ್ತು, ಮಂಡೇ ಇಲ್ದರೆ ದಿಸ್ ವಿಲ್ ಗೋ ಅಂಟಿಲ್ ದಿ ಈವ್ನಿಂಗ್. ಎಸ್. ಗೌತಮ್,
unreasoned order, ex parte order.
230 ಮೂವ್ ಮಾಡಿದ್ದೇನಾ?
ಇಲ್ಲ
ಇದು ಬೇರೆ.
ಯಾವಾಗಲೂ ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೆಲ್ಲ ಮೂವ್ ಮಾಡಿದ್ದೆ.
Authorized officer?
ಇಲ್ಲ authorized officer ಅಲ್ಲ, my lord, we are my lord, developing a solar project. Government, my lord, has said, my lord, given a timeline, we'll have to complete it by 5th of October. The respondent, my lord, I'm the owner of, my lord, I've taken on lease. Lease deeds are all, my lord, at page 72 and 27, page 27, if your lordship sees, my lord.
Yes.
That's a lease deed. Please come to my lord, page 66, schedule ಇದೆ. Survey number 557-2.
Where is the order of injunction?
Order of injunction, my lord, please come to my lord, running page 154. 159 ಅಲ್ಲಿ dispensation, my lord, order 39 rule 3 says urgency ಇದೆ. ನಾವು neighbors. The injunction is granted, say Cart Road ಇದೆ ಅಂತ ಹೇಳಿ. Cart Road, my lord, I have produced, my lord, the village map.
There is no Cart Road?
Nothing, my lord, please here, my lord, take this.
ಅಲ್ಲ Cart Road ಇದ್ರೆ ನಿಮ್ಗೆ permission ಯಾರು ಕೊಡ್ತಾರೆ ಸೋಲಾರ್
ಎಲ್ಲೂ
ಪ್ಲಾಂಟ್
ಇಲ್ಲ.
ಆಗಕ್ಕೆ?
We are, my lord, 557 ಇಲ್ಲಿ. There is no Cart Road, nothing.
557.
ಹೌದು. ಇಲ್ಲಿ ಕೆಳಗಡೆ ಮಧ್ಯದಲ್ಲಿ ಬರ್ದು
ಅದೇ ಮಧ್ಯದಲ್ಲಿದೆ 557.
ಕರೆಕ್ಟ್. ಅಲ್ಲಿ ಕಾರ್ಟ್ ರೋಡ್ ಅಲ್ಲಿ, my lord, the whole idea is we are, my lord, within 1 month, my lord, we'll have to complete it.
The petitioner is the defendant in a suit in OS 474 of 2025. Here, who are the petition plaintiffs?
Plaintiffs are, my lord, the neighboring owners.
Neighboring owners. Neighboring land owners are institute a suit in OS 474 of 2025. And the ex parte order of injunction of stopping of all work is granted by the concerned court.
My lord, it's not all work, my lord. Not to interfere with the, my lord, their
Not,
property.
an order is granted not to interfere with the cart road that
And
is said to be existing in schedule C property. The learned senior counsel has produced a sketch of the property to buttress his submission that there is no cart road passing in survey number survey number ಅದು
ಹೌದು ಸ್ವಾಮಿ.
557 ಅಲ್ಲ survey number what sir?
557
557.
ಅದರಲ್ಲಿ ಸಬ್ ನಂಬರ್ ಗಳೆಲ್ಲ ಇದೆ, ಯಾವ್ದ್ರಲ್ಲೂ ಕಾರ್ಟ್ ರೋಡ್.
Even otherwise, an order of ex parte injunction which grants the final relief is granted by the concerned court. In that light, the order dated so and so shall remain stayed. Petitioner to serve on the counsel who represents the defendants and file an acknowledgement of such service by the 8th list on 15th in plenary hearing.
ಆಯ್ತು, ಅವ್ರು ಎಲ್ಲರ ಮೇಲೂ ಸರ್ವ್ ಮಾಡಿ, ಡಿಫೆಂಡೆಂಟ್ ಒನ್ ಮಾತ್ರ ಸರ್ವ್ ಆಗಿದೆ.
No, on the counsels.
ಅಲ್ಲಿ ಒಬ್ಬರು ಮಾತ್ರ ಇರೋದು, ಬೇರೆಯವರಿಗೆಲ್ಲ ಬೇರೆಯವ್ರ ಮೇಲೆ ಆರ್ ಆಲ್.
ಅಲ್ಲ, whoever is contesting
Very well,
defendant.
very well.
On the defendant/contesting defendants. Yes.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ನೀವೇ ಫರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋ ಸಾಹೇಬ್.
ಅಲ್ಲ,
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಬೇಕಾದ್ರೆ
on
ತಗೊಳ್ತೀವಿ.
the counsel, hand summons on ತಗೊಳ್ಳಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Serve by way of hand summons ಅಂತ.
Correct.
Yes.
ಯಾಕಂದ್ರೆ
Better than the counsel
ಹೌದು,
serving. Okay. In terms of memo.
Lord, the petitioners filed a suit for partition along with, sorry. The petitioners filed suit for partition along with 2 applications for seeking for temporary injunction. Lord, the trial court.
Partial temporary injunction ends. What is that you want?
Lord, now.
Plaintiff, sorry. Petitioners are plaintiffs who institute suit in OS 1594 of 2025 seeking partition and separate possession. They also file an application under Order 39 Rule.
2 applications, I had 2 and 3.
2 applications under Order 39 Rule 1 and 2 seeking a direction to the defendants or direction to injunct the defendants from alienating the property as they were all
And
suit schedule
not
property.
to change the kata, the other eye.
ಎಲ್ಲ ಒಂದೇ ತರ. Yes,
Change
so
the
and
kata
so.
again is the
And
corresponding number.
madam, 2 applications are filed in this suit under Order 39 Rule 1 and 2. One seeking an injunction against the respondent defendants not to alienate the property and not to change the revenue entries. The concerned court has only issued notice and therefore the petitioners are before this court. In the light of the properties being suit schedule properties, the proceedings before the concerned court should not be frustrated. Therefore, the defendants shall not alienate the property or change the revenue entries of the property till the next date of hearing. The petitioners shall serve the defendants by way of hand summons and file an acknowledgement of such service by the 10th, list the matter on 17th in plenary. Next.
Petitioner, madam, this is in
execution petition, my lord, the petitioner has filed application for treating him as an obstructor and also to inquire his title regarding the
ಈಗ
suit
ರಿಜೆಕ್ಟ್
schedule
ಮಾಡಿದಾರ
property. ಅಲ್ಲ ಏನು ಮಾಡಿಲ್ಲ
ಏನು ಮಾಡಿಲ್ಲ.
just they have received the application and they have proceeded to issue commissioner warrant for execution of the sale deed.
Who are you?
I am the owner of the scheduled
What was the
property
suit
is the
for?
joint family property. my
Suit
lord.
for partition.
ಇಲ್ಲ suit for specific performance, my lord, was filed by the respondent number 1 against respondents other respondents, my lord. That suit was decreed and it was confirmed by this honorable court.
Who are you?
I am the co-sharer in the property, my lord. I have filed a separate
Yes, let it be.
ಮತ್ತೇನು?
Nothing wrong.
When my applications are issued, my lord, it has
Suit
to
is
be,
for specific performance.
suit is for specific performance.
ಅಷ್ಟೇನಾ?
In that, my lord, I have filed an application stating that I have already filed a suit for partition and separate possession of my share. That is under consideration. In the
When was
meanwhile,
it,
my lord,
when was the decree in specific performance?
it was
Date.
my lord, on 31/1/2022, my lord.
When did you file suit for partition?
That was filed, my lord, in 1 second. 1/4/2025.
Anything else? Cost impose ಮಾಡ್ತೀನಿ.
When
I will impose dismiss it with cost. 3 ವರ್ಷ ಆದ್ಮೇಲೆ partition suit ಹಾಕಿ decree 2022 ಅಲ್ಲಿ want to frustrate the decree now and object or ಬೇರೆ. How much cost?
My
Share,
share is
your share determine ಆಗ್ಲಿ. There is already a decree preceding your institution of suit. To defeat that specific performance decree, you have filed this partition and wants to get into this also. Anything else? ಅಷ್ಟೇ. ಕಾಸ್ಟ್ ಎಷ್ಟು ಅಂತ?
ಅಲ್ಲ,
1 ಲಕ್ಷ ಹಾಕ್ಲಾ?
I am rightly filed an application for obstruction.
Rightly ಅಲ್ಲ, ulterior motive.
No, I am one of the
Partition
co-sharer.
ತೀರ್ಮಾನ ಆಗ್ಲಿ ಸರ್. ಆಗ್ಲೇ ಡಿಕ್ರಿ ಆಗಿರೋ ಸೂಟಲ್ಲಿ ಆಮೇಲೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಿ ಯು ವಾಂಟ್ ಟು ಗೋ ಬ್ಯಾಕ್ ಅಂಡ್ ಪುಟ್ ದ ಕ್ಲಾಕ್ ಬ್ಯಾಕ್. Go back and put the clock back. ಅಷ್ಟೇ ಅಲ್ಲ, dismissed. 50,000 ಕಾಸ್ಟ್.
ನಾನು ಏನು ಹೇಳಲ್ಲ, ಪಾರ್ಟಿ ತೊಟ್ಟರು ನಾವು ಹಾಕಿದ್ವಿ. My thing is that, my lord, I am rightly prosecuting the.
You will always be right. ತೊಂದ್ರೆ.
Because in the execution, when they have come to know that execution is filed.
Oh, correct.
Wherein, my lord, I have filed this application for.
To frustrate this
obstructor and-
specific performance decree, somebody has set you up ಅಷ್ಟೇ, ಬೇರೆ ಏನು?
When I have already filed a suit for partition.
Already ಅನ್ಬೇಡಿ, after that I have filed.
Of course.
Yes. ಏನು?
Lordship, may I kindly come to page number 147, my lords. Challenging this sale deed, we approached the Honorable Trial Court at Annexure L, my lords, page number 147. Your lordship may kindly
Declaration why?
to cancel the sale deed, my lords. Cancellation.
What date of sale deed?
Date of sale deed 23/8/2024, my lords. The first executant, that is Vaida Khanam. My lord, date of her death is 6/4/2024.
6/4/2024.
After her death, this sale deed has been executed.
6/4, date of death?
Date of death is 6/4/2024.
Sale deed date ಹೇಳಿಸಿ.
Sale date 23/8/2024.
Where is the sale deed?
My lord, at page 147, Annexure L.
127.
147, my lord, pardon.
ಯಾರಿದು? ವಹೀದಾ ಖಾನಂ.
Vaida Khanam. Death certificate, lordship. May I just pass on?
Sold in favor of?
Sold in favor of one Ibrahim Khan, my lords.
Who is he?
He himself is a GPA holder. It is self-registered sale deed, my lords. Colluded with the sub-registrar.
The petitioner. Who are you all?
We are the legal heirs of one Yusuf Ali Khan, my lords.
Who is Yusuf Ali Khan?
In favor of whom this honorable court has granted the rights, my lord. The page number, your lordship may come to rights, my lord. The page number, your lordship may come to Annexure G, my lords.
Page?
Annexure G, page 88.
88.
97, my lord, sorry, 97.
ಏನಿದೆ ಅಲ್ಲಿ? Granted what?
Occupancy right was granted in favor of third persons, my lord. That was challenged in,
So it is restored to your name
yes, my lords.
of the same property.
Same property. There are survey numbers from 59 to 60 for 65, my lord.
Petitioners are the plaintiffs. 9th July 2019. The property which they are seeking declaration of is said to have been sold by one Wahida Kannum in favor of the GPA holder of Wahida Kannum. The sale deed is registered on 23/8/2024. Wahida Kannum, who had executed the power of attorney, dies on 6/4/2024. Therefore, on the death of the power of attorney, on the death of the executant of the power of attorney, it is tried that the power of attorney itself gets diluted or extinguished. The sale deed on the said strength, that too to the general power of attorney holder by a person who was not even alive on the said date, casts a suspicion upon the execution of the sale deed. In that light, the petitioners sought cancellation of the sale deed. In the said suit, seek an injunction directing not to alienate the property, not to alienate the suit schedule property. The said order is not granted, therefore the petitioners are before this court. In the light of the aforesaid reasons, there shall be an injunction as was sought before the concerned court till the next date of hearing. Lest the matter 8th, same other 8th serve 15th. Yes, next.
For the petitioner, my lord. The suit for permanent injunction challenging the order of court, my lord, order 8 rule 1A for I am the plaintiff, my lord. Defendant is seeking to produce certain documents. Kindly see page number 34, my lord.
Commercial OS?
No, my lord. It's a permanent injunction, my lord. Plaintiff is in the US. This is the affidavit, my lord. He says that some sale deed, he changes the number, CTS number. He says that the sale deeds are with the Can Finance Home Limited, please, my lord.
Can Homes.
That's what, even I thereafter I filed one application under 379 of CRPC, perjury to take action, and also an application notice to produce that particular loan documents. Neither he has produced that loan documents, nor he has done that. In fact, against that 379 application, my lord, if I may pass on,
The petitioner to serve on the counsel who represents the respondent in the trial proceedings. Same 8th, 15th, further proceedings shall remain stayed.
Please,
Yes. You are not in Malleshwaram?
my lord, I am very well in possession of the property, but they are land grabbers, my lord.
Yes,
They're
no
trying
problem.
because
Yes.
he's not in the country, my lord.
You didn't get it. I said you are not in Malleshwaram.
No, I am not in.
Yes.
ಒಬ್ರು ಯಾರೋ caveat ಹಾಕಿದ್ದಾರೆ
Caveat
ಅಂತ
ಇದ್ದಾರೆ?
serve ಮಾಡಿದ್ದೇನೆ.
ಗಿರಿಧರ್ ಸರ್ವ್ ಮಾಡಿದ್ರ?
ಹೌದು, ಸರ್ವ್ ಮಾಡಿ ಅವ್ರು ಬೆಳಿ
ಅರ್ಜೆನ್ಸಿ ಉಂಟಾ? ಓವರ್ ನೈಟ್ ಅರ್ಜೆನ್ಸಿ?
ನಾಳೆಗೆ ಹಾಕೊಂಡು
ನಾಳೆ ಬೆಳಗ್ಗೆ ಹಾಕಿ.
ಆಯ್ತು ಆಯ್ತು, ಖಂಡಿತ.
Because caveat ಇದೆ ಅಂತ ಅಷ್ಟೇ.
ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಪ್ಲೀಸ್.
List tomorrow and preliminary ಆಗ್ತಲ್ಲ ಮೇಡಮ್?
ಫ್ರೆಶ್ ಲಿಸ್ಟ್ ಎಲ್ಲ
Fresh.
ಪ್ಲೀಸ್.
Preliminary hearing tomorrow.
ವೆರಿ ಗ್ರೇಟ್ಫುಲ್.
ಇಲ್ಲ ನಾಳೆ ಹಿಯರ್ ಮಾಡಿಲ್ಲ ಅಂತ.
No, I will also not be. It will not be fair for me also to say all that.
Because 2:30 move ಮಾಡಿದ್ರೆ they are not expected to be here.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಒಂದು ಮೆನ್ಷನ್ ಮಾಡೋದ್ರಿಂದ ಡಸಂಟ್.
ಆದ್ರೂ but yes.
ಆದ್ರೂ ಐ ಅಗ್ರಿ ಮಾಡಿ.
Yes.
ಎಂಟೈರ್ಲಿ.
Case I for the petition. There is an order, my lord, passed by this honorable court, my lord.
2:30 ಮೂವ್ ಮಾಡಿದ್ ಯಾಕೆ?
ಮಾಡಿದ್ ಯಾಕೆ ಅಂತಂದ್ರೆ
ಅದೇ ಯಾಕೆ?
ಅದೇ ಪ್ರಾಪರ್ಟಿನ ಈ ಆಪ್ಷನ್ ನಲ್ಲಿ ನಾಡ್ದು 6th ಗೆ ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. There is already an order passed by this honorable court. It is to their knowledge also. ಹೌದು ಸ್ವಾಮಿ, ಇದ್ರೊಳಗೆ
Your colleague is
annexure
it?
J, yes, my colleague.
Your colleague?
Yes, ma'am.
ಇದನ್ನೇ ತೋರಿಸಿದ್ರು ಅವ್ರ
ಹೌದು,
ಬ್ಯಾಗ್.
annexure J.
ಹಾ.
ಇದನ್ನೇ ತೋರಿಸಿ. ಇದ್ರೊಳಗೆ it is at serial number 23 and 24. These are the two properties that I am in possession. ಅವ್ರದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಇದೆ, ಅದನ್ನು ಕಾಪಿನ along with the application ಹಾಕಿದೀನಿ.
ಆಯ್ತು.
There is an order.
Today
Only item
morning,
number
my lord.
23 and 24.
ಆಯ್ತು, ಆಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ರ ಆಮೇಲೆ.
My lord, sir. Okay, my lord, see, 8th ಇದೆ auction.
List the matter on 8th in preliminary hearing. Wait, but hours 2015 da.
Yes, my lord.
List the matter on 9th in preliminary hearing. The
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಇದು ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇತ್ತು.
ಅದೇ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇರ್ಲಿ ಬಿಡಿ. Yes.
ಅಲ್ಲ, this are booked on an earlier occasion as said that 38D ಪ್ರಕಾರ this may be included under section 38B.
38D.
Since the division 38D of the BD Act. Since the division bench is matter is pending before the division bench, court said that we will await for that. That is the reason why
ಈಗ
matter could not be
38D
taken.
ಬೇಕು ಅಂದ್ರೆ ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. They will
38D
consider that, till then they will not auction your property, that's all.
They shall not auction the property. I am in possession also. That
ಇವತ್ತು
is what.
ತೊಂದ್ರೆ ಇಲ್ಲ, 38D ಆರ್ಡರ್ ಬೇಕಾದ್ರೆ ಇವಾಗ್ಲೇ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲ 38D ನಾನು ಕೇಳ್ತಾ ಇಲ್ಲ.
ಪ್ರಾಪರ್ಟಿನೇ ಬೇಕು.
Property.
ಅಕ್ವಿಸಿಷನ್ ಹೋಗ್ಬೇಕಾ?
ಹೌದು.
Yes. List the matter on 9th. The learned counsel for the petitioner apprehends that his property would be auctioned. Petitioner apprehends that his property would be auctioned, but in terms of an auction notification notified by the BDA on.
It was, my lord, it says that e-auction notification.
E-auction notification.
Commencing from
The
25/8/2025.
property of the petitioner, even if notified in the auction notification, shall not be put to auction till the next date of hearing.
Only serial number 23 and 24 items, my lord. Not
Serial-
entire.
Serial number, ಅದು ಎಲ್ಲರಿಗೂ ಕೊಡ್ಲಿಲ್ಲ ನಾನು.
23
Serial
and
number
24.
23 and 24.
Please.
23, ಅದು ಬೇಡ ಮೇಡಮ್. ಪ್ರಾಪರ್ಟೀಸ್ ಕರೆಕ್ಟ್, ಮುಂಚೆ ಆಗಿದ್ದು ಆರ್ಡರ್ ಸರಿ ಇದೆ. ಎಸ್, ಅವ್ರದ್ದು ಮಾತ್ರ.
Please, my lord, see, survey number is not in the auction notification.
ಪೆಟಿಷನ್ ಅಲ್ಲಿ
Petition ಅಲ್ಲಿ survey number ಇದೆ. Auction notification ಅಲ್ಲಿ site numbers ಇರುತ್ತೆ, ಅದು
C603, 601 and 603.
match. Order may be uploaded today itself, my lord. I just
ನಾಳೆ
can.
6th ಇರೋದು ಆಕ್ಷನ್.
No, 7, 8th ಇದೆ.
6th.
ಮಂಡೇ
Yes,
ಈ
ನಾಳೆ
property
ಕೊಡ್-
6th ಇದೆ.
ನಾಳೆ ಮಾಡು.
yes, much.
Extension for general fair.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
My lord is completed 14 years and my lords.
ಪ್ರಿಮೆಚೂರ್ ರಿಲೀಸ್ ಮಾಡಿದಾರಾ?
Premature, my lords have passed an order at page number 6 and operative portion at page number 10, my lord.
ಓ ದಿಸ್
Liberty.
60 days ಎಷ್ಟು ಕೊಟ್ಟಿದೆ ಅವಾಗ?
Last time 30 days, my lord.
302.
Yesterday, one matter, without surrendering the station, my lord, he is taken in parole on 60 days.
ಬಿಫೋರ್ ಸರೆಂಡರಿಂಗ್ ಕೊಟ್ಟಿರೋದು ಎಕ್ಸ್ಟೆನ್ಷನ್.
He is not surrendered.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದು. ಗೋಲ್ಗೆ ವಾಪಸ್ ಹೋಗ್ಬೇಕು ಅಂತಿಲ್ಲ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೊಟ್ರೆ.
So on premature, eligible for premature.
They are all premature release. See, eligible for premature release, ನೀವು ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದೀರಾ, ಕಮಿಟಿ ಕೂತ್ಕೊಳ್ಳಲ್ಲ. For ages together, that application will be pending before you. That is why I am granting parole. Supreme Court has granted 60 days. Next.
Deeply obliged.
Yes, madam.
Lord, there is a caveat. We have served on WhatsApp.
ನಾಳೆ.
ಆಯ್ತು.
Tomorrow. caveat ಇದ್ರೆ ಕಷ್ಟ.
ಅದೇ, therefore I pointed out the first.
Unless there's heavens falling overnight.
Matters tomorrow, that's the only difficulty.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ.
ಆಯ್ತು.
Suit for
eviction.
Tenant. You are a tenant.
I am a tenant.
ನಾಳೆ ಏನಕ್ಕಿದೆ ಕೋರ್ಟ್?
Nale, what has happened, trial court has allowed the application for marking of a GPA, which is neither stamped nor notarized.
ನಾಳೆ ಮಾಡಿ.
Nor registered. Nale.
ಇವತ್ತು ರಾತ್ರಿ ನಿಮ್ನ ಎವಿಕ್ಟ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ
ಇಲ್ಲ,
ಬೇಕಾದ್ರೆ
ಆ ತರ. My only difficulty, there is a direction that I have to deposit certain rents. I'll anyway.
ಅದು ನಾಳೆ.
Great.
ಇಷ್ಟಿದೆ. ಹಾ, ಕರೆದ್ಬಿಡಿ.
For respondent 9.
7 and 8.
Total 11 minutes.
ನಾನು 3:30 ಅಂತ ಹೇಳಿದ್ 4:30 ಆಗೋಗಿದೆ.
Please.
Date may be fixed.
We are ready.
ಎಲ್ಲಿ?
The matter had gone up to thrice before the Honorable Supreme Court. It has ended, and no right as such has been created in favor of the petitioner. No matter what have challenged, my lord, the approval given by the BDA. What is the locus standi of petitioners, my lord, to question when their right has been negatived by the Honorable Supreme Court as well as by this Honorable Court? Lordship, kindly see, my lord, the prayer.
ಏನೋ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ? ಯಾರು ಹಾಕಿದ್ದಾರೆ?
I think everyone is.
ಎಲ್ಲರೂ ಹಾಕಿದಾರ?
My lord, 94 acres was the subject matter of the tenancy before the tribunal. Then, my lord, 1970, my lord, 1997, a writ petition filed by Puttaswamy. He set aside and all the tenants were granted the occupancy right, and the said order was challenged by the owner, that is the respondents hearing.
I'll take it tomorrow. Tomorrow at 3:30.
Hearing.
I'll take it tomorrow. Tomorrow at 3:30. ನಾಳೆ ಮತ್ತೆ 3:30 ಇರಕ್ಕೆ ಹೇಳಿ. Yes. Yes, sir.
With the appeal of the petitioner, my lord, your lordship, wide order dated 28th of August, was pleased to grant a stay, my lords, wherein the further proceedings pending before the trial court were stayed. However, there's a factual error which has crept in the order, my lords. If your lordship reads the fourth line, which reads, learned counsel for the petitioner submits that a suit for partition instituted in the year 2024.
This court on 28/8/2025 has passed the following order. The learned counsel submits that there is an error crept in the first paragraph of the order, inasmuch as reference is made to the earlier resurrecting partition suit, but it was only a partition deed and not a suit.
As such, there was no contention regarding the suit being belated, my lords, on that ground.
Belated and delhi.
The next line, my lords, therefore the suit instituted.
That's all right. The paragraph now will read as follows. The learned counsel for the petitioner submits that the subject suit is in fact contrary to the partition deed of the year 1986 that is instituted and acted upon.
Yes, ma'am. Grateful. Yes. My lords, and also the TI may be extended and the notice hasn't been.
Interim order subsisting would continue to the next date of hearing.
My lords, and notice may be issued to the other respondents. My lords, lead respondent number 1 is on KVA. And
the remaining respondents be served by way of hand summons.
Grateful, my lords.
Yes, next. Are they list?
I appear for petition.
Yes, sir.
My lord, Annexure E.
File barlitade. But what he says is.
Para 22 I have explained.
Synopsis ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ? Additional synopsis.
Additional synopsis.
Further synopsis.
ಅದು
ಎಷ್ಟೊಂದು?
ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ರು ಅದನ್ನ ರೆಫರ್ ಮಾಡಿ ಹಾಕಿದ್ರು ಟು ಅಸಿಸ್ಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
Yes, sir.
ಇದರಲ್ಲಿ ಇಫ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಂಕ್ ಪೇಜ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ 8 ಅಲ್ಲಿ in the additional synopsis ಅಲ್ಲಿ.
Now, what is the order under challenge, sir?
The order under challenge is
Page.
Tribunal order.
Adhe page.
Page, in page
16.
State government. Lord, the sanction of the state government was in favor of the 6th respondent because there were 5 bidders. May I read that annexure E, in page 60, my lord, for a moment. This is dated, my lord, 17/7/2017 by the state government and subject approval of lease of land belonging to Mirza Ali Raza Waqf for a period of 30 years. As per section 17(1) of the Waqf property.
Deposit a sum of 50 lakhs, all right.
50 lakhs also. Then, my lord, the board also passed an order, annexure F, in page 63, my lord.
Yes.
What they say is the administrator in place of board was there, therefore the order passed at annexure F is not correct. That is their contention before tribunal. And also
They went before the
they
tribunal.
went before the tribunal. May I make a submission? My lord, the case before the Waqf tribunal is only as against annexure E and F by the respondent number 1 and 2.
Respond number 1 and 2 yaru?
Oh, they are strangers to the lease, my lord. They are neither.
They are interested.
Interested
No,
person which is
But
defined.
interested means, supposing, my lord, if they were participant or they were bidders, then if their bidding was not accepted, and then, my lord, they would have gone before it, they would have been justified in saying that they were interested. That is one. Then section 3K of the Work Act also, they cannot take the benefit. I have, my lord, in my further submission, because I should not forget the point, that's the reason in a written submission yesterday.
Who forget the point?
No, I should not forget. That's the reason I had made some homework. I placed before your lordship, if your lordship permits me, my lord, the second further submission, may I just, if your lordship permits me.
Yes, sir. ಹೇಳಿ.
ನಾನು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ನಾನು ನಿನ್ನೆ ಹಾಕಿದ್ದು.
Additional.
ಅಡಿಷನಲ್ ಫರ್ದರ್ ಸಬ್ಮಿಷನ್ ಅಂದ್ಬಿಟ್ಟು ಒಂದು ರೈಟಿಂಗ್ ನಲ್ಲಿ ರಿಟರ್ನ್ ಹಾಕಿದ್ದೀನಿ. Because section 3K also will not come to their aid for the reason, my lord, supposing if the right to perform a religious rite or a pious ceremony or a participation in charitable activity is obstructed, or then under only those circumstances. But section 3K will not give power to a person to interfere with the administration of the Waqf institution or Waqf. That is what I have tried to explain before your lordship in the form of a written submission. Now, my lord, the petition before the Waqf tribunal by the respondent number 1 and 2 was not for the enforcement of their personal right or public right. Then, my lord, they have not participated, they are not bidders. Then, my lord, the internal synopsis ಅಲ್ಲಿ ನಂದು
Internal synopsis.
sorry, additional synopsis ಅಲ್ಲಿ I have, my lord, they admit, my lord, they admit in para 2A of their petition before tribunal, internal page 8 for a moment, my lord. Admitted facts by the respondent number 1 and 2. They in the Waqf tribunal proceedings bearing application number 20/18, in paragraph number 2A of the respondent number first and second respondents case before Waqf tribunal in application 20/18, the respondent number 1 and 2 in the present revision petition admit that the fourth respondent therein, that is the revision petitioner, is a gazette notified Waqf wide notification number so and so of 1965. They also admit, my lord, the revision petitioner Waqf was created by Mirza Ali dedicating his property wide Waqf deed dated 6/4/53. They further admit the mutawallis to manage the revision petitioner was also appointed under the said deed of Waqf dated 6/4/53. They further admit that as per section 4 of the Waqf Act, the revision petitioner was notified under the Waqf Act 54 because the Waqf Board's notification is dated 7 June 1965. Hence, Waqf Act 1954 was in force when the revision petitioner Waqf was notified. The case of the respondent number 1 before the tribunal is not for the enforcement of their private or public right at annexure E and order at annexure F, because the respondent number 1 and 2 have not made any application before state government or before the Waqf Board for the grant of 30 years lease in their favor in respect of property of the revision petitioner Waqf. They have not responded or objected or obtained any application in response to public notice.
ನೀವು synopsis ಓದ್ಬೇಡಿ, ನಾನು ನೋಡ್ಕೊಂತೀನಿ.
Yes, my lord. So, no, my lord, for all that. And, my lord, when they have no locus standi to challenge the government order, then, my lord, how the tribunal, without appreciating these aspects of the matter,
Yes, sir.
Yes. My lord, section 83, my lord, 2 specifically says, my lord, who is
Interested
my lord, that has been defined.
ಕೊಡಿ.
And, my lord, this court as well as the Supreme Court, my lord. So, sir, madam.
May I make one submission?
ಇನ್ನು ಆಗಿಲ್ವಾ?
Just 2 points. It is not their case before tribunal that person interested, number 1. The second is, it is not their case that they are beneficiaries. They have not said anywhere in their petition.
My lord, that issue is framed, my lord, after objecting. Tribunal has framed that issue and it is answered, my lord.
I think judgment ಹೇಳಿ sir.
No, judgment, my lord, the first judgment, my lord, ILR 2000, Karnataka
ಏನಿದು?
01. My lord, who are the interested persons, my lord, has been discussed.
Para
my lord,
13. Para 13.
13, 14, as well as 18, my lord. Both, my lord, beneficiaries, who is the beneficiaries as well as the interested persons, my lord.
Ridhiyal, para 14 defines.
Yes.
The definition is.
Interested persons, my lord.
Ridhiyal, para 14 defines.
Yes.
The definition is wide enough.
Yes. In the earlier act, my lord, before amendments, your lordship may kindly come to, my lord, page 21. My lord, 1979 to SCC 468, my lord. My lord, in fact, it is the Supreme Court had gone to the extent saying that it is not narrowed down to section 3K. It has more wider than what is page, my lord, page 21. It starts, my lord, in page 21. Paragraph 32, my lord.
30?
Page paragraph 32. Page 40, my lord. ILR 1992, Karnataka 586, division bench, my lord. My lord, para 5 to 9, my lord. The judgment of the Supreme Court is extracted, and again the interested person was discussed and defined.
Yes.
My lord, page 4, my lord. Ink page 49. Sorry, ink page 49. The lordships may come, my lord, kindly see the petitioners therein, my lord.
Yes.
WAF Protection Committee, who are the applicant, and another person who is a beneficiary, my lord, in similar circumstances.
But who are you?
I am, my lord, the two applicants, my lord, before court. One is WAF Protection Action Committee. My lord, this organization is registered under Societies Registration Act. They are, my lord, basically formed for the purpose of, my lord, protecting the WAF properties. They have filed number of petitions before this court, and court said they are interested person. Second, my lord, now in the second applicant was filed it, who is the beneficiary, my lord. This is a Shia WAF. My lord, whatever income or whatever comes, my lord, it is the benefit for the Shia community. So therefore, I am interested person, my lord. In this, my lord, this court, my lord, has taken page para.
Yes. Justice Venugopal Gowda.
Yes, my lord. Para 17. Para 17. Para 17, my lord. It says that they are interested persons. My lord, these are the judgments with regard to locus standi is concerned. Now, your lordships is concerned. Now, your lordships may kindly come. My lord, the issue is whether the administrator who has appointed has a power to, my lord, sanction 30 years lease is the question which has been challenged.
That's all.
That is the question. My lord, your lordships may kindly see the administrator order, my lord, for a moment. Next year, Andre, page 1 and that. Lord, this is the data in my lord, Act of 27 of 13 to the WAF Act. The existing Karnataka WAF rules has to be amended suitably as per WAF Amendment Act 2013. The government of Karnataka has constituted an advisory committee to draft a new WAF Amendment Rules 2016, which will have to be vested with the Parliamentary Affairs and Legislative Department and has to be placed before both the houses, which will consume time for finalizing the draft Karnataka WAF Amendment Rules 2016. Till the composition of regular WAF board, it is decided to appoint administrator for day-to-day affairs, my lord, may kindly mark, of the administration of the board for a period of 6 months from the date of expiry of the present term of the board, that is from 28/2016 till further orders. My lord, next page is, my lord, the again extension for 6 months. My lord, the entire scheme of the act, my lord, doesn't prescribe, my lord, a provision wherein the power is enumerated to the state government to appoint an administrator when expiry terms there. Now, my lord, they say that under section 99 they have a power. Section 99 with regard to supersession of the board, my lord. During the term of the board, during the term of the board, my lord, if there is any default committed by the board, or there is a misappropriation, or there is no direction, my lord, followed by the board, then, my lord, after giving notice, my lord, it is a penal provision. An administrator can be appointed. but there is no provision under the act which
That,
says
that you have not challenged.
that we have not challenged. Lord,
So
that-
don't
that-
mention about
yes,
that. How the administrator comes in, you have not challenged
my lord,
and
only
cannot
to-
be challenged there.
Yes.
That's all right.
To
Now it is,
emphasize-
it is
to em-
only with regard to the, whether the administrator could have granted lease for 30 years or not.
Yes.
That's all.
Yes.
Yes.
Now, why?
According to you, it's the government which should have been, which should
Yes.
have granted.
No,
That-
my lord.
Then,
It has to be done by the board with
Yes.
two-third majority.
yes, board, madam.
It has to be, my lord,
Section-
that I
Your
will point
lordship.
out the some provisions.
Ah.
The provisions. my
Your
lord.
lord,
Sanction of the board, it has to go to the government. I will point out with the
No, no.
provisions. My lord. My lord, let me
Page,
complete. My lord,
page,
yes.
one minute.
Yes,
Tahir,
in,
one
in
minute.
annexure B, annexure E.
Page
ink
60,
page
your lordship.
60.
ಈಗ ABCD ಆಗೋಯ್ತು ಎಲ್ಲಿದೆ ಹೇಳಿ?
Sorry. Ink page 60, my
60,
lord.
your lordship.
Ink page 60 of my revision papers. It is the state government.
Administrator is not granted.
Administrators, I'll show it, I'll point it out.
Annexure F subsequent passed by
Secretary to
the
government.
state government. We are directly on the government order.
Then, my lord, my case is better. If the administrator is not granted,
No.
it is the
No.
first sanction has to be given to by the board, two-third majority. Then it has
So
to go
now
to
the board
government.
was, Waqf board has not granted anything?
No, if that is so, what I'm
Annex.
saying.
May, if your lordship permits,
Yes.
let us not, let there not be a confusion. Section 56, if your lordship permits, just read.
Odi.
Yes. It is very clear. It is only the state government.
Before that, let him read, my lord,
No, no,
32J.
you please.
I
See.
feel you, don't get touchy about his submission. Odi first.
Sorry, my lord. 56, restriction on power to grant lease of work property. A lease for any period exceeding 30 years of any immovable property which is work property shall notwithstanding anything contained in the deed or instrument of work or any other law for the time being in force be void and of no effect, provided that a lease for any period up to 30 years may be made for commercial activities, education or health purpose with the approval of the state government for such period and purposes as may be specified in the rules by the
Government has
central.
approved it here.
Yes,
Illa.
that's all.
With reference subject, I am directed to convey the approval of the government to lease out so and so, so and so.
My lord, before government approval, there has to be a sanction by the board. My lord, kindly see section 32.
Section 109 will not empower the state government to frame any rule contrary to section 56.
So you mean to say board is superior here?
Yes, my lord, definitely. This is
32
this is
M.
the scheme of the act. My lord, that is.
Why was the
Yeah,
administrator
administrator.
appointed?
That the administrator was appointed only for the purpose of looking into
No,
day-to-day
no.
affairs.
Correct.
This is, my lord, the power contemplated by the board, which cannot be exercised by the, my lord, the administrator is my.
No, administrator is not, with the approval of the government. Government has approved it. Now you mean to say when the board is not functioning, even the government is powerless to do anything?
First board, my lord, then government. That is the scheme.
Correct, sir, board ilwala.
My lord, if the, they have to wait till, my lord, what?
Oh, yeah.
My lord,
That is your submission.
My lord, my lord, the power of the board, my lord, cannot be taken away, my lord, because kindly see the composition of the board, my lord. There are 11 members, all elected members. They are all elected members. from
ಅವಾಗ
different-
ಇರ್ಲಿಲ್ವಲ್ಲ board, administrator was there.
Administrator cannot step, my lord, that
You
is
have not challenged that, see. Act of appointment of administrator is not challenged.
challenge, my lord.
Now, the only challenge is the administrator, after approval of the board, granting lease of, for 30 years of the property. ಅಷ್ಟೇ ಇರೋದು.
Board approve ಮಾಡಿಲ್ಲ.
Board ಅಲ್ಲ, government approve ಮಾಡ, board has not approved. The administrators issued it after the approval of the government.
No.
Right. What is this, sir?
My lord, may I point
With
out, sir?
reference to the subject, I am directed to convey approval of the government to lease out work property. What does that
My lord,
mean?
that is after sanction, my lord. That is after sanction. I'll point out. First,
What
let-
sanction?
my lord, kindly see rule 32. 32, one second. 32J.
No, I get it. Board sanction ಆದ್ಮೇಲೆ government ಹೋಗ್ಬೇಕು, government approve
Yes.
ಮಾಡ್ಬೇಕು is your submission. As on that day, board was not existing, so you mean to say till the board is constituted, no lease should be granted,
But
or this action is wrong?
This court has
ಅಷ್ಟೇ
held,
ತಾನೇ?
this court has held, the administrator cannot take such action. That I'll
ಅದೇ
point.
ಅದೇ ಕೇಳ್ತೀರ,
ಹಾ.
ಅದು ಕೊಡಿ ಸಾಕು. Where is that?
That,
Ja-
my lord, in my compilation,
Which judgment is that?
Yes.
That Justice ವೇಣುಗೋಪಾಲ್ ಗೌಡ್ರದ?
ಅದಾದ್ಮೇಲೆ,
ಅಲ್ಲಿವರೆಗೂ ಅದಾದ್ಮೇಲೆ ಹೋಗ್ಲೇ ಇಲ್ಲ ನೀವು.
this is only with regard to locus standi.
ಇದ್ಯಾವ್ದು my order?
My order, your lordship's order, my lord, that's why. And this was precisely, my lord, referred by the tribunal.
ನಂದಲ್.
The same administrator, my lord, and he, my lord, divides district of advisory committees into two region, which the court has said, my lord, the single judge has said that he steps into the shoes of the board, therefore he can do it. The division bench, my lord, reasoning. We find that this reason for the learned single judge is inappropriate. The administrator is appointed for the purpose of conducting the day-to-day affairs of the board. In fact, the language
What,
used in
that
the
is
order.
bifurcation of districts.
Yes, my lord. That power, my lord, is contemplated under section 18. Here also, my lord, that power to grant a lease was with the board.
We'll see.
Now, your lordship may kindly turn to page 6, my lord, the Supreme Court. The same question was arisen with regard to cooperative societies are concerned, my lord.
That
Here
I'm
also, my lord, the similar issue has been dealt with.
That is settled law where what an administrator can do.
Can do.
Day-to-day affairs ಇದ್ದಾಗ ಏನ್ ಮಾಡ್ಬೋದು.
Yes.
But here there is a little twist. Government has approved it.
No, the government.
And directly section 56 is the power vested with the government. All other things will not come in the
The
way.
government, my lord, only after sanction of the government.
That we will consider.
My lord, your lordship may, for that, my lord, I want certain provisions to be,
Provisions.
provisions of the act, my lord.
ಹಾ,
The,
ಇದೇ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
my lord, 32 J's, my lord, one, my lord, section 51
ನಿಮಿಷ 32
J, 51, 56, my lord. Rule 5 and 17 of the WAF Properties Lease Rules 2014.
Rule 5 and
17
lease rules.
Lease Rules.
ಅದು ಕೊಡಿ ಮೇಡಮ್.
And rules 63 and 64 of the WAF Rules 2017. Well, they have to publish.
ಪ್ರಾಪರ್ಟಿ ರೂಲ್ಸ್ ಯಾವ್ದು ಕೊಡಿ ಅದು.
2017. 2014, my lord, sorry.
ಇದು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇದೆ. Entry order is there.
On what basis?
That's the only issue. To section 56.
1 minute. Oh, it is the board under rule 5.
And 17. And they have to publish in national, my lord. It is not only regional. The tribunal has recorded the finding.
Long-term lease up to 30 years inside.
They have not published in only regional paper publication ಮಾಡಿದ್ದಾರೆ. They have not done it national. That is the finding even by the tribunal.
Deccan Herald national ಅಲ್ವಾ?
Deccan Herald, ಪ್ರಜಾವಾಣಿ, ಆಮೇಲೆ ಉರ್ದು ಸಾಲಾರ್, ಡೈಲಿ ಸಾಲಾರ್, 3 ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ನನ್ನ ಅಡಿಷನಲ್
ಸಾಲಾರ್.
And apart from this,
ಡೇಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿ ಬರ್ತಿದ್ದೀನಿ. ಅವರು ಕೊಟ್ಟಾರ.
The person who is appointed and as administrator is a principal secretary who is supposed to give, my lord, the sanction, approval, the government. The same person, the administrator.
Same person.
Same person. The administrator is the principal secretary of the department who acts as this.
We'll see. Yes.
Section 19 ನಲ್ಲಿ any
The
person.
tribunal goes only on administrator's powers.
Yes.
And there is also, my lord, says that there is a lapse under following the.
Yes.
And my humble submission is on, main submission is that they have no locus to challenge.
That we'll see.
Courts have taken a view that so far as a person who claims to be interested in the work does not just merely belong to the same community. Lordship sees the definition. He must really have a look at the explanation of a person interested.
Yes.
Receive any pecuniary or other benefits from the work. There is no allegation that he's either of the two petitioners, but in the entire petition. In fact, there is no averment at all that they are interested in the work. There is no averment. It is also not the petitioner. There is no averment whatsoever.
ನೀವು ಇವ್ರು ಹಾಕಿಲ್ವಾ?
Petition.
Copy of the petition filed before the tribunal.
ಅಲ್ಲ ಅದರಲ್ಲಿ
Absolutely no averment. So it should be not in a mosque or imambara or dargah connected with that religious institution, not any general mosque. Otherwise, we would have simply said any person of the community can be a person interested. That's not the, in fact, not, that's why your office is now, one judgment of the High Court of Telangana point out. Just consider this aspect.
If section 3K is dealt in this case, if my humble submission, many cases will now will be reduced before tribunal, because what is happening before tribunal, we have been seeing many cases are coming up on the strength of section 3K. Now, section 3K, in my written submission, I have brought.
Interested person.
Interested ಬಗ್ಗೆ, ನಾನು
Senior counsel.
92 not of CPC. 92 CPC also says not a person interested in a trust. Not the Supreme Court has said, merely not if it is a public charitable trust and you claim to be belonging to the community, that is not sufficient. You must show special interest in this particular institution. Not you may have been associated in some way with the working of the institution, or you may have donated, contributed, worked with that institution in any manner. Then not that may be sufficient. But absolutely no argument here that these persons are in any way connected with this institution. Not just takes this judgment not Jack pointed out. In fact, it says,
Paragraph.
not kindly not para 9 not Lordship sees, dealing with section 83 itself. This question was raised. Then the Lordship kindly have a look at paragraph 13 not at page 7. Respondent 1 and 2 plaintiffs are not mutawali of the work, but they are claiming that they are persons interested. The person interested, they are claiming that they are persons interested. The person interested in work is defined under section 3K of the Work Act. The person interested in the work means any person who is entitled to receive so and so. Then your Lordship kindly tells paragraph 14. Admittedly, so and so is purely an education institution, and the question of worship and performing in religious rite does not arise because the only way of mosque as mentioned in section so and so of the Work Act. Therefore, response so and so, they are not persons interested in the work. Though they were students for some time, even that not the court says is not sufficient. Even if they were students for some time. Even otherwise, plaintiffs are not entitled to receive any benefit from the work. So in such a case, would not fall in the definition of person who is the work. So therefore, not they say they are also not mutavalis, etc. And therefore, the question of not then section not
3K. 92 CPC.
92 CPC. Because the words used are same. Person interested.
Madam, could you?
But here it was a case of a Gurudwara in para 4, you should find, which was not offering food to all the visitors in the village. And the villagers claimed they were interested because it was they had contributed and it was situated in the village and offering service. Para 4, you should find that factual situation. Then you should kindly turn to page
Yes.
para 6 over the page.
Yes.
Second line on top. Second ground of claim was that the plaintiff responded to a resident of village Dandawala. But again, there is no pleading and no evidence claimed to show that the residents of village Dandawala in general had any such interest in this trust, which could entitle them to issue such a suit. The only allegation of the Langar used to be running this institution. Their free kitchen was provided to visitors. Because nowhere said that any such free kitchen was being run.
We'll see. Yes.
But then it approves the Privy Council judgment which says that they must be interested in that particular institution. Not generally as.
Well, all these require an answer. Administrative powers also. Yes, sir.
This is part of the day. I would humbly submit not even with respect to judgment.
30 ವರ್ಷ ಕೊಡೋದು day-to-day affairs.
But I would humbly submit the Lordship sees section 32 which is referred to is part of the regular function of the board. Humbly submit the Lordship sees section 32 which is referred to is part of the regular function of the board. Not all that the Mutawali would be the one who makes the proposal. Then not the administrator is sanctioning, but it is subject to approval. Therefore, it is part of his regular function. There could be several institutions which keep coming with proposals for leases. So that is part. The judgment which your Lordship had rendered was in a situation where he had bifurcated the.
No, that division bench.
Yes, therefore, this would be part of the regular. Kindly see section 32. Section 32 is part of general function.
Same administrator. Huh?
Same administrator.
Section.
And one more, my lord, in regular sense, my lord, the meeting how takes place, my lord, the majority will prevail, my lord, the decision in the board. But in regard to leasing of the property, the 2/3 majority is specifically pointed out because this has more emphasis, more
Board
But therefore, as part of one of that is approval not for a lease, sanctioning of a lease for 30 years. Therefore, it's part of the regular day-to-day administration is what I would humbly submit.
Yes.
Once those is subject to approval not by the government.
We'll look into
there is a further check not by virtue of the requirement of a sanction for the government.
Synopsis ಹಾಕಿದಿರಲ್ಲ.
ಹಾಕಿದೀನಿ. Section 109 just one point ಹೇಳ್ತೀನಿ.
ಆಯ್ತು ಹೇಳಿ.
Section 109 power to make rules by the state government. ಇದರಲ್ಲಿ the state government may by notification in the official gazette make rules to carry out the purposes of this act other than those of chapter 3 in subsection 2 in particular and without prejudice to the generality of the foregoing powers, and such rules may be provided for all or any of the following matters. Now the prescribed provisions for introduction of the rules vested with the government. Section 56 ಮೇಲೆ rule frame ಮಾಡ್ಲಿಕ್ಕೆ ಅಲ್ಲಿ scope ಇಲ್ಲ. Any rule introduced by the state government is in violation of section 109.
Challenge in the, all of you are going beyond the challenge. Wait, yes.
I make one
Will
submission.
answer what is.
Respondent number one. My lord, the petitioners have no locus standi to challenge this petition.
Petitioners have no locus
Now
standi.
they are in the no mutavalis.
Which
Now the
petitioners?
administration was appointed in
Yura
the
avra.
petitioners, present petitioners. Now the administration was appointed. The present petitioners have no, they are not the
Who
mutavalis.
are these petitioners?
They are the mutavalis. They are saying that mutavalis in 2021 itself.
They are not respondents there?
Yes. They are respondents.
All right. Yes, next. ನೀವು ಯಾರು?
I am for the respondent number. I am the interested party.
Oh, you are also interested.
Two applicants.
Oh, two interested parties, yes.
The first response.
Was this because there was a procedure. There were almost 6-7 developers submitted bids pursuant to all the paper publications. It went through a whole process of checks, went to the administrator, then went to the government. Now, my lord, suddenly somebody is being filing. We're not sure, my lord, what.
We'll see, yes, yes. But reserved, yes. Intermodal subsisting, ಇದೆಯಲ್ಲ?
ಇದೆ.
Subsisting would continue till the disposal of the petition. Group entry models ಯಾವ್ದಿದೆ, they'll come after 2 weeks. Entry models ಇಲ್ದೇ ಇರೋದು?
My lord, serial number 70, my lord. Change of land use covered by judgment, my lord.
But we'll
Top
see.
of the
ಎಲ್ಲ
list, my lord.
top of the list.
ಹೌದು,
No, sir.
preliminary hearing ಗೆ ಬಂದ್ರೆ
Number one.
covered by judgment, my lord. 2021, only seeking for mandamus to consider my
Madam,
70 serial number.
List number 2, serial number 28.
One minute. Wherever there is a prayer only for mandamus, only to consider a particular thing, representation or whatever it is, all those, I'll make it a separate list and post it on Tuesday, 9th or 16th. Separate list. ಬೇರೆ ಯಾವ್ದಾರು prayer ಇದ್ರೆ ಅದು ಯಾವ್ದು grant ಮಾಡಲ್ಲ.
ಇದೆ, ಆದ್ರೆ I will
ಇದೆಯಾ?
stick for, stick for mandamus only, my lord. Only for mandamus.
Serial
number 39.
Serial number.
ಅದು that will do. ಈಗ no other ಎಲ್ಲ common dates.
Serial number 28, B group post ಆಗಿದೆ, CRP matter.
Interim order ಇರೋದೆಲ್ಲ 2 weeks. Interim order ಇಲ್ಲದೆ ಇರೋದು dates.
Serial number 39.
Serial number 28.
Pay for vacating stay. ಯಾವ GMCPC?
Party.
Vacating stay ಇದೆ ಇಲ್ಲಿ. Madam, vacating stay applications 9th ಮೇಲ್ಗಡೆನೆ ಹಾಕಿ.
Serial number
Wherever
20.
vacating stay applications are there, the 9th immediately after preliminary hearing ಹಾಕಿ.
Serial number
30.
I will not press for, I will
Serial
not
number
press for
7.
certiorari, only
Asking to pay the additional amount after having paid the entire title value.
ಅದು interim order ಇದೆಯಾ?
Interim order illa sir. Your lordship had previously said it will be considered on today.
Serial number?
72. List 1.
B group ಯಾಕೆ ಹೋಯ್ತದು? K Krishna, ವಕಾಲತ್ not filed.
Day after tomorrow.
Tuesday ಹಾಕಿ ಮಾಡಿ. 9th.
My lord, serial number 64.
Serial number 64, my lords.
Triple one, my lords. Petition of the year 2000, my lords.
1 minute. ಎಲ್ಲಿ B group start ಮಾಡಿ ಮೇಡಮ್, 1 ನಿಮಿಷ. ಈ ತರ ಆದ್ರೆ shall I call it page wise if you permit me? Yes.
At this page 10, 37, 39,
37 to 39 ಯಾವ ವರ್ಷದ ಮೇಡಮ್ ಅದು?
14, 13.
37 to 16, 1 ನಿಮಿಷ. 37 to 40, 37 to 50.
42.
1 minute. Sorry sir, 1 ನಿಮಿಷ. 37 to 50. List them on 9th, Tuesday. 40, 51 to ಎಲ್ಲ ಬೇರೆ 23, 24, 25. 51 to 1 ನಿಮಿಷ. 51 to 80. ಯಾವ್ದಾರು ಇರ್ಲಿ 51 to 80 list them on 16th.
My lord, serial
Entry
number
notice ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
70, my lord, or top of the list, kindly, my lord.
Yes.
My lord,
ಅದು ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ತಾಳಿ.
ಆಗ್ಬೋದು.
81 to 87.
83 and 86 are nice matters, only preliminary notification. Connected matters are listed on 15th.
15th ಹೆಂಗ್ ಸರ್ 16th ಇರ್ಬೇಕು. 16 87 ವರೆಗೂ 16th ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
Serial number 109 also nice matters. Serial number 109 also the nice matters only.
And 89, my lord.
What are these interlock? ಆಮೇಲೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಎಲ್ಲೆಲ್ಲಿದೆ ಅದನ್ನ ವಿಲ್ ಪೋಸ್ಟ್ ದೆಮ್ ಅಟ್ ದಿ ಟಾಪ್.
My lord, 64.
ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ನೀವು.
My lord, serial number 64.
ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್. ಒಂದು ನಿಮಿಷ. What are these interlocutory applications? ಇಷ್ಟೊಂದಿದೆ ಮೇಡಮ್. IA dispensation. Dispensation. Finally, what is this 2000 the matter?
Acquisition, challenging the acquisition for Panshankari fifth stage, my lords. A coordinate bench of this honorable court has held that it seemed to be lapsed. But that's the only question. It's a petition. It's gone to the Supreme Court. It's been remanded, my lords, in 2000.
Then it is covered by that?
It's covered by that judgment, my lords.
Padma?
MC Padma.
All right. ಆಯ್ತು, ವಿಲ್ ಸಿ. ಅದು 9th ಹಾಕಿರಿ ಮೇಡಮ್. You make a mention at 2:30. 25 years old case. We'll close it.
110 is also a nice matter. 89 is also a nice matter. 110.
89, 109 and 110, my lords. All these matters are covered by matters, my lords.
Justice Devdas or order.
Please.
89 also. That's it. Instead all these matters.
ಯಾವತ್ತಿದೆ 16th?
16.
89
109 and 110.
89 109 110 ಎಲ್ಲ 16th ಬರೋದು ಅದು.
Please.
Yes.
110 also.
16th.
My lord, serial number 102, my lord. My lord, serial number 102.
That is disposed. 60. We'll see. 64 list on 9th in preliminary hearing.
My lord, serial number 102.
1 minute, madam. Yes.
Number 2, my lord, 29 serial.
ನೀವು ಇರ್ಲಿಲ್ವಾ?
ಕರೆದಿಲ್ಲ 28 also.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಯಾರು ನೀವು ಹಾಕಿದ್ದೀರಾ? ಅಡ್ವೊಕೇಟ್ ಇದಾರಲ್ಲ, ಇದ್ದಾಗ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಬಾರ್ದು.
So serial number 28 madam. 28
there is no interim order.
28 madam.
ಬರಲ್ಲ.
CRP
I have already divided the dates. Nothing.
CRP matter admission post
Matter is for speedy disposal, my lord. That's the only concern.
28
How is
admission
speedy
post
disposal?
28 ಅದೇ CRP connect ಆಗಿದೆ. ಅದು ಅಡ್ಮಿಟ್
From
ಆಗಿದೆ.
last for date of hearing, it has been not reached, my lord. That's the
start for
only.
entry matter my lord. This matter admission ಗೆ year ಆಗಬೇಕಾಗಿದೆ.
ಅವರು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಂತಾರೆ, ನೀವು ಎಂಟ್ರಿ ಮಾಡಕ್ಕೆ
Connected matters.
Two connected matter.
Subsequent was CRP, my lord.
ಬರ್ಲಿ.
My lord, serial number 102.
Admission post ಆಗಬೇಕು.
07. My lord, in
16.
serial number 107, your lordship was pleased to allow the IA, my lord.
What
And-
IA?
And there was a direction, my lord, to post
What
it
IA?
my lord, for dispensation, my lord.
ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಎಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಗಿದೆ ಮೇಡಮ್.
ಅವತ್ತೇ ಆಗಿತ್ತದು.
ಅಲ್ಲ ಮೇಡಮ್, ಆಲ್ ಔಟ್ ಮಾಡಬೇಡಿ ಅಷ್ಟೇ.
Serial number 82.
Can I request for an earlier date, my lord? Because they,
No, if the dispensation application allow ಆಗಿದ್ರೆ it will come on.
well, it was allowed on the last occasion, but it's not showing, my lord.
Let's
in the
see.
order.
Serial number 82, ma'am.
Kind leave, my lord, serial number 102. I filed an impleading application
You
on the
will not be
auction
in
purchase
station.
the shortest date, my lord.
ಲಿಸ್ಟ್ ಆನ್ ಲಿಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಬರಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿರೋ ಡೇಟ್ ಇಲ್ಲ. ಇಂಟರಿ ಮಾಡಿರೋ ಡೇಟ್ ಕೊಡಬೇಕು ಎಲ್ಲ 2 weeks.
Serial number 77, my lord.
Yes, what's on the VC?
My lord, serial number 102, my lord. I am the auction purchaser. I filed an impleading application. They have to go to DRT, my lord, a shortest date. It's an application for, it's a writ petition for cancellation of kata by the borrower. The sale certificate is already in my favor, my lord. They have to approach DRT. I'm praying for a shortest date possible, my lord.
9th, madam. Yes.
Great.
Serial number
67 and 71, my lord.
Serial number 2, serial
Yes, yes.
68 to serial number
67 and 71 only mandamus.
Madam, hand delivery.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 93 ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆ. ಲೋಕ್ರೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ. Serial number 93 ನೋಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಂತ ಹೇಳಿದೆ ರೀಚ್ ಆಗಿಲ್ಲ. Court officer.